The House will come to order. The Pledge of Allegiance will be led by Representative Garcia Sander.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Mr. Shebel, please call the roll.
Representatives Armagost, Bacon, Barone, Byrd, Representative Byrd,
Excused.
Basenecker, Bottoms, Bradfield, Bradley, Brooks, Brown, Representative Brown,
Excused.
Caldwell, Camacho, Carter, Clifford, DeGraff, Duran, English, Representative English,
Excused.
Espinoza, Foray, Froelich, Garcia, Garcia Sander, Gilchrist, Gonzalez, Hamrick, Hartsook, Jackson, Johnson, Joseph, Kelty, Leader, Lindsay.
Here.
Representative Lindstedt is excused. Luck, Lukens, Mabry, Marshall, Martinez, Morrow, McCormick, Pascal, Phillips, Puglisi, Richardson, Ricks, Representative Ricks,
Excused.
Rootenell, Ryden, Sirota, Smith, Soper, Representative Soper,
Excused.
Stewart K, Stewart R, Story, Sukla, Taggart, Titone, Valdez A, Representative Valdez,
Excused.
Velasco, Weinberg, Wilford,
Here.
Winter, Representative Woodrow is excused. Woog, Zokai, and Madam Speaker.
Yes, I do. With 60 present, 5 excused, we do have a quorum. Representative Garcia Sander.
Thank you, Madam Chair. Happy Wednesday.
Happy Wednesday.
Congratulations. Today is your day. You're off to great places. You're off and away. You have brains in your head. You have feet in your shoes. You can steer yourself any direction you choose. You're on your own, and you know what you know, and you are the couple who decide where to go. You'll look up and down the streets, look them over with care. About some you will say, we don't choose to go there. With your heads full of brains and your shoes full of feet, you're too smart to go down any not so good street. And you may not find any you'll want to go down. In that case, of course, you'll head straight out of town. It's opener there in the wide open air. Out there, things can happen and frequently do to people as brainy and footsy as you. And when things start to happen, don't worry, don't stew. Just go right along. You'll start happening too. Oh, the places you'll go. It is Read Across America Week. Happy Wednesday. Madam Speaker, I move that the Journal of Tuesday, March 4th, 2025 be approved as corrected by the Chief Clerk.
Thank you. Members, you have heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye. All those opposed, no. The ayes have it. The motion is adopted. Members, we are proceeding to third readings. I'll invite you to take your seats. Members, please take your seats. We are proceeding to third readings. Mr. Schiebel, please read the title to House Bill 1116.
House Bill 1116 by Representatives Armagost and Bacon, also Senator Pelton R., concerning requiring the Department of Corrections to search for information related to an offender's court appearances.
Madam Majority Leader.
Madam Speaker, I move House Bill 1116 on third reading and final passage.
The motion before us is the adoption of House Bill 1116 on third reading and final passage. Mr. Schiebel, please open the machine and members proceed to vote. Members, please take your seats. Thank you. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Wilford, how do you vote?
Yes.
Representative Wilford votes yes. Joseph and Ryden. Ryden is excused with a $6 fine. Please close the machine. With 59 ayes, 0 noes, 6 excused, House Bill 1116 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1014.
House Bill 1014 by Representatives Johnson and Lukens, also Senators Roberts and Simpson, concerning measures to increase efficiency in division of water resources processes.
Madam Majority Leader.
Madam Speaker, I move House Bill 1014 on third reading and final passage.
The motion before us is the adoption of House Bill 1014 on third reading and final passage. Mr. Schiebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Wilford, how do you vote?
Yes.
Representative Wilford votes yes. Please close the machine. With 61 ayes, 0 no, 4 excused, House Bill 1014 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Representative Wilford, co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1011.
House Bill 1011 by Representatives Garcia and Sirota, also Senators Kipp and Judah, concerning requirements for child care centers owned by an institutional investment entity.
Madam Majority Leader.
Madam Speaker, I move House Bill 1011 on third reading and final passage.
Seeing no further discussion, the motion before us is the adoption of House Bill 1011 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Wilford, how do you vote?
Yes.
Representative Wilford votes yes. Please close the machine. With 38 aye, 23 no, and 4 excused, House Bill 1011 is adopted. Co-sponsors. Representatives Lindsay and Wilford, co-sponsor. Please close the machine. Mr. Shebel, please read the title to House Bill 1200.
House Bill 1200 by Representatives Foray and Armagost, also Senator Cutter, concerning modifications to the Office of the Child Protection Ombudsman.
Madam Majority Leader.
Madam Speaker, I move House Bill 1200 on third reading and final passage.
Representative Armagost.
Thank you, Madam Speaker. I just didn't get a chance to yesterday. I wanted to say today my co-prime did all the heavy lifting on this. I jumped on last minute to support kids and make this bipartisan. So thanks goes to her. Vote yes. Let's keep taking care of kids.
Seeing no further discussion, the motion before us is the adoption of House Bill 1200 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Wilford, how do you vote?
Yes.
Representative Wilford votes yes. Rep. Carter. Please close the machine. With 55 ayes, 6 no, 4 excused, House Bill 1200 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1168.
House Bill 1168 by Representatives Lindsay and Espinoza, also Senator Weissman, concerning housing protections for victim survivors of gender-based violence.
Madam Majority Leader.
Madam Speaker, I move House Bill 1168 on third reading and final passage.
The motion before us is the adoption of House Bill 1168 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Wilford, how do you vote?
Yes.
Representative Wilford votes yes. Garcia. Please close the machine. With 40 aye, 22 no, and 3 excused, House Bill 1168 is adopted. Co-sponsors. Representative Wilford, co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1148.
House Bill 1148 by Representatives Bacon and Carter, also Senators Gonzalez and Weissman, concerning protection orders.
Madam Majority Leader.
Madam Speaker, I move House Bill 1148 on third reading and final passage.
Seeing no further discussion, the motion before us is the adoption of House Bill 1148 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Wilford, how do you vote?
Yes.
Representative Wilford votes yes. Please close the machine. With 39 aye, 23 no, and 3 excused, House Bill 1148 is adopted. Co-sponsors. Representative Lindsay, co-sponsors. Representative Wilford, co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1179.
House Bill 1179 by Representatives Okai and Foray, also Senators Doherty and Judah, concerning automobile insurance coverage for the replacement of a child restraint system.
Madam Majority Leader.
Madam Speaker, I move House Bill 1179 on third reading and final passage.
The motion before us is the adoption of House Bill 1179 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Wilford, how do you vote?
Yes.
Representative Wilford votes yes. Please close the machine. With 40 aye, 22 no, and 3 excused, House Bill 1179 is adopted. Co-sponsors. Representatives Lindsay and Wilford, co-sponsor. Please close the machine. Madam Majority Leader.
Thank you, Madam Speaker. I move the following bills be made special orders on Wednesday, March 5th, 2025 at 9:24 a.m. House Bill 1201, House Bill 1169, House Bill 1147, Senate Bill 28, and House Bill 1203.
If there's no objection, the bills listed by the Majority Leader will be made special orders today, Wednesday, March 5th at 9:24 a.m. Representative Joseph. Members, you have heard the motion. Seeing no objection, Representative Joseph will take the chair.
Practice. The committee will come to order. With unanimous consent, the bills will be read by title unless there is a request for reading of bills at length. Committee reports are printed in your bill folders. Floor amendments will be shown on the screen or on iLegislate and in today's folder on your box account. Bills will be laid over upon motion of the majority leader and the court rule is relaxed. Representative Marshall.
Thank you, Madam Speaker. It's an
Please, wait a minute. Mr. Shebo, please read the title to House Bill 25-1201.
House Bill 1201 by Representative Marshall, also Senator Henriksen, concerning implementing a model act to modernize money transmission.
Thank you, Mr. Shebo. Rep. Marshall.
Thank you, Madam Speaker. It's an honor to serve with you.
It is an honor to serve with you. Thank you for the upgrade.
I move the Finance Committee report to House Bill 1201.
To the committee report.
Members, at the committee,
Mr.
we added 3 amendments to this
Marshall,
bill.
Please move the bill.
With it. So I move House Bill 1201 with the Finance Committee report.
To the committee report.
In the committee, we added 3 amendments, members. One, to exempt banks and trust companies that are already chartered by other states or the federal government. We also exempted payroll providers that are acting solely as agents and exempted them out. And we had a 3rd amendment to marry up our timelines to reflect the same as the other states have. This is like a Uniform Law Commission bill, and I ask for a yes vote.
Is there any further discussion to the committee report? Seeing none. Oh, Rep. Bradley.
Thank you, Madam Chair. I like this bill read at length.
So you just say the bill will be read at length. The bill will be read at length.
House Committees, Senate Committees, Finance. A bill for an act. 101 concerning implementing a model act to modernize money. 102 transmission. Bill summary. Note, this summary applies to this bill as introduced and does not reflect any amendments that may be subsequently adopted. If this bill passes 3rd reading in the House of Introduction, a bill summary that applies to the re-engrossed version of this bill will be available at http://leg.colorado.gov. The bill repeals the current Money Transmitters Act and replaces it with the Money Transmission Modernization Act. The new act enacts, in part, a model law developed in conjunction with the money transmitter industry. The act reduces regulatory burden by modernizing outdated and inconsistent regulatory requirements, including House sponsorship Marshall. Senate sponsorship Hinrichsen. Shading denotes House amendment. Double underlining denotes Senate amendment. Capital letters or bold and italic numbers indicate new material to be added to existing law. Dashes through the words or numbers indicate deletions from existing law. Clarifying the definition of control of a licensee and introducing a rebuttable presumption of control. Enabling Colorado's participation in multi-state licensing initiatives. Codifying the agent-to-payee exemption to licensure. Revising prudential standards required for licensing and ongoing monitoring, such as tangible net worth and permissible investment calculations. Establishing an irrevocable, standby letter of credit as a permissible investment, and expanding the enforcement actions available in case of non-performance by a money transmitter. 1. Be it enacted by the General Assembly of the State of Colorado, 2 Section 1. In Colorado Revised Statutes, repeal and reenact, 3 with amendments, Article 110 of Title 11 as follows, for Article 110-5 Money Transmitters 6 Part 1-7 Short Title and Legislative Declaration 811-110-101. Short Title. The short title of this Article 110 is 9 The Money Transmission Modernization Act. 1011-110-102. Legislative Declaration. 1. The General 11 Assembly finds and declares that the purpose of this Article 110-12 ISTO 13a ensure states can coordinate in all areas of 14 regulation, licensing, and supervision to eliminate unnecessary 15 regulatory burden and more effectively utilize regulator 16 resources, 17 b protect the public from financial crime, 18 c standardize the types of activities that are subject to 19 licensing or otherwise exempt from licensing, and -2 HB 25-1201. 1d. Modernize safety and soundness requirements 2 to ensure customer money is protected in an environment that 3 supports innovative and competitive business practices. For Part 2.5 Definitions 611-110-201. Definitions, Rules. As used in this Article 110, 7 unless the context otherwise requires. 8. 1. Acting in concert means persons knowingly acting 9 together with a common goal of jointly acquiring control of a 10 licensee, whether or not pursuant to an express agreement. 11. 2. Authorized delegate means a person a licensee 12 designates to engage in money transmission on behalf of the 13 licensee. 14. 3. Average daily money transmission liability means 15 the amount of a licensee's outstanding money transmission 16 obligations in this state at the end of each day in a given period 17 of time, added together and divided by the total number of days 18 in the given period of time. For purposes of calculating average. 19. Daily money transmission liability under this Article 110 for any 20 licensee required to do so. The given period of time is the 21 quarters ending March 31, June 30th, September 30th, and December 22nd, 31. 23. 4. Banking Board or Board means the Banking Board 24 created in Section 11-102-103. 25. 5. Bank Secrecy Act means the Federal Bank Secrecy 26 Act, 31 U.S.C. SEC 5311 SEC, as amended, and its implementing 27 regulations. 3. HB 25-1201. 1. 6. Closed loop stored value means stored value that 2 is redeemable by an issuer only for goods or services provided 3 by the issuer or its affiliate or franchisees of the issuer or its 4 affiliate, except to the extent required by applicable law to be 5 redeemable in cash for its cash value. 6. 7. Commissioner means the State Bank Commissioner 7 appointed and serving pursuant to Section 11-102-101, 2. 8. 8a. Control means the power to 9. I. Vote, directly or indirectly, at least 25-10% of the outstanding voting shares or voting interests of 11a licensee or person in control of a licensee. 12. 2. Elect or appoint a majority of key individuals or 13 executive officers, managers, directors, trustees, or other 14 individuals exercising managerial authority of a person. 15. Control of a licensee, or 16. 3. Exercise, directly or indirectly, a controlling. 17. Influence over the management or policies of a licensee or 18. Person in control of a licensee. 19. B. Rebuttable presumption of control. I. A person is 20 presumed to exercise a controlling influence when the person 21 holds the power to vote, directly or indirectly, at least 10-22% of the outstanding voting shares or voting interests of 23. A licensee or person in control of a licensee. 24. 2. A person presumed to exercise a controlling influence. 25. As described in this subsection. 8. May rebut the presumption of 26 control if the person is a passive investor. 27. C. For purposes of determining the percentage of a person. 4. HB 25-1201. 1. Controlled by any other person, the person's interest shall be 2. Aggregated with the interest of any other immediate family 3 member, including the person's spouse, parents, children, 4 siblings, mothers, and fathers-in-law, sons, and 5 daughters-in-law, and brothers, and sisters-in-law, and any 6 other person who shares such person's home. 7. 9. Division means the division of banking created in 8 Section 11-102-101. 9. 10. Eligible rating means a credit rating of any of the 10 highest rating categories provided by an eligible rating 11 service, whereby each category may include rating category 12 modifiers such as plus or minus. For S&P Global Ratings or 13 the equivalent for any other eligible rating service. Long-term 14 credit ratings are deemed eligible if the rating is equal to A-15 or higher by S&P Global Ratings or the equivalent from any 16 other eligible rating service. Short-term credit ratings are 17 deemed eligible if the rating is equal to or higher than A2 or 18 SP2 by S&P Global Ratings or the equivalent from any other 19 eligible rating service. In the event that ratings differ among 20 eligible rating services, the highest rating applies when 21 determining whether a security bears an eligible rating. 22. 11. Eligible rating service means any nationally 23 recognized statistical rating organization, or NRSRO, as 24 defined by the United States Securities and Exchange 25 Commission, and any other organization designated by the 26 Banking Board by rule or order. 27. 12. Federally insured depository financial institution. 5. HB 25-1201. 1 means a bank, credit union, savings and loan association, trust 2 company, savings association, savings bank, industrial bank, or 3 industrial loan company organized under the laws of the United 4 states or any state of the United States, when such bank, credit 5 union, savings and loan association, trust company, savings 6 association, savings bank, industrial bank, or industrial loan 7 company has federally insured deposits. 8. 13. Individual means a natural person. 9. 14. A. In this state means at a physical location within 10 this state for a transaction requested in person. 11. B. For a transaction requested electronically or by 12 phone, the provider of money transmission shall determine if the 13 person requesting the transaction is, in this state, by relying on 14 other information provided by the person regarding the 15 location of the individual's residential address or a business 16 entity's principal place of business or other physical address. 17. Location, and any records associated with the person that the 18 provider of money transmission may have that indicate such 19 location, including but not limited to an address associated 20 with an account. 21.15. Key individual means any individual. Ultimately 22 responsible for establishing or directing policies and procedures. 23 of a licensee, such as an executive officer, manager, director, or 24 trustee. 25.16. Licensee means a person licensed under this article 26.110. 27.17. Material litigation means litigation that. -6, HB 25-1201. 1. According to United States generally accepted accounting 2 principles, is significant to a person's financial health and would 3 be required to be disclosed in the person's annual audited 4 financial statements or report to shareholders or similar 5 records. 6.18. Monetary value means a medium of exchange. 7. Whether or not redeemable in money. 8.19. A. Money means a medium of exchange that is 9 authorized or adopted by the United States or a foreign 10 government. 11. B. Money includes a monetary unit of account. 12. Established by an intergovernmental organization or by 13 agreement between 2 or more governments. 14.20. A. Money transmission means any of the following. 15. Selling or issuing payment instruments to a person. 16. Located in this state. 17. 2. Selling or issuing stored value to a person located in 18. this state, or 19. 3. Receiving money for transmission from a person. 20. Located in this state. 21. B. Money transmission includes payroll processing. 22. Services. 23. C. Money transmission does not include the sole 24 provision of online or telecommunication services or network. 25. Access. 26. 21. MSB accredited state means a state agency that is 27 accredited by the Conference of State Bank Supervisors and the -7, HB 25-1201. 1. Money Transmitter Regulators Association for Money 2. Transmission licensing and supervision. 3. 22. Multi-state licensing process means any agreement for entered into by and among state regulators relating to 5. Coordinated processing of applications for money transmission. 6. Licenses, applications for the acquisition of control of a 7. Licensee, control determinations, or notice and information. 8. Requirements for a change of key individuals. 9. 23. NMLS means the nationwide multi-state licensing 10 system and registry developed by the Conference of State Bank 11 Supervisors and the American Association of Residential 12 Mortgage Regulators and owned and operated by the State 13 Regulatory Registry, LLC, or any successor or affiliated 14 entity, for the licensing and registration of persons in financial 15 services industries. 16. 24. A. Outstanding money transmission obligation. 17. Means, AS established and extinguished in accordance with 18 applicable state law. 19. I. Any payment instrument or stored value issued or sold. 20. By a licensee to a person located in the United States or 21. Reported as sold by an authorized delegate of the licensee to a 22. Person that is located in the United States that has not yet been 23. Paid or refunded by or for the licensee or as cheat in 24. Accordance with applicable abandoned property laws, or 25. 2. Any money received for transmission by a licensee or 26. An authorized delegate of the licensee in the United States from 27. A person located in the United States that has not been received. -8, HB 25-1201. 1. By the payee or refunded to the sender or as cheat in 2. Accordance with applicable abandoned property laws. 3. B. As used in this subsection, 24, in the United States, for means, to the extent applicable, a person in any state, territory, 5. Or possession of the United States, the District of Columbia, the 6th Commonwealth of Puerto Rico, or a United States military 7. Installation that is located in a foreign country. 8. 25. Passive investor means a person that, 9. Does not have the power to elect a majority of key 10 individuals or executive officers, managers, directors, trustees, 11 or other persons exercising managerial authority of a person. 12. Control of a licensee. 13. B. Is not employed by and does not have any managerial. 14. Duties of the licensee or person in control of a licensee. 15. C. Does not have the power to exercise, directly or 16. Indirectly, a controlling influence over the management or 17. Policies of a licensee or person in control of a licensee, and 18. D. Either. 19. I. Attests to subsections 25. A. 2. 25. C. Of this section 20 in a form and in a medium prescribed by the Banking Board by 21 Rule, or 22. 2. Commits to the passivity characteristics of 23 subsections 25. A. 2. 25. C. Of this section in a written 24 document. 25. 26. A. Payment instrument means a written or 26 electronic check, draft, money order, traveler's check, or other 27 written or electronic instrument for the transmission or -9, HB 25-1201. 1. Payment of money or monetary value, whether or not too negotiable. 3. B. Payment instrument does not include stored value for or any instrument that, 5. Is redeemable by the issuer only for goods or services. 6. Provided by the issuer or ITS affiliate or franchisees of the issuer. 7. Or their affiliates, except to the extent required by applicable 8 law to be redeemable in cash for ITS cash value, or 9. 2. Is not sold to the public but issued and distributed as 10 part of a loyalty, rewards, or promotional program. 11. 27. A. Payroll processing services means receiving 12 money for transmission pursuant to a contract with a person. 13. Deliver wages or salaries, make payment of payroll taxes to 14 state and federal agencies, make payments relating to employee 15 benefit plans, or make distributions of other authorized 16 deductions from wages or salaries. 17b. Payroll processing services does not include an 18. Employer performing payroll processing services on its own. 19. Behalf or on behalf of its affiliate or a professional employer. 20. Organization subject to regulation under other applicable state 21 law. 22, 28. Person means any individual, general partnership. 23. Limited partnership, limited liability company, corporation. 24. Trust, association, joint stock corporation, or other corporate. 25. Entity identified by the banking board. 26, 29. Receiving money for transmission or money. 27. Received for transmission means receiving money or monetary. 10, HB 25-1201. 1. Value in the United States for transmission within or outside the 2 United States by electronic or other means. 3, 30, A. Stored value means a monetary value that represents a claim against the issuer evidenced by an electronic 5 or digital record and that is intended and accepted for use as a 6 means of redemption for money or monetary value or payment. 7 For goods or services. Stored value includes but is not limited to prepaid access as defined by 31 CFR 1010.100. 9b. Notwithstanding subsection 30a of this section. 10. Stored value does not include a payment instrument or closed. 11. Loop stored value or stored value not sold to the public but 12. Issued and distributed as part of a loyalty, rewards, or 13. Promotional program. 14, 31. Tangible net worth means the aggregate assets of 15. A licensee excluding all intangible assets, less liabilities, as 16. Determined in accordance with United States generally 17. Accepted accounting principles. 18. Part 3. 19. Exemptions 2011-110-301. Exemptions. 1. This Article 110 does not apply 21-2, 22a, an operator of a payment system to the extent that IT 23 provides processing, clearing, or settlement services, between 24 or among persons exempted by this section or licensees, IN 25 connection with wire transfers, credit card transactions, debit 26 card transactions, stored value transactions, automated 27 clearinghouse transfers, or similar money transfers. 11, HB 25-1201. 1b. A person appointed as an agent of a payee to collect to and process a payment from a payer to the payee for goods or 3 services, other than money transmission itself, provided to the payer by the payee, so long as 5i. There exists a written agreement between the payee 6 and the agent directing the agent to collect and process 7 payments from payers on the payee's behalf. 8. 2. The payee holds the agent out to the public as 9. Accepting payments for goods or services on the payee's behalf. 10 and 11. 3. Payment for the goods and services is treated as 12 received by the payee upon receipt by the agent so that the 13 payer's obligation is extinguished and there is no risk of loss. 2. 14. The payer if the agent fails to remit the money to the payee. 15. C. A person that acts as an intermediary by processing 16 payments between an entity that has directly incurred and 17 outstanding money transmission obligation to a sender and the 18 sender's designated recipient if the entity 19. I. is properly licensed or exempt from licensing. 20. Requirements under this Article 110, 21, 2, provides a receipt, electronic record, or other 22 written confirmation to the sender identifying the entity as the 23 provider of money transmission in the transaction, and 24, 3, bears sole responsibility to satisfy the outstanding 25 money transmission obligation to the sender, including the 26 obligation to make the sender whole in connection with any 27 failure to transmit the money to the sender's designated. 12, HB 25-1201. 1. Recipient. 2. D. The United States or a department, agency, or 3. Instrumentality of the United States or ITS agent. 4. E. Money transmission by the United States Postal 5 Service or by an agent of the United States Postal Service. 6. F. A state, county, or city or any other governmental 7. Agency or governmental subdivision or instrumentality of a 8. State or ITS agent. 9. G. A federally insured depository financial institution. 10. Bank holding company, office of an international banking. 11. Corporation, foreign bank that establishes a federal branch. 12. Pursuant to the Federal International Bank Act 12 U.S.C. SEC 13 3102, as amended, a corporation organized pursuant to the 14 Federal Bank Service Corporation Act 12 U.S.C. Secs 1861 to 15 1867, as amended, or a corporation organized under the Edge 16 Act 12 U.S.C. Secs 611 to 633, as amended. 17. H. Electronic funds transfer of governmental benefits. 18. For a federal, state, county, or governmental agency by a 19. Contractor on behalf of the United States or a department. 20. Agency, or instrumentality of the United States or on behalf of 21. A state or governmental subdivision, agency, or instrumentality. 22. Of a state. 23. I. A board of trade designated as a contract market. 24. Under the Federal Commodity Exchange ACT, 7 U.S.C. Secs 1 to 25. 25, as amended, or a person that, in the ordinary course of 26 business, provides clearance and settlement services for a 27 board of trade to the extent of its operation as or for such a 13, HB 25-1201. 1 Board, 2, J, or registered futures commission merchant under 3 federal commodities laws to the extent of ITS operation as such for a merchant. 5, K, a person registered as a securities broker-dealer. 6 under federal or state securities laws to the extent of the 7 persons operation as such a broker-dealer. 8, L, an individual employed by a licensee, and authorized. 9 Delegate, or any person exempted from the licensing 10 requirements of this Article 110 when acting within the scope of 11. Employment and under the supervision of the licensee. 12 Authorized delegate, or exempted person as an employee and not. 13 as an independent contractor. 14 M, a person expressly appointed as a third-party service. 15 provider to or agent of an entity exempt under subsection 1 G 16 of this section, solely to the extent that. 17 I, the service provider or agent is engaging in money. 18 transmission on behalf of and pursuant to a written agreement. 19 with the exempt entity that sets forth the specific functions. 20 that the service provider or agent is to perform, and 21, 2, the exempt entity assumes all risk of loss and all. 22 legal responsibility for satisfying the outstanding money. 23 transmission obligations owed to purchasers and holders of the 24 outstanding money transmission obligations upon receipt of the 25 purchasers or holders' money or monetary value by the service. 26 provider or agent, or 27, N, a person exempt by regulation or order if the banking. 14, HB 25-1201. 1 Board finds an exemption to be in the public interest and that the 2 regulation of such person is not necessary for the purposes of 3 this Article 110. For 11-110-302. Authority to require demonstration of exemption. 5 The Banking Board may require that a person claiming to be 6 exempt from licensing pursuant to Section 11-110-301 provide 7 information and documentation to the Board demonstrating 8 that the person qualifies for the claimed exemption. 9 Part 410 Implementation, Confidentiality, Supervision, 11 and Relationship to Federal Law 1211-110-401. Implementation, Rules. 1. Powers. In order to 13 carry out the purposes of this Article 110, the Banking Board May 14th, subject to the provisions of Section 11-110-402, 1, and 215, a, enter into agreements or relationships with other 16 government officials or federal and state regulatory agencies. 17 and regulatory associations in order to improve efficiencies and 18 reduce regulatory burden by standardizing methods or 19 procedures and sharing resources, records, or related. 20 information obtained under this Article 110, 21, b, use, hire, contract, or employ analytical systems. 22 methods, or software to examine or investigate any person. 23 subject to this Article 110, 24, c, accept, from other state or federal governmental. 25 agencies or officials, licensing, examination, or investigation. 26 reports made by such other state or federal governmental. 27 agencies or officials, and 15, HB 25-1201. 1d. Accept audit reports made by an independent certified 2 public accountant or other qualified third-party auditor for an 3 applicant or licensee and incorporate the audit report in any 4 report of examination or investigation. 5. 2. Broad administrative authority, rules. A. The Banking 6 Board has broad administrative authority to 7. I. Administer, interpret, and enforce this Article 110. 8. 2. Adopt rules implementing this Article 110, including 9 rules to conform to applicable federal regulations. 10. 3. Recover the cost of administering and enforcing this 11 Article 110 by imposing and collecting proportionate and 12 equitable fees and costs associated with applications. 13. Examinations and investigations. And 14. 4. Take other reasonable actions required to achieve. 15. The purposes of this Article 110. 16. B. The powers, duties, and functions of the Banking Board. 17. And the Commissioner set forth in Article 102 of this Title 11 and 18. The declaration of policy set forth in Section 11-101-102 apply to 19. This Article 110. For purposes of this section and Section 2011-102-104, the Banking Board has the same powers, duties, and 21 functions concerning a violation of this Article 110, or a Rule 22 adopted pursuant to this Article 110, as the Board has 23 concerning a violation of the Colorado Banking Code, 24 Articles 101 to 109 and Article 10.5 of this Title 11, or a Rule 25 adopted pursuant to that code. 26 11-110-402. Confidentiality. 1. Except as otherwise 27 provided in subsection 2 of this section, all information or 16, HB 25-1201. 1. Reports obtained by the Banking Board from an applicant, 2. Licensee, or authorized delegate, and all information contained 3. In or related to an examination, investigation, operating report, for or condition report prepared by, on behalf of, or for the use of 5. The Board, or financial statements, balance sheets, or 6. Authorized delegate information, are confidential and are not 7. Subject to disclosure under the Colorado Open Records Act, 8 Part 2 of Article 72 of Title 24. 9. 2. The Banking Board may disclose information not 10 otherwise subject to disclosure under subsection 1 of this 11 section to representatives of state or federal agencies who 12 promise in a record that they will maintain the confidentiality. 13 of the information or where the Board finds that the release is 14 reasonably necessary for the protection and interest of the 15 public. 16. 3. This section does not prohibit the Banking Board from 17. Disclosing to the public a list of all licensees or the aggregated 18 financial or transactional data concerning those licensees. 19. 4. Information contained in the records of the Division 20 that is not confidential and may be made available to the public. 21. Either on the Division's website, upon receipt by the Division of a 22 written request, or in NMLS must include 23. A. The name, business address, telephone number, and 24. Unique identifier of a licensee. 25. B. The business address of a licensee's registered agent. 26. For service. 27. C. The name, business address, and telephone number of 17. HB 25-1201. 1. All authorized delegates. 2. D. The terms of or a copy of any bond filed by a licensee. 3. So long as confidential information, including but not limited to 4 prices and fees, for such bond is redacted. 5. E. Copies of any non-confidential final orders of the 6th Division relating to any violation of this Article 110 or Rule 7 implementing this Article 110. And 8. F. Imposition of an administrative fine or penalty under 9 this Article 110. 1011-110-403. Supervision. 1. The Banking Board may 11th conduct an examination or investigation of a licensee or 12 authorized delegate or otherwise take independent action. 13. Authorized by this Article 110 or by a rule adopted or order 14 issued under this Article 110 as reasonably necessary or 15. Appropriate to administer and enforce this Article 110. Rule 16 implementing this Article 110 and other applicable law. 17. Including the Bank Secrecy Act and the Federal, USA Patriot 18 Act, Pub.L. 107-56, the Banking Board may 19. A. Conduct an examination either on site or OFF site as the 20 Board may reasonably require. 21. B. Conduct an examination in conjunction with and 22. Examination conducted by representatives of other state. 23. Agencies or agencies of another state or of the federal. 24. Government. 25. C. Accept the examination report of another state. 26. Agency or an agency of another state or of the federal. 27. Government, or a report prepared by an independent accounting. 18. HB 25-1201. 1 firm, which, upon being accepted, is considered for all purposes 2 as an official report of the Board, and 3 d. Summon and examine under oath a key individual or 4 employee of a licensee or authorized delegate and require the 5 key individual, employee, or authorized delegate to produce 6 records regarding any matter related to the condition and 7 business of the licensee or authorized delegate. 8. 2. A licensee or authorized delegate shall provide, and 9. The Banking Board shall have full and complete access to all 10 records the Board may require to conduct a complete 11 examination. The records must be provided at the location and 12 in the format specified by the Board. However, the Board may 13th utilize multi-state record production standards and 14 examination procedures when such standards will reasonably 15 achieve the requirements of this subsection. 2. 16. 3. Unless otherwise directed by the Banking Board, a 17. Licensee shall pay all costs reasonably incurred in connection. 18. With an examination of the licensee or the licensee's authorized. 19. Delegates. 2011-110-404. Network supervision. 1. To efficiently and 21. Effectively administer and enforce this Article 110 and to 22. Minimize regulatory burden. The Banking Board may participate 23. In multi-state supervisory processes established between states. 24. And coordinated through the Conference of State Bank. 25. Supervisors, the Money Transmitter Regulators Association. 26. And affiliates and successors thereof for all licensees that 27 hold licenses in this state and other states. As a participant in 19. HB 25-1201. 1. Multi-state supervision. The Banking Board shall 2. A. Cooperate, coordinate, and share information with 3 other state and federal regulators in accordance with Section 411-110-402. 5. B. Enter into written cooperation, coordination, or 6. Information sharing contracts or agreements with 7 organizations, the membership of which is made up of state or 8 federal governmental agencies, and 9. C. Cooperate, coordinate, and share information with 10 organizations, the membership of which is made up of state or 11 federal governmental agencies, if the organizations agree in 12 writing to maintain the confidentiality and security of the 13 shared information in accordance with Section 11-110-402. 14. 2. The Banking Board does not waive, and nothing in this 15 section constitutes a waiver of, the Board's authority to 16. Conduct an examination or investigation or otherwise take 17. Independent action authorized by this Article 110 or a rule. 18. Adopted or order issued under this Article 110 to enforce. 19. Compliance with applicable state or federal law. 23. A joint examination or investigation, or acceptance of 21. An examination or investigation report, does not waive and 22. Examination assessment provided for in this Article 110. 23. 11-110-405. Relationship to federal law, interpretative 24. Guidance. 1. In the event state money transmission jurisdiction 25 is conditioned on a federal law, any inconsistencies between a 26 provision of this Article 110 and federal law governing money 27 transmission is governed by the applicable federal law to the 20. HB 25-1201. 1. Extent of the inconsistency. 2. In the event of any inconsistencies between this 3 Article 110 and federal law that governs money transmission for pursuant to subsection 1 of this section, the Banking Board may 5th provide interpretive guidance that 6. A. Identifies the inconsistency, and 7. B. Identifies the appropriate means of compliance with 8 federal law. 9. Part 510 Money Transmission Licenses 1111-110-501. License required. 1. A person shall not engage 12 in the business of money transmission or advertise, solicit, or 13 make representations that the person may provide money 14 transmission unless the person is licensed under this Article 110. 15. 2. Subsection 1 of this section does not apply to 16. A person that is an authorized delegate of a person 17 licensed under this Article 110 acting within the scope of 18 authority conferred by a written contract with the licensee, or 19. B. A person that is exempt pursuant to Section 11-110-301. 20 and does not engage in money transmission outside the scope of 21 such exemption. 2211-110-502. Consistent state licensing rules. 1. TO established 23 consistent licensing between Colorado and other states. The 24 Banking Board may, 25, A, implement all licensing provisions of this Article 110-26 in a manner that is consistent with other states that have 27 adopted laws regulating money transmission that are similar to 21 HB 25-1201. 1. The provisions of this Article 110 or multi-state licensing 2 processes, and 3. B. Participate in nationwide protocols for licensing for cooperation and coordination among state regulators if such 5 protocols are consistent with this Article 110. 6. 2. In order to fulfill the purposes of this Article 110, the 7 Banking Board may establish relationships or contracts with 8 NMLS or other entities designated by NMLS. TO enable the Board 9. 2. 10. A. Collect and maintain records. 11. B. Coordinate multi-state licensing processes and 12 supervision processes. 13. C. Process fees. And 14. D. Facilitate communication between Colorado and 15 licensees or other persons subject to this Article 110. 16. 3. The Banking Board may utilize NMLS for all aspects of 17 licensing in accordance with this Article 110, including but not 18 limited to license applications, applications for acquisitions of 19 control, surety bonds, reporting, criminal history background, 20 checks, credit checks, fee processing, and examinations. 21. 4. The Banking Board may utilize NMLS forms, processes, 22 and functionalities in accordance with this Article 110. In the 23 event NMLS does not provide forms, processes, or 24 functionalities for a provision of this Article 110, the Board may 25th implement this Article 110 in a manner that facilitates 26 uniformity with respect to licensing, supervision, reporting, and 27 regulation of licensees that are licensed in multiple. 22 HB 25-1201. 1. Jurisdictions. 2. 5. Waive or modify requirements. For the purpose of 3 participating in NMLS, the Banking Board may waive or modify, for in whole or in part, by rule or order, any or all of the 5 requirements and establish new requirements as reasonably 6 necessary to participate in NMLS. 711-110-503. Application for license, license fee, rules. 1. An 8 applicant for a license shall apply with the Banking Board in A9 form and in a medium prescribed by the Board. The Board by Rule 10 or procedure shall determine the content of the application and may 11th change or update the application in accordance with 12 applicable law or to carry out the purposes of this Article 110-13 and maintain consistency with NMLS licensing standards or 14 practices. The application must state or contain, as applicable, 15. A. The legal name and residential and business addresses 16 of the applicant and any fictitious or trade name used by the 17 applicant in conducting the applicant's business. 18. B. A list of any criminal convictions of the applicant and 19. Any material litigation in which the applicant has been involved. 20. In the 10-year period immediately preceding the submission of 21. The application. 22. C. A description of any money transmission previously 23 provided by the applicant and the money transmission that the 24 applicant seeks to provide in this state. 25. D. A list of the applicant's proposed authorized delegates. 26. And the locations in this state where the applicant and the 27 applicants authorized delegates propose to engage in money. 23 HB 25-1201. 1. Transmission. 2. E. A list of other states in which the applicant is licensed. 3. To engage in money transmission and any license revocations, for suspensions, or other disciplinary action taken against the 5 applicant in another state. 6. F. Information concerning any bankruptcy or 7. Receivership proceedings affecting the applicant or a person. 8. Control of an applicant. 9. G. A sample form of contract for authorized delegates. 10. If applicable. 11. H. A sample form of payment instrument or stored value. 12. As applicable. 13. I. The name and address of any federally insured. 14. Depository financial institution through which the applicant. 15. Plans to conduct money transmission. And 16. J. Any other information the Board or NMLS reasonably. 17. Requires with respect to the applicant. 18. 2. If an applicant is a corporation, limited liability. 19. Company, partnership, or other legal entity, the applicant shall 20 also provide. 21. A. The date of the applicant's incorporation or formation. 22. And state or country of incorporation or formation. 23. B. If applicable, a certificate of good standing from the 24 state or country in which the applicant is incorporated or 25 formed. 26. C. A brief description of the structure or organization of 27 the applicant, including any parents or subsidiaries of the 24 HB 25-1201. 1. Applicant, and whether any parents or subsidiaries are publicly traded. 3. D. The the legal name, any fictitious or trade name, all 4 business and residential addresses, and the employment, AS5 applicable, in the 10-year period immediately preceding the 6 submission of the application of each key individual and person 7 in control of the applicant. 8e. A list of any criminal convictions and material 9 litigation in which a person in control of the applicant that is 10 not an individual has been involved in the 10-year period. 11 immediately preceding the submission of the application. 12 f. A copy of audited financial statements of the applicant. 13 for the most recent fiscal year and for the 2-year period. 14 immediately preceding the submission of the application, or, if 15 determined to be acceptable to the banking board, certified. 16 unaudited financial statements for the most recent fiscal year. 17 or other period acceptable to the board. 18 g. A certified copy of unaudited financial statements of 19. The applicant for the most recent fiscal quarter. 20 h. If the applicant is a publicly traded corporation, a 21 copy of the most recent report filed with the United States 22 Securities and Exchange Commission under Section 13 of the 23 Federal Securities Exchange Act of 1934, 15 U.S.C. SEC, 78 AS 24 amended. 25 I. If the applicant is a wholly owned subsidiary of 26 I. A corporation publicly traded in the United States, a 27 copy of audited financial statements for the parent corporation. 25 HB 25-1201. 1 for the most recent fiscal year, or a copy of the parent 2 corporation's most recent report filed under Section 13 of the 3 Federal Securities Exchange Act of 1934, 15 U.S.C. SEC, 78 AS4 amended, or 5, 2, a corporation publicly traded outside the United States. A copy of similar documentation filed with the regulator. 7 of the parent corporation's domicile outside the United States. 8 J. The name and address of the applicant's registered 9 agent in this state. And 10 K. Any other information the banking board reasonably 11 requires with respect to the applicant. 12 3. An applicant must submit a non-refundable license fee. 13 as determined by the banking board, with the application for a 14 license. 15 4. The banking board may waive 1 or more 16 requirements of subsection 1 or 2 of this section, or permit an 17 applicant to submit other information in lieu of the required 18 information. 1911-110-504. Information requirements for certain individuals. 20. Background check, name-based judicial record check. 1. 21 individual in control of a licensee or applicant, and individual 22 that seeks to acquire control of a licensee, and each key 23 individual shall furnish to the banking board through NMLS 24 the following items. 25 A. The individual's fingerprints for submission to the 26 Federal Bureau of Investigation and the board for purposes of a 27 National Criminal History background check unless the person. 26 HB 25-1201. 1 currently resides outside of the United States and has resided 2 outside of the United States for the last 10 years, and 3 B. Personal history and experience in a form and in A4 medium prescribed by the board to obtain the following. 5 information related to any criminal convictions or 6 pending charges, and 7 2 information related to any regulatory or aid administrative action in any civil litigation involving claims 9 of fraud, misrepresentation, conversion, mismanagement of 10 money, breach of fiduciary duty, or breach of contract. 11 2. If the individual described in subsection 1 of this 12 section has resided outside of the United States at any time in 13 the last 10 years, the individual shall also provide to the 14 banking board an investigative background report prepared by 15 an independent search firm that meets the following 16 requirements. 17 A. At a minimum, the search firm shall 18 I. demonstrate that it has sufficient knowledge and 19 resources and employs accepted and reasonable methodologies. 20 to conduct the research of the background report, and 21 2. Not be affiliated with or have an interest with the 22 individual it is researching. 23 B. At a minimum, the investigative background report 24 must be written in the English language and must contain the 25 following. 26 I. Criminal records information for the past 10 years, 27 including but not limited to felonies, misdemeanors, or similar. 27 HB 25-1201. 1 Convictions for violations of law in the countries, provinces, 2 states, cities, towns, and contiguous areas where the individual 3 resided and worked. 4 2 Employment history. 5 3 Media history, including an electronic search of 6 national and local publications, wire services, and business 7 applications. And 8 4 Financial services related regulatory history. 9 Including but not limited to money transmission, securities, 10 Banking, insurance, and mortgage related industries. 11 3 When the results of a criminal history record check 12 performed pursuant to this section reveal a record of arrest 13 without a disposition, the board shall require the individual to 14 submit to and pay the required cost for a name-based judicial 15 record check, as defined in section 22-2-119.3, 6, d. 1611-110-505. Issuance of license, investigation of financial 17 condition, initial license term, denial, appeal. 1. When an 18 application for an original license appears to include all the 19 items and addresses all of the matters that are required 20 pursuant to this Article 110, the application is complete, and the 21 Banking Board shall promptly notify the applicant in a record 22 of the date on which the application is determined to be complete 23 and the date of scheduled action by the Board. 24.2. A determination by the banking board that in 25 application is complete and is accepted for processing means 26 only that the application, on its face, appears to include all of 27 the items, including the criminal background check response. Dash 28, HB 25-1201. 1 from the Federal Bureau of Investigation and the results of a 2 name-based judicial record check, if applicable, and addresses 3 all of the matters that are required pursuant to this Article 4.110, and the determination is not an assessment of the substance 5 of the application or of the sufficiency of the information 6 provided. 7.3. When an application is filed and considered complete 8 under this section, the banking board shall investigate the 9 applicants' financial condition and responsibility, financial and 10 business experience, competence, character, and general fitness. 11. The board may conduct an on-site investigation of the applicant, 12 with the applicant paying the reasonable cost of the 13 investigation. The board shall issue a license to an applicant 14 under this section if the board finds that all of the following 15 conditions have been fulfilled. 16. A. The applicant has complied with sections 11-110-50317 and 11-110-504, and 18. B. The financial condition and responsibility, financial. 19. And business experience, competence, character, and general 20 fitness of the applicant, and the competence, experience, 21 character, and general fitness of the key individuals and 22 persons in control of the applicant, indicate that it is in the 23 interest of the public to permit the applicant to engage in money 24 transmission. 25. 4. If an applicant uses or is otherwise subject to a 26 multi-state licensing process. 27. A. The banking board may accept the investigation. 29, HB 25-1201. 1. Results of a lead investigative state for the purpose of 2 subsection 3 of this section if the lead investigative state has 3 sufficient staffing, expertise, and minimum standards, or 4. B. If Colorado is a lead investigative state, the Banking 5 Board may investigate the applicant pursuant to subsection 3. 6 of this section and the time frames established by Agreement 7 through the multi-state licensing process. 8. 5. The Banking Board shall issue a formal written notice 9 of the denial of a license application within 30 days after 10 the decision to deny the application. The board shall set forth 11 in the notice of denial the specific reasons for the denial of the 12 application. An applicant whose application is denied by the 13 board under this subsection 5 may appeal within 30 days 14 after receipt of the written notice of the denial pursuant to 15 state administrative law procedures. 16. 6. The initial license term begins on the day the license 17 is issued. The license expires on December 31st of the year in which 18. The license term began, except that, if the initial license date is 19 between November 1st and December 31st, the initial license term 20 runs through December 31st of the following year. 21. 7. A license issued under this section is not transferable 22 or assignable. 23. 11-110-506. Renewal of license, annual fee, renewal report. 24. 1. A license issued under this Article 110 shall be renewed 25 annually. 26. B. Not more than 60 days before the license 27 expiration, a licensee shall pay an annual license fee to the 30, HB 25-1201. 1. Banking Board, as established by the Banking Board. 2. C. The renewal term is for a period of 1 year and begins 3 on January 1st of each year after the initial license term and 4 expires on December 31st of the year the renewal term begins. 5. 2. A licensee shall submit a renewal report with the 6 annual fee to the Banking Board, in a form and in a medium 7 prescribed by the Board by rule. The renewal report must state 8 or contain a description of each material change in information 9 submitted by the licensee in its original license application that 10 has not been reported to the Board. 11. 3. The Banking Board may grant an extension of the 12 renewal date for good cause. 13. 4. The Banking Board may utilize NMLS to process license 14 renewals if the functionality is consistent with the 15 requirements of this section. 16. 11-110-507. Maintenance of license, suspension and 17 revocation. 1. If a licensee does not continue to meet the 18 qualifications or satisfy the requirements for an applicant for 19. A new money transmission license described in this Article 110, 20. The Banking Board may suspend or revoke the licensee's license 21 in accordance with the procedures established by this Article 22-110 or other applicable state law for such suspension or 23 revocation. 24. 2. An applicant for a money transmission license shall 25 demonstrate that the applicant meets or will meet, and a 26 licensee shall at all times meet, the requirements in sections 2711-110-1001, 11-110-1002, and 11-110-1003. 31, HB 25-1201. 1 Part 6-2 Acquisition of control and change 3 of key individual for 11-110-601. Acquisition of control, application, fee, 5 Investigation of financial condition, denial, appeal, exemptions. 6. 1. A person, or group of persons acting in concert, seeking to 7 acquire control of a licensee shall obtain the written approval 8 of the Banking Board prior to acquiring control. An individual 9 is not deemed to acquire control of a licensee and is not subject 10 to this section if that individual becomes a key individual in the 11 ordinary course of business. 12. 2. A person, or group of persons acting in concert. 13. Seeking to acquire control of a licensee shall, in cooperation 14 with the licensee. 15. Submit an application in a form and in a medium 16 prescribed by the banking board by rule. And 17. B. Submit with the request for approval a non-refundable 18 fee established by the banking board. 19. 3. Upon request, the banking board may permit a licensee. 20. Or a person, or group of persons acting in concert, to submit. 21. Some or all information required by the board pursuant to 22 subsection 2a of this section without using NMLS. 23. 4. The application required by subsection 2a of this 24 section must include information required by section 11-110-50425 for new key individuals that have not previously completed the 26 requirements of section 11-110-504 for a licensee. 27. 5. When an application for acquisition of control. 32. HB 25-1201. 1 submitted under this section appears to include all the items and 2 address all of the matters that are required. The application is 3 considered complete, and the banking board shall promptly notify the applicant in a record of the date on which the 5 application was determined to be complete and approve or deny 6 the application within 90 days after the completion date. 7. 6. When an application is filed and considered complete 8 pursuant to subsection 5 of this section, the banking board 9 shall investigate the financial condition and responsibility, 10 financial and business experience, competence, character, and 11 general fitness of the person, or group of persons acting in 12 concert, seeking to acquire control. The board shall approve and 13 acquisition of control pursuant to this section if the board finds 14 that all of the following conditions have been fulfilled. 15. A. The requirements of subsections 2 and 4 of this 16 section have been met, as applicable, and 17. B. The financial condition and responsibility, financial 18 and business experience, competence, character, and general 19 fitness of the person, or group of persons acting in concert, 20 seeking to acquire control, and the competence, experience, 21 character, and general fitness of the key individuals and 22 persons that would be in control of the licensee after the 23 acquisition of control, indicate that it is in the interest of the 24 public to permit the person, or group of persons acting in 25 concert, to control the licensee. 26. 7. If an applicant uses or is otherwise subject to a 27 multi-state licensing process. 33. HB 25-1201. 1a. The banking board may accept the investigation 2 results of a lead investigative state for the purpose of 3 subsection 6 of this section if the lead investigative state has 4 sufficient staffing, expertise, and minimum standards, or 5b. If Colorado is a lead investigative state, the banking 6 board may investigate the applicant pursuant to subsection 6, 7 of this section and the time frames established by agreement 8 through the multi-state licensing process. 9. 8. The banking board shall issue a formal written notice 10 of the denial of an application to acquire control within 11 days after the decision to deny the application. The board shall 12 set forth in the notice of denial the specific reasons for the 13 denial of the application. An applicant whose application is 14 denied by the board under this subsection 8 may appeal within 30 days after receipt of the written notice of the denial 16 pursuant to state administrative law procedures. 17. 9. The requirements of subsections 1 and 2 of this 18 section do not apply to any of the following. 19. A. A person that acts as a proxy for the sole purpose of 20 voting at a designated meeting of the shareholders or holders 21 of voting shares or voting interests of a licensee or a person in 22 control of a licensee. 23. B. A person that acquires control of a licensee by devise 24 or dissent. 25. C. A person that acquires control of a licensee as a 26 personal representative, custodian, guardian, conservator, or 27 trustee or ASN. Officer appointed by a court of competent. 34. HB 25-1201. 1. Jurisdiction or by operation of law. 2. D. A person that is exempt under section 11-110-301, 1, G, 3 E. A person that the banking board determines is not for subject to subsection 1 of this section based on the public 5 interest. 6. F. A public offering of securities of a licensee or a person 7 in control of a licensee, or 8, G. An internal reorganization of a person in control of 9 a licensee where the ultimate person in control of the licensee 10 remains the same. 11. 10. Persons described in subsections 9b, 9c, 9d, 12, 9f, and 9g of this section shall, in cooperation with the 13 licensee, notify the banking board within 15 days after the 14 acquisition of control. 15. 11. Streamlined acquisition of control. A. The requirements 16 of subsections 1 and 2 of this section do not apply to a person 17 that has complied with and received approval to engage in 18 money transmission under this Article 110 or was identified as a 19 person in control in a prior application filed with and approved. 20 by the banking board or by an MSB accredited state pursuant to 21 a multi-state licensing process, so long as 22 the person has not had a license revoked or suspended. 23 or controlled a licensee that has had a license revoked or 24 suspended while the person was in control of the licensee in the 25 previous 5 years. 26. 2. If the person is a licensee, the person is well managed. 27 and has received at least a satisfactory rating for compliance. 35. HB 25-1201. 1. At the person's most recent examination by an MSB accredited 2 state if such rating was given. 3. The licensee to be acquired is projected to meet the 4 requirements of sections 11-110-1001, 11-110-1002, and 5 11-110-1003 after the acquisition of control is completed. And 6. If the person acquiring control is a licensee, that licensee is also 7 projected to meet the requirements of sections 11-110-1001, 8 11-110-1002, and 11-110-1003 after the acquisition of control is 9. Completed. 10. 4. The licensee to be acquired will not implement any 11 material changes to its business plan as a result of the 12 acquisition of control, and, if the person acquiring control is a 13 licensee, that licensee also will not implement any material 14 changes to its business plan as a result of the acquisition of 15 control, and 16. V. The person provides notice of the acquisition in 17 cooperation with the licensee and attests to the conditions. 18 specified in subsections 11a, I, to, 11a, 4 of this section IN. 19 a form and in a medium prescribed by the board by rule. 20 b. If the notice is not disapproved within the 90 days 21 after the date on which the notice was determined TOB 22 complete, the notice is deemed approved. 23. 12. Before filing an application for approval to acquire 24 control of a licensee, a person may request in writing a 25 determination from the banking board as to whether the person 26 would be considered a person in control of a licensee upon 27 consummation of a proposed transaction. If the board 36, HB 25-1201. 1 determines that the person would not be a person in control of 2 a licensee, the proposed person and transaction is not subject to 3 the requirements of subsections 1 and 2 of this section. 4. 13. If a multi-state licensing process includes a 5 determination made pursuant to subsection 12 of this section 6 and an applicant uses or is otherwise subject to the multi-state 7 licensing process, 8a, the banking board is authorized and encouraged to 9 accept the control determination of a lead investigative state 10 with sufficient staffing, expertise, and minimum standards for 11 the purpose of this subsection, 13, or 12b, if the state is a lead investigative state, the Banking 13 Board is authorized and encouraged to investigate the applicant 14 pursuant to this subsection, 13, and the time frames established 15 by agreement through the multi-state licensing process. 1611-110-602. Notice and information requirements for a change. 17 of key individuals. A licensee adding or replacing a key individual. 18 shall provide notice to the banking board in a manner prescribed. 19 by the board by rule within 15 days after the effective date. 20 of the key individual's appointment. 21 Part 722 Reporting and Records 2311-110-701. Report of Condition. 1. Each licensee shall 24 submit a report of condition to the banking board within 45 days after the end of a calendar quarter or within 26 any extended time as the board by rule may prescribe. 27. 2. The report of condition must include 37, HB 25-1201. 1a. Financial information at the licensee level. 2b. Nationwide and state-specific money transmission. 3. Transaction information in every jurisdiction in the United 4 states where the licensee is licensed to engage in money. 5. Transmission. 6c. A permissible investments report. 7d. Transaction destination country reporting for money. 8. Received for transmission, if applicable. And 9e. Any other information the banking board reasonably 10 requires with respect to the licensee. 11. 3. The information required by subsection 2d of this 12 section shall only be included in a report of condition submitted 13 within 45 days after the end of the 4th calendar 14 quarter. 1511-110-702. Audited financials. 1. Each licensee shall, 16 within 90 days after the end of each fiscal year, or within 17 any extended time as the banking board by rule may prescribe, 18 file with the board, 19a, an audited financial statement of the licensee for the 20 fiscal year prepared in accordance with United States 21 generally accepted accounting principles, and 22b, any other information that the board may reasonably 23 require. 24. 2. The audited financial statements shall be prepared by 25 an independent certified public accountant or independent 26 public accountant who is satisfactory to the banking board. 27. 3. The audited financial statements must include or be 38, HB 25-1201. 1. Accompanied by a certificate of opinion of the independent 2 certified public accountant or independent public accountant. 3. That is satisfactory in form and content to the banking board. For if the certificate or opinion is qualified, the board may order the 5 licensee to take any action that the board may find necessary. 6. To enable the independent certified public accountant or 7 independent public accountant to remove the qualification. 811-110-703. Authorized delegate reporting. 1. Each licensee 9 shall submit a report of authorized delegates to the banking 10 board within 45 days after the end of a calendar 11 quarter. The board is authorized and encouraged to utilize 12 NMLS for the submission of the report required by this section 13 if the functionality is consistent with the requirements of this 14 section. 15. 2. The authorized delegate report must include, at a 16 minimum, the following information for each authorized 17 delegate. 18a. Company legal name. 19b. Taxpayer employer identification number. 20c. principal provider identifier, 21, D, physical address, 22, E, mailing address, 23, F, business conducted in other states, if any, 24, G, fictitious or trade names, if any, 25, H, contact person name, phone number, and email, 26, I. Start date AS licensees authorized delegate, 27, J, end date acting AS licensees authorized delegate, if. Dash 39, HB 25-1201. 1 applicable, and 2, K, other information the banking board reasonably 3 requires with respect to the authorized delegate. For 11-110-704. Reports of certain events. 1. A licensee shall file a report with the banking board within 1 business day 6 after the licensee has reason to know of the occurrence of any 7 of the following events. 8. The filing of a petition by or against the licensee under 9 the United States Bankruptcy Code, 11 U.S.C. Secs. 1012-110, AS 10 amended, for bankruptcy or reorganization. 11. B. The filing of a petition by or against the licensee for 12 receivership, the commencement of any other judicial or 13 administrative proceeding for the licensee's dissolution or 14 reorganization, or the making of a general assignment for the 15 benefit of the licensee's creditors. Or 16. C. The commencement of a proceeding to revoke or 17 suspend the licensee's license in a state or country in which the 18 licensee engages in business or is licensed. 19. 2. A licensee shall file a report with the banking board. 20 within 3 business days after the licensee has reason to know 21 of the occurrence of any of the following events. 22. A. A charge or conviction of the licensee or of a key 23 individual or person in control of the licensee for a felony, or 24. B. A charge or conviction of an authorized delegate for 25 a felony. 2611-110-705. Bank Secrecy Act reports. A licensee and an 27 authorized delegate shall file all reports required by federal. 40, HB 25-1201. 1. Currency reporting, record keeping, and suspicious activity. 2. Reporting requirements as set forth in the Bank Secrecy Act and 3 other federal and state laws pertaining to money laundering. For the timely filing of a complete and accurate report required 5 under this section with the appropriate federal agency is deemed 6 compliant with the requirements of this section. 711-110-706. Records, rules. 1. A licensee shall maintain 8 the following records for determining the licensee's compliance. 9 with this Article 110 for at least 3 years after the creation. 10 of the record. 11. A record of each outstanding money transmission. 12 obligation sold. 13. B. A general ledger posted at least monthly containing 14 all asset, liability, capital, income, and expense accounts. 15. C. Bank statements and bank reconciliation records. 16. D. Records of outstanding money transmission. 17. Obligations. 18. E. Records of each outstanding money transmission. 19. Obligation paid within the 3-year period. 20. F. A list of the last known names and addresses of all of 21 the licensee's authorized delegates, and 22. G. Any other records the banking board by Rule 23 reasonably requires. 24. 2. The items specified in subsection 1 of this section May 25th be maintained in any form of record. 26. 3. Records specified in subsection 1 of this section May 27th be maintained outside the state if they are made accessible to. 41. HB 25-1201. 1. The banking board with 10 business days notice that is sent in 2A record. 3. 4. All records maintained by the licensee as required in 4 subsections 1, 2, 3 of this section are open to inspection by the 5 banking board pursuant to section 11-110-403, 1. 6 Part 8-7 Authorized Delegates 811-110-801. Relationship between licensee and authorized 9 delegate, written policies and procedures required, background 10 investigation, definition. 1. As used in this section, remit means 11 to make direct payments of money to a licensee or the licensee's 12 representative authorized to receive money or to deposit money. 13 in a bank in an account specified by the licensee. 14. 2. Before a licensee is authorized to conduct business. 15 Through an authorized delegate or allows a person to act as. 16 The licensee's authorized delegate, the licensee shall. 17. A. Adopt and update as necessary, written policies and 18 procedures reasonably designed to ensure that the licensees 19 authorized delegates comply with applicable state and federal 20 law. 21. B. Enter into a written contract that complies with 22 subsection 4 of this section, and 23. C. Conduct a reasonable risk-based background. 24 Investigation sufficient for the licensee to determine whether 25 the authorized delegate has complied and will likely comply. 26 With applicable state and federal law. 27. 3. An authorized delegate must operate in full. 42. HB 25-1201. 1. Compliance with this Article 110. 2. 4. The written contract required by subsection 2b of 3 this section must 4. Be signed by the licensee and the authorized delegate. 5. And, at a minimum, must appoint the person signing the contract. 6. As the licensee's authorized delegate with the authority to 7. Conduct money transmission on behalf of the licensee. 8. B. Set forth the nature and scope of the relationship. 9. Between the licensee and the authorized delegate and the 10 respective rights and responsibilities of the Parties, 11, c, require the authorized delegate TO agree to fully 12 comply with all applicable state and federal laws, rules, and 13 regulations pertaining to money transmission, including this 14 Article 110 and rules implementing this Article 110 and relevant 15 provisions of the Bank Secrecy ACT and the Federal USA 16 Patriot ACT, PUB.L. 107 to 56, 17, d, require the authorized delegate TO remit and handle 18 money and monetary value in accordance with the terms of the 19 contract between the licensee and the authorized delegate. 20 e, impose a trust on money and monetary value net of 21 fees received for money transmission for the benefit of the 22 licensee. 23 f, require the authorized delegate TO prepare and 24 maintain records as required by this Article 110 or Rules 25 implementing this Article 110 or as reasonably requested by the 26 Banking Board. 27 g, acknowledge that the authorized delegate consents. 43 HB 25-1201. 1-2 examination or investigation by the Banking Board. 2-h, state that the licensee is subject to regulation by the 3 Banking Board and that, as part of that regulation, the Board may fourth suspend or revoke an authorized delegate designation or 5 require the licensee TO terminate an authorized delegate 6 designation, and 7-i, acknowledge receipt of the written policies and 8 procedures required under subsection 2-a of this section. 9-5, if the licensee's license is suspended, revoked, 10 surrendered, or expired, the licensee must, within 5 business 11 days, provide documentation to the Banking Board that the 12 licensee has notified all applicable authorized delegates of the 13 licensee whose names are in a record filed with the Board of the 14 suspension, revocation, surrender, or expiration of a license. 15 upon suspension, revocation, surrender, or expiration of a 16 license, applicable authorized delegates shall immediately 17 cease to provide money transmission as an authorized delegate. 18 of the licensee. 19.6. An authorized delegate of a licensee holds in trust for 20 the benefit of the licensee all money net of fees received from 21 money transmission. If an authorized delegate commingles any 22 money received from money transmission with any other money 23 or property owned or controlled by the authorized delegate, 24 all commingled money and other property shall be considered 25 held in trust in favor of the licensee in an amount equal to the 26 amount of money net of fees received from money transmission. 27.7. An authorized delegate shall not use a subdelegate to 44, HB 25-1201. 1. Conduct money transmission on behalf of a licensee. 211-110-802. Unauthorized activities, joint and several. 3. Liability. A person shall not engage in the business of money for transmission on behalf of a person not licensed under this 5 Article 110 or not exempt pursuant to Part 3 of this Article 110. 6. A person that engages in such activity provides money 7. Transmission to the same extent as if the person were a licensee. 8. And shall be jointly and severally liable with the unlicensed or 9. Non-exempt person. 10. Part 9. 11. Timely transmission, refunds, and disclosures. 1211-110-901. Timely transmission. 1. Every licensee shall 13 forward all money received for transmission in accordance 14 with the terms of the agreement between the licensee and the 15 sender unless the licensee has a reasonable belief or a 16 reasonable basis to believe that the sender may be a victim of 17 fraud or that a crime or violation of a law, rule, or regulation 18 has occurred, is occurring, or may occur. 19.2. If a licensee fails to forward money received for 20 transmission in accordance with this section, the licensee must 21 respond to inquiries by the sender with the reason for the 22 failure unless providing a response would violate a state or 23 federal law, rule, or regulation. 2411-110-902. Refunds. 1. This section does not apply to 25a. Money received for transmission subject to the 26 Federal Remittance Rule, 12 CFR 1005, Subpart B, or 27b. Money received for transmission pursuant to a 45, HB 25-1201. 1. Written agreement between the licensee and payee to process 2 payments for goods or services provided by the payee. 3.2. Every licensee shall refund to the sender within 4 days after receipt of the sender's written request for a refund 5 any and all money received for transmission unless any of the 6 following occurs. 7.a. The money has been forwarded within 10 days after 8 the date on which the money was received for transmission. 9.b. Instructions have been given committing an equivalent 10 amount of money to the person designated by the sender within 10 days after the date on which the money was received for 12 transmission. 13. C. The agreement between the licensee and the sender. 14. Instructs the licensee to forward the money at a time that is 15 beyond 10 days after the date on which the money was received. 16. For transmission. If money has not yet been forwarded in 17 accordance with the terms of the agreement between the 18 licensee and the sender, the licensee shall issue a refund in 19 accordance with the other provisions of this section. 20d. The refund is requested for a transaction that the 21 licensee has not completed based on a reasonable belief or a 22 reasonable basis to believe that a crime or violation of law, 23 rule, or regulation has occurred, is occurring, or may occur, or 24e. The refund request does not enable the licensee to 25i. Identify the sender's name and address or telephone 26 number, or 27, 2. Identify the particular transaction to be refunded in 46, HB 25-1201. 1. The event the sender has multiple transactions outstanding. 211-110-903. Receipts, definition. 1. This section does not 3 apply to 4. A. Money received for transmission subject to the 5 Federal Remittance Rule, 12 CFR 1005, Subpart B. 6. B. Money received for transmission that is not primarily 7 for personal, family, or household purposes. 8. C. Money received for transmission pursuant to a written 9 agreement between the licensee and payee. TO process payments. 10 for goods or services provided by the payee, or 11. D. Payroll processing services. 12. 2. As used in this section, receipt means a paper receipt, 13 electronic record, or other written confirmation. For a 14 transaction conducted in person, the receipt may be provided 15 electronically if the sender requests or agrees to receive an 16 electronic receipt. For a transaction conducted electronically 17 or by phone, a receipt may be provided electronically. All 18 electronic receipts shall be provided in a retainable form. 19. 3. A. Every licensee or every licensee's authorized 20 delegate shall provide the sender a receipt for money received. 21 for transmission. 22. B. The receipt must contain the following information: AS 23 applicable. 24. I. The name of the sender. 25. 2. The name of the designated recipient. 26. 3. The date of the transaction. 27. 4. The unique transaction or identification number. 47. HB 25-1201. 1. V. The name of the licensee, the NMLS unique identifier, 2. The licensee's business address, and the licensee's customer 3. Service telephone number. 4. 6. The amount of the transaction in United States $5. 6. 7. The fee charged by the licensee to the sender for the 7 transaction, if any, and 8. 8. Taxes collected by the licensee from the sender for 9. The transaction, if any. 10. C. The receipt required by this section must be in English. 11. And in the language principally used by the licensee or 12. Authorized delegate, if other than English. TO advertise, solicit. 13. Or negotiate, either orally or in writing, for a transaction. 14. Conducted in person, electronically, or by phone. 15. 11-110-904. Notice. Every licensee or authorized delegate. 16. Shall include on a receipt described in section 11-110-903 or 17. Disclose on the licensee's website or mobile application the name, 18, and phone number of the division and a statement that the 19 licensee's customers can contact the division with questions or 20 complaints about the licensee's money transmission services. 21. 11-110-905. Disclosures for payroll processing services. 1. A 22 licensee that provides payroll processing services shall, 23. A. Issue reports to clients detailing client payroll. 24. Obligations in advance of the payroll money being deducted. 25. From an account, and 26. B. Make available worker pay stubs or an equivalent. 27. Statement to workers. 48. HB 25-1201. 1. 2. Subsection 1 of this section does not apply to a 2 licensee providing payroll processing services where the 3 licensee's client designates the intended recipients to the 4 licensee and is responsible for providing the disclosures. 5. Required by subsection 1 B of this section. 6. Part 10. 7. Prudential Standards 811-110-1001. Net worth. 1. A licensee licensed pursuant to 9 this Article 110 shall maintain at all times a tangible net worth 10 of the greater of $100,000 or 3. 11% of total assets for the first $100 million. 12%, 2% of additional assets for $113 million to $1 billion, and 1/2 of 14% of additional assets for over $1 billion. 15. 2. Tangible net worth required by subsection 1 of this 16 section must be demonstrated at initial application by the 17 applicants' most recent audited or unaudited financial 18 statements pursuant to section 11-110-503, 2, F. 19. 3. Notwithstanding subsections 1 and 2 of this section, 20. The banking board may, for good cause shown, exempt, in part or 21 in whole, an applicant or licensee from the requirements set 22 forth in this section. 23. 11-110-1002. Surety bond. 1. An applicant for a Money 24 transmission license shall provide, and a licensee at all times 25 shall maintain, security consisting of a surety bond in a Form 26 satisfactory to the banking board or, with the board's approval, 27 a deposit instead of a bond in accordance with this section. 49. HB 25-1201. 1. 2. The amount of the required security is the greater of $250,000 or an amount equal to 1/300% of the licensee's average daily money for transmission liability in this state calculated for the most 5 recently completed 3-month period, up to a maximum of $16 million. 7. 3. A licensee that maintains a bond in the maximum 8 amount provided for in subsection 2 of this section is not 9 required to calculate its average daily money transmission 10 liability in this state for purposes of this section. 11-110-1003. Maintenance of permissible investments, 12 statutory trust rules. 1. A licensee shall maintain at all times 13 permissible investments that have a market value computed in 14 accordance with United States generally accepted accounting 15 principles of not less than the aggregate amount of all of the 16 licensees' outstanding money transmission obligations. 17. 2. Except for permissible investments enumerated in 18 Section 11-110-1004, 1. The Banking Board, with respect to a 19 licensee, may by rule or order limit the extent to which a 20 specific investment maintained by a licensee within a class of 21 permissible investments may be considered a permissible 22 investment if the specific investment represents undue risk to 23 customers not reflected in the market value of investments. 24. 3. Permissible investments, even if commingled with other 25 assets of a licensee, are held in trust for the benefit of the 26 purchasers and holders of the licensee's outstanding money 27 transmission obligations in the event of insolvency, the filing of -50, HB 25-1201. 1. A petition by or against the licensee under the United States 2 Bankruptcy Code, 11 U.S.C. Secs. 101-110, as amended, for 3 bankruptcy or reorganization, the filing of a petition by or for against the licensee for receivership, the commencement of any 5 other judicial or administrative proceeding for the licensee's 6 dissolution or reorganization, or an action against the licensee 7 by a creditor that is not a beneficiary of the statutory trust. 8. Permissible investments impressed with a trust pursuant to this 9 section are not subject to attachment, levy of execution, or 10 sequestration by order of any court, except for a beneficiary of 11 the statutory trust. 12. 4. Upon the establishment of a statutory trust in 13 accordance with subsection 3 of this section or when money is 14 drawn on a letter of credit pursuant to section 11-110-1004-15, 1d, the Banking Board shall notify the applicable regulator. 16. Of each state in which the licensee is licensed to engage in money. 17. Transmission, if any, of the establishment of the trust or the 18 money drawn on the letter of credit, as applicable. Notice is 19 deemed satisfied if performed pursuant to a multi-state 20 agreement or through an MLS. Money drawn on a letter of 21 credit, and any other permissible investments held in trust for 22 the benefit of the purchasers and holders of the licensee's 23 outstanding money transmission obligations, is deemed held in 24 trust for the benefit of such purchasers and holders on a pro 25 rata and equitable basis in accordance with statutes pursuant 26 to which permissible investments are required to be held in this 27 state, and other states, as applicable. A statutory trust. 51, HB 25-1201. 1. Established pursuant to this section is terminated upon 2. Extinguishment of all of the licensee's outstanding money 3. Transmission obligations. 4. 5. The Banking Board by rule may allow other types of 5 investments that the Board determines are of sufficient 6. Liquidity and quality to be a permissible investment. The Banking 7 Board may participate in efforts with other state regulators to 8. Determine that other types of investments are of sufficient 9. Liquidity and quality to be a permissible investment. 1011-110-1004. Types of permissible investments, rules. 1. The 11 following investments are permissible under Section 11-110-1003, 12, a. Cash, including demand deposits, savings deposits, and 13 money in such accounts held for the benefit of the licensee's 14 customers in a federally insured depository financial 15 institution, and cash equivalents, including ACH items in transit 16 to the licensee and ACH items or international wires in transit. 17. To a payee, cash in transit via armored car, cash in smart safes. 18. Cash in licensee-owned locations, debit card or credit. 19. Card-funded transmission receivables owed by a bank or money. 20. Market mutual funds rated AAA, BYSAMP Global Ratings or the 21 equivalent from any eligible rating service. 22. B. Certificates of deposit or senior debt obligations of and 23. Insured depository institution. As defined in Section 3 of the 24 Federal Deposit Insurance Act, 12 U.S.C. SEC 1813, as amended. 25. Or as defined under the Federal Credit Union Act. 12 U.S.C. SEC. 26-1781, as amended. 27, c. An obligation of the United States or a commission. 52, HB 25-1201. 1. Agency, or instrumentality of the United States, an obligation to that is guaranteed fully as to principal and interest by the 3 United States, or an obligation of a state or a governmental for subdivision, agency, or instrumentality of a state, or 5, d. The full drawable amount of an irrevocable standby 6 letter of credit for which the stated beneficiary is the Banking 7 Board that stipulates that the beneficiary need only draw a 8 site draft under the letter of credit and present it to. Obtain 9 money up to the letter of credit amount within 7 days after 10 presentation of the items required by subsection 2, c, of this 11 section. 12, 2, a. The letter of credit described in subsection 1, d, of 13 this section must, 14, I, be issued by, 15, a federally insured depository financial institution, 16, b, a foreign bank that is authorized under federal law 17 to maintain a federal agency or federal branch office in a state 18 or states, or 19, c, a foreign bank that bears an eligible rating or whose 20 parent company bears an eligible rating, that is regulated, 21 supervised, and examined by federal or state authorities having 22 regulatory authority over banks, credit unions, and trust 23 companies, and that is authorized under state law to maintain 24 a branch in a state, 25, 2, be irrevocable, be unconditional, and indicate that 26 the letter of credit is not subject to any condition or 27 qualifications outside of the letter of credit. 53, HB 25-1201. 1. 3. Not contain reference to any other agreements, to documents, or entities or otherwise provide for any security 3. Interest in the licensee, and 4. Contain an issue date and expiration date, and 5. Expressly provide for automatic extension, without a written 6. Amendment, for an additional period of 1 year after the 7 present and each future expiration date, unless the issuer of the 8 letter of credit notifies the banking board in writing by 9 certified or registered mail or courier mail or other receipted 10 means, at least 60 days prior to any expiration date, that the 11 irrevocable letter of credit will not be extended. 12b. In the event of a notice of expiration or non-extension 13 of a letter of credit issued under subsection 2a 4 of this 14 section, the licensee is required to demonstrate to the 15 satisfaction of the banking board, at least 15 days prior to 16 expiration, that the licensee maintains and will maintain 17 permissible investments in accordance with section 11-110-1003. 18. 1. Upon the expiration of the letter of credit. If the licensee is 19 not able to do so, the board may draw on the letter of credit in 20 an amount up to the amount necessary to meet the licensee's 21 requirements to maintain permissible investments in accordance 22 with section 11-110-1003. 1. A draw on the letter of credit by 23 the board shall be offset against the licensee's outstanding 24 money transmission obligations. The drawn money shall be held 25 in trust by the board or the board's designated agent, to the 26 extent authorized by law, as agent for the benefit of the 27 purchasers and holders of the licensee's outstanding money. 54, HB 25-1201. 1. Transmission obligations. 2. C. The letter of credit must provide that the issuer of the 3 letter of credit will honor, at sight, a presentation made by the 4 beneficiary to the issuer of the following documents on or prior 5 to the expiration date of the letter of credit. 6. I. The original letter of credit, including any 7 amendments, and 8. 2. A written statement from the beneficiary stating that 9. Any of the following events have occurred. 10. A. The filing of a petition by or against the licensee. 11. Under the United States Bankruptcy Code, 11 U.S.C. Secs. 101 to 12110, as amended, for bankruptcy or reorganization. 13. B. The filing of a petition by or against the licensee for 14. Receivership or the commencement of any other judicial or 15. Administrative proceeding for its dissolution or reorganization. 16. C. The seizure of assets of a licensee by a banking board. 17. Pursuant to an emergency order issued in accordance with 18. Applicable law, on the basis of an action, violation, or condition. 19. That has caused or is likely to cause the insolvency of the 20 licensee, or 21. D. The beneficiary has received notice of expiration or 22. Non-extension of a letter of credit, and the licensee failed to 23. Demonstrate to the satisfaction of the beneficiary that the 24 licensee will maintain permissible investments in accordance 25 with section 11-110-1003. 1. Upon the expiration or non-extension 26 of the letter of credit. 27. D. The banking board may designate an agent to serve on 55, HB 25-1201. 1. The board's behalf as beneficiary to a letter of credit so long as 2. The agent and letter of credit meet requirements established by 3. The board's agent may serve as agent for multiple for licensing authorities for a single irrevocable letter of credit if 5. The proceeds of the drawable amount for the purposes of 6 subsection 1 D of this section are assigned to the board. 7. E. The banking board is authorized and encouraged to 8. Participate in multi-state licensing processes designed to 9. Facilitate the issuance and administration of letters of credit. 10. Including but not limited to services provided by NMLS and the 11 State Regulatory Registry, LLC. 12. 3. Unless permitted by the banking board by rule or by 13 order to exceed the limits as set forth in this subsection. 3. The 14 following investments are permissible under section 11-110-1003, 15 to the extent specified. 16. A. I. Except as provided in subsection 3. A. 2 of this 17 section, receivables that are payable to a licensee from the 18 licensees authorized delegates in the ordinary course of 19 business that are less than 7 days old, up to 50% of 20 the aggregate value of the licensee's total permissible 21 investments. 22. 2. Of the receivables permissible under subsection 23, 3, A, I, of this section, receivables that are payable to a 24 licensee from a single authorized delegate in the ordinary 25 course of business must not exceed 10% of the aggregate 26 value of the licensee's total permissible investments. 27. B. The following investments, up to 20% PR. 56, HB 25-1201. 1. Category and combined up to 50% of the aggregate 2 value of the licensee's total permissible investments. 3. I. A short-term investment of up to 6 months bearing an 4 eligible rating. 5. 2. Commercial paper bearing an eligible rating. 6. 3. A bill, note, bond, or debenture bearing an eligible 7 rating. 8. 4. United States TRI party repurchase agreements. 9. Collateralized at 100% or more, with United 10 States government or agency securities, municipal bonds, or 11 other securities bearing an eligible rating. 12. V. Money market mutual funds rated less than AAA, 13 and equal to or higher than A-BY S&P Global Ratings or the 14 equivalent from any other eligible rating service. And 15. 6. A mutual fund or other investment fund composed 16 solely and exclusively of one or more permissible investments 17 listed in subsections 1, A, 2, 1, C, of this section, and 18, C, cash, including demand deposits, savings deposits, and 19 cash in such accounts held for the benefit of the licensees. 20 customers at foreign depository institutions, up to 10% 21 of the aggregate value of the licensee's total permissible 22 investments if the licensee has received a satisfactory rating in 23 the licensee's most recent examination and if the foreign 24 depository institution, 25, I, has an eligible rating, 26, 2, is registered under the Federal Foreign Account Tax 27 Compliance Act, Pub.L. 111 to 47. 57, HB 25-1201. 1, 3, is not located in any country subject to sanctions. 2, from the Office of Foreign Assets Control, and 3, 4, is not located in a high-risk or non-cooperative 4 jurisdiction as designated by the International Financial Action 5 Task Force. 6 Part 11-7 Enforcement and Judicial Review 811-110-1101. Suspension and revocation of license. 1. The 9 Banking Board may suspend or revoke a license or order a 10 licensee to revoke the designation of an authorized delegate if 11. A. The licensee violates this Article 110 or a rule adopted 12 or an order issued under this Article 110. 13. B. The licensee does not cooperate with an examination 14 or investigation by the board. 15. C. The licensee engages in fraud, intentional 16 misrepresentation, or gross negligence. 17. D. An authorized delegate is convicted of a violation of 18 a state or federal anti-money laundering statute, or violates 19 a rule adopted or an order issued under this Article 110, as a 20 result of the licensee's willful misconduct or willful blindness. 21. E. The competence, experience, character, or general 22 fitness of the licensee, authorized delegate, person in control 23 of the licensee, key individual, or responsible person of the 24 authorized delegate indicates that it is not in the public interest 25 to permit the person to provide money transmission. 26. F. The licensee engages in an unsafe or unsound practice. 27. G. The licensee is insolvent, suspends payment of ITS. 58, HB 25-1201. 1. Obligations, or makes a general assignment for the benefit of ITS 2 creditors, or 3. H. The licensee does not remove an authorized delegate 4 after the board issues and serves upon the licensee a final 5 order, including a finding that the authorized delegate has 6 violated this Article 110. 7. 2. In determining whether a licensee is engaging in an 8 unsafe or unsound practice, the banking board may consider the 9 size and condition of the licensee's money transmission, the 10 magnitude of the loss, the gravity of the violation of this 11 Article 110 or a rule adopted or order issued under this Article 12-110, and the previous conduct of the person involved. 1311-110-1102. Suspension and revocation of authorized 14 delegates. 1. The banking board may issue an order suspending 15 or revoking the designation of an authorized delegate if the 16 board finds that 17. A. The authorized delegate violated this Article 110 or 18. A rule adopted or an order issued under this Article 110. 19. B. The authorized delegate did not cooperate with an 20 examination or investigation by the board. 21. C. The authorized delegate engaged in fraud, intentional 22 misrepresentation, or gross negligence. 23. D. The authorized delegate is convicted of a violation of 24 a state or federal anti-money laundering statute. 25. E. The competence, experience, character, or general 26 fitness of the authorized delegate or a person in control of the 27 authorized delegate indicates that it is not in the public interest. 59, HB 25-1201. 1. TO permit the authorized delegate TO provide money to transmission, or 3. F. The authorized delegate is engaging in an unsafe or 4 unsound practice. 5. 2. In determining whether an authorized delegate is 6 engaging in an unsafe or unsound practice, the banking board may 7th consider the size and condition of the authorized delegate's 8 provision of money transmission, the magnitude of the loss, the 9 gravity of the violation of this Article 110 or a rule adopted or 10 order issued under this Article 110, and the previous conduct of 11 the authorized delegate. 12. 3. An authorized delegate may apply for relief from a 13 suspension or revocation of designation as an authorized 14 delegate according to procedures prescribed by the Banking 15 Board by Rule 1611-110-1103. Orders to cease and desist. 1. If the Banking 17 Board determines that a violation of this Article 110 or a Rule 18 adopted or an order issued under this Article 110 by a licensee 19 or authorized delegate is likely to cause immediate and 20 irreparable harm to the licensee's customers, or 21 the public as a result of the violation, or cause insolvency or 22 significant dissipation of assets of the licensee, the board may 23rd issue an order requiring the licensee or authorized delegate to 24 cease and desist from the violation that the order becomes effective 25 upon service of the order upon the licensee or authorized 26 delegate. 27. 2. The banking board may issue an order against a 60, HB 25-1201. 1. Licensee to cease and desist from providing money transmission to through an authorized delegate that is the subject of a 3 separate order by the board. 4. 3. An order to cease and desist remains effective and 5. Enforceable pending the completion of an administrative 6 proceeding pursuant to state administrative procedures. 7. 4. A licensee or an authorized delegate that is served 8 with an order to cease and desist may petition the appropriate 9 court for a judicial order setting aside, limiting, or suspending 10 the enforcement, operation, or effectiveness of the order 11 pending the completion of an administrative proceeding 12 pursuant to state administrative procedures. 13.5. An order to cease and desist expires within 10 days. 14. After the order is issued unless the banking board commences an 15. Administrative proceeding pursuant to State Administrative 16 procedures. 1711-110-1104. Consent orders. The banking board may enter 18 into a consent order at any time with a person to resolve a 19 matter arising under this Article 110 or a rule adopted or Order 20 issued under this Article 110. A consent order must be signed by 21 the person to whom it is issued or by the person's authorized 22 representative and must indicate agreement with the terms 23 contained in the order. A consent order may provide that it does 24 not constitute an admission by a person that this Article 110 or 25 a rule adopted or an order issued under this Article 110 has been 26 violated. 2711-110-1105. Criminal penalties. 1. An individual that 61, HB 25-1201. 1. Intentionally makes a false statement, misrepresentation, or 2. False certification in a record filed or required to be maintained. 3. Under this Article 110 or that intentionally makes a false entry for or omits a material entry in such a record commits a Class 2-5 misdemeanor and shall be punished as provided in Section 618-1.3-501. 7. 2. An individual that knowingly engages in an activity 8 for which a license is required under this Article 110 without 9 being licensed under this Article 110 and that receives more $10 than $500 in compensation within a 30-day 11 period from this activity commits a Class 2 misdemeanor and 12 shall be punished as provided in Section 18-1.3-501. 13. 3. An individual that knowingly engages in an activity 14 for which a license is required under this Article 110 without 15 being licensed under this Article 110 and that receives no more $16 than $500 in compensation within a 30-day 17 period from this activity commits a Class 2 misdemeanor and 18 shall be punished as provided in Section 18-1.3-501. 1911-110-1106. Civil penalties. The banking board may assess 20 a civil penalty against a person that violates this Article 110 or 21 a rule adopted or an order issued under this Article 110 in an 22 amount as determined by the board for each day the violation 23 is outstanding, plus this state's costs and expenses for the 24 investigation and prosecution of the matter, including 25 reasonable attorney fees. 2611-110-1107. Unlicensed persons. 1. If the banking board 27 has reason to believe that a person has violated or is violating 62, HB 25-1201. 1. Section 11-110-501, the board may issue an order to show cause 2y an order to cease and desist should not be issued requiring 3 that the person cease and desist from the violation of Section 411-110-501. 5. 2. In an emergency, the banking board may petition the 6 appropriate court for the issuance of a temporary restraining 7 order ex parte pursuant to the rules of civil procedure. 8. 3. An order to cease and desist becomes effective upon 9 service of the order upon the person. 10. 4. An order to cease and desist remains effective and 11 enforceable pending the completion of an administrative 12 proceeding pursuant to state administrative procedures. 13. 5. A person that is served with an order to cease and 14 desist for violating Section 11-110-501 may petition the 15 appropriate court for a judicial order setting aside, limiting, or 16 suspending the enforcement, operation, or effectiveness of the 17 order pending the completion of an administrative proceeding. 18. Pursuant to state administrative procedures. 1911-110-1108. Judicial review. A person aggrieved and 20 directly affected by an order of the banking board issued under 21 this Article 110 may seek a review in the district court of this 22 state in and for the county in which the principal place of 23 business of the applicant, licensee, or authorized delegate is 24 located within 30 days after receipt of written notice of the 25 order. 26 Part 1227 Miscellaneous Provisions. 63, HB 25-1201. 1111101201. Uniformity of application and construction. In 2 applying and construing this Article 110, consideration must be 3 given to the need to promote uniformity of the law with respect 4 to its subject matter among states that enact it. 511-110-1202. Severability. If any provision of this Article 6.110 or the application thereof to any person or circumstance is 7 held invalid, such invalidity does not affect other provisions or 8 applications of this Article 110 that can be given effect without 9 the invalid provision or application, and to this end the 10 provisions of this Article 110 are declared to be severable. 1111-110-1203. Repeal of Article, Review of Functions. This 12 Article 110 is repealed, effective September 1, 2030. Before the 13 repeal, this Article 110 is scheduled for review in accordance 14 with Section 24-34-104. 15 Section 2. Act subject to petition, effective date. This Act 16 takes effect at 12:01 a.m. on the day following the expiration of the 1790-day period after final adjournment of the General Assembly, except 18 that, if a referendum petition is filed pursuant to Section 1(3) of Article V-19 of the State Constitution against this Act or an item, section, or part of this 20 Act within such period, then the Act, item, section, or part will not take 21 effect unless approved by the people at the general election to be held in November 22, 2026 and, in such case, will take effect on the date of the 23 official declaration of the vote thereon by the Governor. 64, HB 25-1201.
The committee will come back to order. Members, please join us. We're back. Rep Marshall to the committee report.
And thank you, Madam Chair. Pleasure to serve with you again and again. And I ask for a yes vote.
Are there any discussion to the committee report? Seeing none, the question before us is the adoption of the committee report. All in favor, please say aye. Aye. All opposed, no. The committee report is adopted. To the bill.
Since you
Rep.
all
Marshall.
since you all did the reading last night and know what the bill's about, we'll just give you the Cliff Notes version real quick. So this is a bill that is a kumbaya one because it's the regulators and the regulated love it. They came together. It's like a uniform law code bill that we put through to try and get uniformity across state lines. It makes it a lot easier for the regulators and the regulated to know what the rules are in the various states rather than having to deal with 50 different state rules, that they know what the rules are. It makes it more efficient, so it lets the regulators do more of what they need to do and lets the regulated do more of what they should do. 26 states have already, 16 states have passed it, 10 more are looking at it this session. So I ask for an aye vote, and again, I don't think anyone's opposed.
Is there any further discussion to House Bill 1201? Seeing none, the question before us is the passage of House Bill 1201. All those in favor, please say aye. Aye. All opposed, no. The ayes have it. House Bill 1201 passed. Mr. Shebo, please read House Bill 251169.
House Bill 1169 by Representatives Basenecker and Mabry, also Senators Gonzalez and Exum, concerning the promotion of residential development on qualifying properties.
Rep. Basenecker.
Thank you, Madam Chair. It's an honor to serve with you.
It is an honor to serve with you.
I move House Bill 1169 and the Transportation, Housing, and Local Government Committee report.
To the Housing and Transportation Committee report, Rep. Mabry.
Thank you, Madam Chair. Members, we made a bunch of changes in committee in response to stakeholder feedback. First, we brought an amendment that limited qualifying properties to 5 acres. This was in response to concerns we heard from counties about organizations with hundreds of acres of land that, if developed all at once, could put a strain on government services. 5 acres is about the size of 2 city blocks, and so this amendment helped right-size our policy. We also brought an amendment that limited the policy to jurisdictions that have over 2,000 people. Communities under 2,000 people often do not have the full-time planning or staff or administrative capacity, and they represent just 1.6% of the state's population. This amendment ensures that the legislation applies to 98% of the state while not unintentionally causing a burden on small communities. We also brought an amendment that ensured that local governments can regulate short-term rentals. This was in response to feedback that we received. We brought an amendment clarifying school district construction. School districts currently have a new unique review process for school buildings, and this bill does not alter that process, so this was a clarification amendment on that. Importantly, and one of the amendments that I really want to highlight is the bill as drafted provided very robust protections to enforce Fair Housing Act protections to ensure that there's not discrimination on the basis of religion. We brought an amendment to expand that and clarified that that also includes Colorado Fair Housing Act protections and to include enforcement from the Colorado Civil Rights Division. And then lastly, we brought an amendment that clarified community serving commercial space. It ensured that there would be feasible space for community services in certain developments. It was a clarification request that we brought, and with that, I will pass it to my co-prime sponsor.
Speaker Pro Tem, Rep. Basenecker.
Thank you, Madam Chair. I move L11 to the Transportation, Housing, and Local Government Committee report and ask that it be properly displayed.
The amendment has been moved and properly displayed. Rep. Basenecker to the amendment.
Thank you, Madam Chair. This amendment simply adds some language further clarifying the bill intent through the legislative declaration and how we seek to address the state's housing shortage. It also adds a section making clear that nothing prevents local governments from applying and enforcing regulations related to the health and safety of residents and the environment, including oil and gas setbacks, floodplain regulations, and airport influence areas. It adds language that to the nothing prevents section stating that local governments can use development agreements or other affordable housing policies. This was an amendment requested by our local governments, and we ask for a yes vote.
Are there any further discussion on the amendment? Seeing none, the question before us is the adoption of L011. Those in favor, please say aye.
Aye.
Those opposed, no. The amendment is adopted. To the committee report, Rep. Basenecker.
Thank you, Madam Chair. I move L12 to the Transportation, Housing, and Local Government Committee report and ask that it be properly displayed.
L12 has been moved and properly displayed. Rep. Basenecker to the
Yes.
amendment.
Thank you, Madam Chair. This adds a section clarifying that permitted activities in the bill don't automatically qualify properties for a tax exemption at the local, state, or federal level. This was an amendment request from the Northern Colorado Legislative Alliance that we're happy to include. It also adds language clarifying that height-related standards of contiguous parcels may be used for qualifying properties rather than contiguous zone districts, which may have variable height standards. This was a request from our local governments due to some of the variations inside of the original language. It also adds a section allowing subject jurisdictions to apply minimum dwelling unit per acre requirements as long as they're consistent with similar zoning standards in the jurisdiction. The concern we heard from our counties there was that you might have one house on 5 acres. That's obviously not the intent. We want to make sure that we're building housing in areas where it makes sense and representative of what our counties already enforce in relation to density standards. We'd ask for a yes vote.
Colleagues, please keep it down. I can hear some of you from up here. Is there any further discussion on Amendment L12? Representative Luck.
Thank you, Madam Chair. I apologize, but there was a little bit of noise and I didn't catch. You said something about only one house on 5 acres or something. Can you just clarify that for me?
Representative Basenecker.
Thank you, Madam Chair. Thank you for the question. The way the bill was originally drafted, there was no protection if a developer said, you know what, there's 5 acres of available land here, and our plan is to say to put one house on those 5 acres. I don't think that really fits probably with the congregation's intent at the end of the day, but what we wanted to say at the request of our counties was if you actually wanted to build more dense housing, the county commissioners could influence that decision by saying that one house on 5 acres is not an appropriate use of the tool, and that actually our county commissioners would like to see more density in those projects as opposed to less. So it gives them the flexibility to enforce those minimum density standards, which they already utilize in other development projects.
Are there any further discussion on L12? Seeing none, the question before us is the adoption of Amendment L012 to the Transportation, Housing, and Local Government Report. Seeing none, all in favor, please say aye.
Aye.
All opposed, no. The amendment is adopted. To the committee report, Rep. Basenecker.
Thank you, Madam Chair. I move L15 to the Transportation, Housing, and Local Government Committee report. And ask that it be properly displayed.
L15 has been moved and properly displayed. Rep. Basenecker to the amendment.
Thank you, Madam Chair. And colleagues, I'm going to move an amendment to this amendment. By way of explainer, this is the affordability language that our local governments had been working on in conversation with our affordable housing providers. So I move L18 to amendment L15 and ask that it be properly displayed.
The amendment has been moved and properly displayed to L18. Rep. Basenecker.
Thank you, Madam Chair. And with your indulgence, I'd like to speak to L18, but also as it amends L15, just to give a overall picture of what we're looking to do here through these two amendments so that members can understand why we're amending L15. The amendments basically, in tandem with one another, add a new section that was worked out with affordable housing advocates that specifies affordability requirements for rental units and for sale units. Rental units on qualifying properties must include affordability requirements in the following scenarios. If a local government has an applicable inclusionary zoning ordinance or affordable housing policy, the requirements of the ordinance or policy apply. So that's step one, is that our local governments are well positioned to make those decisions. Step two would be to say if the subject jurisdiction does not have an applicable inclusionary zoning ordinance or affordable housing policy, and the market rate rent in the subject jurisdiction is at or below 120% of the monthly AMI, the residential housing development must align with the local government's demonstrated need and their housing needs assessment as prescribed by Senate Bill 174. The third piece would be to say if the subject jurisdiction does not have an IZ ordinance or affordable housing in place, the market rate rent in the subject jurisdiction is above 120% of AMI, then the development must provide 20% of the dwelling units at rent for renters making 80% or below the AMI, and record a deed restriction or a covenant memorializing those requirements for a period of at least 40 years. For sale units on qualifying properties must include affordability requirements, again, in a very similar fashion. The first line of defense for affordability would be that the local government could utilize their applicable IZ ordinance or affordable housing policies. If they don't have one of those policies in place, then the residential development must provide 20% of the dwelling units for homeowners making 140% or below the AMI and record a deed restriction memorializing those requirements for a period of at least 30 years. So two separate pathways for affordability on the home ownership side, on the rental side, that we've negotiated with our stakeholders who the committee heard asking for these provisions when the bill was in front of the committee.
Rep. Mabry.
Thank you, Madam Chair. Members, I just want to emphasize that for me, this was a critical part of coming to this legislation. I wanted to make sure that any housing that we're building here, there would be some sort of pathway to affordability without us falling into the trap that some other states have fallen into as they've navigated this policy space with being too stringent in their affordability requirements, and then projects didn't actually pencil out and weren't feasible to do. So I think we've threaded the needle well here, and I'm glad that we have gotten our friends in the affordable housing space to a good place on this bill. And I also just want to thank my co-prime sponsor for leading that stakeholding.
Thank you, Representative Mabry. Are there any further discussions? Rep. Brooks. To L18.
Thank you, Madam Chair. You know, I mean, look, I'm here on the well to speak against the bill in general. I wasn't so sure that I needed to speak about the amendments, but the amendments are making what I fear is bad even worse. We're putting AMI regulations on the land. It's not just enough that we say, you know what, let's go ahead and let's tear the lid off of local control, and let's say that we want religious institutions, educational land to be able to build, but it has to be now, we're talking about with these amendments, build within these specific parameters that are now going to be specific to AMI's, area market incomes, and then also to whom you're going to be able to have live there. So, I mean, I understand the intent that they're trying to solve. The intent is to try to get at affordable housing, but yet they're drawing some very strong confinements around this. And this is one that I believe we ought to be paying attention to, and I am going to be in opposition to this amendment. Thank you.
Are there any further discussions to L18? Seeing none, the question before us is the adoption of Amendment L18 to Amendment L15. Seeing none, those in favor, please say aye. Those opposed, no. Amendment L18 to Amendment L15 is adopted. Rep. Basenecker to L15. Are there any further discussions to L15? Seeing none, the question before us is the adoption of Amendment L15. Those in favor say aye.
I apologize, Madam Chair.
Rep. Basenecker?
It's L15 as amended. I just want to make sure we're...
Thank you, Mr. Chair. Is there any further discussion to Amendment L15 as amended? Seeing none, the question before us is the adoption of L15 as amended. Seeing none, those in favor say aye.
Aye.
Those opposed, no. The amendment is adopted. Rep. Basenecker to the committee report. Rep. Richardson.
Thank you, Madam Chair.
Please give us a moment. Thank you.
Yes. All righty. Thank you, Madam Chair. I move Amendment L016 to the committee report and ask that it be displayed.
Thank you, Representative Richardson. The amendment has been moved and displayed. Please do the amendment.
Thank you. This is a simple amendment that recognizes that the bill shortcuts existing zoning and subdivision processes and could very well overburden existing infrastructure, leading to both additional cost burden on existing residents and or lowering the quality of life for all in the area. This amendment would ensure demands on local infrastructure are fully understood, and if inadequate for what the state or we are planning to allow, requires that the state or we find the funding to address the overburden, since if this bill passes, we, the state, are the ones that are overriding the almost universal local policies that ensure development pays for itself. Without this amendment, the bill becomes a huge and indefensible unfunded mandate on local governments, who will then be forced to cut other essential services to address the state-driven shortfall or try to pull more money out of the pockets of our already struggling citizens. So I do urge a yes vote on this amendment.
Are there any further discussion? Representative Mabry.
Thank you, Madam Chair. Members, we urge a no vote on this amendment. And first, I want to note that the bill already provides for local governments being able to enforce infrastructure standards, to be able to consider the impact that a development will have on a locality's infrastructure. That on the printed bill, that section starts on page 6, lines 16 through 27. This is already a part of the administrative review process. What we're trying to do with this bill is make it easier for faith-based institutions and schools to develop affordable housing if they want to. There's no mandate in here, and we're just trying to streamline the process a little bit. It doesn't get rid of an administrative review process. There still is the administrative review, and a one-size-fits-all approach would be onerous and costly for all involved, not to mention potentially duplicative of the already existing local process, which we call out in the bill. So we urge a no vote.
Are there any further discussions? Representative Brooks.
Thank you, Madam Chair. I urge a yes vote on this very sensible amendment. It is attempting at least to draw and retain some sort of ability for local governments to have an input on what's happening within their municipality. It is, and you might hear me speak about this a little bit later as well, constitutionally, Colorado constitutionally protected home rule. And any destruction of that should be problematic to us all. This is just ensuring that, you know, the local municipalities continue to be able to have a say in what's happening in the jurisdiction, in your municipalities. We should all be protecting our municipalities and their ability to have the input to what's happening in their communities. I urge a yes vote.
Thank you, Representative Brooks. Is there any further discussion on Amendment L16? Seeing none, the question before us is the adoption of Amendment L16 to the committee report. Those in favor say aye. Those opposed, no. The amendment failed. To the committee report, Representative Richardson.
Madam Chair, I move Amendment L017 to the committee report and ask that it be displayed.
Thank you, Representative Richardson. The amendment has been displayed and moved. To the amendment.
Thank you. Since the previous amendment was rejected and we seem dead set on passing down unfunded mandates onto our already overburdened local governments and struggling citizens, let's at least do our best to ensure that housing that is generated under this bill be of good quality and projects not get bogged down due to unfamiliarity with best practices for new community development. This amendment recognizes that housing development is not a core competency of school districts and churches. So if we're going to encourage them to become developers, we, the state, owe them some support to ensure that the housing they provide under this bill is developed efficiently and homes built are of high quality and do not become a blight or create ongoing problems for the eventual residents. This amendment would require that DOLA set up some training and technical assistance for those that want to stray outside of their church and their school's core missions and become housing developers. I urge a yes vote.
Are there any further discussion to L17? Representative Basenecker, thank you.
Thank you, Madam Chair. We ask for a no vote on L17. As you read the amendment, I think it's important to clarify that this would both grow the size of the state of Colorado's government. It would also require expenditures from the state level. Curious to be arguing the other side of that with my colleagues. However, I do believe ultimately, because the dollar amount is also not defined in terms of financial resources, we could expect a fiscal note from this amendment that is not defined in terms of scope and focus. I would say that our partners are already working on these resources as well, and you've seen this in other states that have enacted legislation similar, where there's a Know Your Rights guide for congregations, for public schools, public universities. We intend to do the same thing here. We heard from those community partners in committee related to their activities to be able to support our congregations and certainly our public schools and universities with these resources. Ultimately, this is a costly and government-growing amendment, and I would ask for a no vote.
Representative DeGraff.
Thank you, Madam Chair. This is a costly and government-growing bill. So we've just heard. So if we're going to take this amendment and say that it's costly and government-growing, if we pass it down to the state, the county level, what we're saying is we're going to keep this at the. Right now, what it is, it's a unfunded mandate that is being pushed down because somebody is going to pay the price. You either have individuals, you have either these places that are trained and qualified to do this sort of thing, or you are going to pay the price. We don't, I mean, the Pandora's box that this bill opens in general, just by the very, very broad terms of faith-based, everything is technically faith-based. Everybody that owns anything is faith-based. You had a lot of faith just to drive here this morning because you're passing traffic with a closure of 160 miles an hour. So you're a faith-based operator at some level, and there's no constraints on this. So you could buy a mall, and that's faith-based. You could buy a old school property, that's faith-based or school-based or anything based. And now what you have done is you've opened up developers, you've opened up developments, the possibility of developments. Like say you want to just build a trailer park. Well, just make one of those trailers into a chapel, put a little cross on top or anything else you want to put on top, call it a chapel. Now it's a faith-based property, and you can do whatever the heck you want. So if we're not going to have any qualifications, and of course this is all part of, and you know, I'm chagrined to admit that this is a movement that has come out of Colorado Springs, where this has been done one time, and it seems like a good idea. And of course, anything that feels like a good idea, that it has good intentions, of course, then what we do is we take it up to the state level, and then we impose it on the rest of the state with absolutely no meaningful guidelines, no meaningful guide rails. And what this is it's more of an effort from the last year's bill to cram in as much housing into as little space as possible, because humans are tax-paying widgets in the mind of the government. Yes, ma'am.
Can you please get to the amendment? I'm trying to give you as much latitude, but you're not on the amendment. Thank you.
So what we have is this amendment to try to rein in these faith-based organizations to make sure that there is some level of qualification. Make sure that there's some level of qualification for these people to become developers, as opposed to having a trailer in the corner of the property and calling it a church. And then saying, oh, well, by the way, this property is tax-free. We're not going to pay taxes on this property. We're going to put a bunch of houses on it. No real stipulation. Those houses aren't just going to be, they need sewers, they need electricity, they need like all of the stuff. They need to know how to comply. They need to know how to comply with all of the myriad of regulations that this body passes down seemingly on a daily basis, that drives up the cost of housing.
Rep. DeGraff?
Yes, ma'am.
You're still not on the amendment. It's more about technical support. So can you please get back to the amendment you're on? You're talking about the overarching bill, but get to the amendment, please. Thank you.
Thank you. The amendment for technical support is to make sure that all of those things that I just mentioned in relation to this amendment don't happen. You need to have technical support to make sure that these developments are done right. Normally, this technical support is going to come in the form of all of the planning operations that this bill and the fiat zoning. This is more fiat zoning from the bureaucracy of Denver. And what it's doing is it's taking the fiat zoning of Denver bureaucrats and saying, we know better than the market. And so this bill is putting some guidelines in there, this amendment. We want to talk, ma'am, I want to make sure I talk about only the amendment. We want to have these guidelines to make sure that these properties are developed properly. Because you don't just casually run sewer lines and electrical lines and all that. You have setbacks, you have easements, you have all of the same considerations, unless we're just going to waive all those things. And if you waive all those things, then we're just going to have more of the Calcutta zoning that the governor is pushing for across the state. So this is just to put some guardrails on a really, really bad idea of fiat zoning of good intentions. So it's a good amendment. It doesn't make the bill good. It just puts some guardrails on the good intentions so that we don't end up with slums. This bill is about creating slums.
To the amendment, Raf, please. Thank you.
Thank you, ma'am. We want technical support for these developments so we don't create slums as the intent of the bill. Well, it won't be the intent of the bill, it will be the outcome of the bill. No guardrails, no technical support, just people with no expertise cramming their good intentions down the throats of Colorado. So for some level of sanity, for some level of control, for some level of unslumishness of this bill, I think this is a good amendment to at least roll back some of the damage that this bill will do.
Thank you, Rep. DeGraff. Rep. Richardson.
Thank you. I wanted to respond directly to the sponsor's comment that this amendment would add cost. It does, because nothing is free. There is just a universal tenet, I think, if you talk to any local community, county, anybody involved in the oversight of development, that the expectation of our citizens in general is that development pay for itself. if we're not going to make development pay for itself, then we're going to have to pay for it. Somebody has to pay for it. We should not be saddling local governments and the citizens they serve with the added costs that come along with taking controls off of development. It's well-meaning. We do need more housing, but we don't make things cheaper by just shifting cost burdens around. The cost still remains. I still urge a yes vote.
Thank you, Rep. Richardson. Is there any further discussions on L17? Seeing none, the question before us is the adoption of L17 to the committee report. Those in favor say aye. Those opposed, no. The amendment failed. To the committee report. Seeing none, is there any further discussion? Seeing none. The question before us is the adoption of the Transportation, Housing, and Local Government Report to House Bill 1169. Seeing none, those in favor say aye. Those opposed, no. The committee report is adopted. To House Bill 1169, to the bill. Representative Mabry.
Thank you, Madam Chair. So members, I think almost everybody in the room would agree that we have an affordable housing crisis here in the state of Colorado. The cost of housing is too high in our communities. We see evictions close to all-time high for non-payment of rent, and we need to do so much more to address the cost of living and affordability in our communities, and I think that housing is at the heart of that. So many Coloradans are housing cost burdened. That's a measure put out by HUD on how much of your income are you spending on housing. And almost half of Coloradans are housing cost burdened. And so what we're trying to do here is introduce a modest proposal that helps. This doesn't solve the affordable housing crisis. I wish it did. That would be awesome. But it doesn't. It will help. It will give some faith-based institution and schools who want to help address the affordable housing crisis the opportunity to do so by somewhat streamlining the process. That's all this bill does. It somewhat streamlines the process for some faith-based institutions and schools to build housing to help us with our all-of-the-above approach to address housing costs here in the state of Colorado. It's common sense. We've put reasonable guardrails in here to ensure that faith-based institutions that are building housing are following federal and state Fair Housing Act provisions so that there's not discrimination. We put guardrails in here so that localities can consider the impact that this will have on their infrastructure. And I think critically, we've worked with our affordable housing partners to make sure that this isn't going to have an unintended consequence of luxury housing being developed where we all know we don't need new luxury housing. I think that those concerns were a little bit overblown because I'm not sure that churches or schools are chomping at the bit to build luxury housing. But I'm glad that we have stated in this bill that we want certain affordability standards because working people are struggling to get by and keep roofs over their heads, and that is what this legislation is about. And I believe that the impact of this bill will be modest. I think 20, 30, 40 years from now, we're not going to see apartment complexes on every church yard. We're not. That's not how this is going to work out. But some churches are going to step up and build housing and help address the affordable housing crisis in their communities, and that matters. And so for that reason, I'm proud to have been on this bill. I also just want to shout out my co-prime sponsor, Rep. Basenecker. I sat through probably 20 or 30 hours of stakeholder meetings, which means he probably sat through 100 hours of stakeholder meetings because you definitely did about triple the work on this bill. So thank you for your leadership, and I strongly urge a yes vote on this.
Speaker Pro Tem Basenecker.
Thank you, Madam Chair. Thank you to my co-prime. It really has been a team lift on this, and really appreciate the good collaboration that I think has put the bill in the place where it is, where it's one that addresses the affordability requests that we heard in committee. It's one that speaks clearly to an obligation of any institution that uses this process to also abide by the Fair Housing Act, the ADA, and any applicable state and federal law. I want to zoom out a little bit and just give a little more context for why bills like this matter. The state of Colorado has the second worst housing deficit in the United States, meaning we are 100,000 units short. We can talk about how to solve our state's affordable housing crisis. We should talk about that. We should debate that. But bottom line, we need more housing for the folks in our state. This is a vital link between housing folks in our community who wish to downsize, giving opportunities for home ownership for the first time for some folks in our communities who might never have thought that possible, and also making sure that our communities can sustain the types of workforces we know our businesses need to thrive here in the state of Colorado. This is teamwork in play. Now, I understand that there's always going to be tension between local control and statewide action. However, this bill recognizes fully, and you'll see this throughout the first couple pages of the bill, that housing is a mixture of statewide and local concern, meaning that what one jurisdiction does might be well-intended, but it doesn't stop at those jurisdictional boundaries. It has ripple effects out into the community. I have nothing but good things to say about the way that our affordable housing crisis continues to be engaged with by our local governments. I firmly believe that they also want to solve this. This is a way that the state can also help. And I want to give you an example in my community by way of how this matters. Heartside Hill is a project in my community that faced 8 to 10 months of delay. And what this project ultimately was doing was building multifamily and single-family homes in conversation with and in partnership with a congregation that had land to offer. Those delays ultimately jeopardized the project several times, increased cost, and would have meant a lack of housing for folks with disabilities who require a live-in caregiver or a family member. It would have jeopardized childcare services on site. It would have jeopardized multifamily housing that is deeply affordable. We know that the primary cost driver in affordable housing is land acquisition. And if we're able to partner in a mission-based way with a congregation that's willing to come to the table and say, we can't solve this by ourselves, but we know we have something to offer to this problem that can help, and that is land, or a public school that wishes to house students in their communities because ultimately our students can't access the schools they want because they can't afford housing in those neighborhoods. This is an incredibly powerful way to say that the state can provide some help here, partner with those institutions, and also solve this at a local level by using local affordability in a very meaningful way. That is what the intent of the bill is. There are over 5,000 acres of underdeveloped or undeveloped land in the Denver metro area alone. Some of those lots have been sitting empty for 70+ years. As we try to solve our state's affordable housing crisis, we have to look for opportunities where the process ultimately has dictated an outcome that is not in line with the expectations of our communities, and that is that we fix this affordable housing crisis in our state. This is one way we seek to do it. I think it is, as my co-prime said, a modest solution, but when it matters, it matters. And when you have a congregation or a school that's willing to come to the table and offer a resource in a meaningful way, let us not get in the way of that. Let's align mission with intent with need in our communities in a way that ultimately works to solve this problem. And so I would urge a yes vote on the bill. I think ultimately the bill accommodates for a lot of the feedback we have heard. You see that through the multitude of amendments we've even run today. We are not done with our work on this bill, but it does present a meaningful and I think important step forward in recognizing ways that we can gain on our state's affordable housing crisis. We'd ask for a yes vote.
Thank you, Representative Basenecker. Any further discussion? Representative Richardson.
Thank you, Madam Chair. The issue does exist. We do have a shortage of housing in the state. It was mentioned by the sponsor just now, we're 100,000 units short. But why are we short? The government doesn't generally build housing, the free market does, but we've been interfering with the market for so long that it cannot provide what citizens need. Co-sponsor, or Mr. Mabry, Representative Mabry, said we can do so much more. I'd ask, haven't we done enough? I rise today with a resounding no on House Bill 1169. The bill represents yet another misguided attempt to solve a complex issue, our housing crisis, by stripping away local control, ignoring market realities, and adding yet another layer of top-down government overreach. Enough is enough. It's time to stop pretending that state legislators and bureaucrats know more about how to develop land than the people who actually are involved in the planning and development at a local level. For years now, we've seen continued attacks on local control, and this bill is yet another step in that direction. It forces communities to accept housing developments on land owned by religious institutions and schools without regard for existing zoning laws, infrastructure capacity, or community needs. They've said otherwise, but the intent is clear. It assumes that a one-size-fits-all state mandate is superior to thoughtful, deliberate planning that happens at the local level by people who actually live in the communities and understand their unique challenges. So let's be clear about something. The housing shortfall in Colorado is not because of a lack of government mandates. Nothing has come out of this building in the past 5 years that's measurably reduced the cost or increased the availability of homes. In fact, everything we've done and passed has done the opposite. We've seen bill after bill that adds new requirements, fees, restrictions, and mandates that make it harder, not easier, to build homes that people can afford. The bill doesn't fix problems, it makes them worse. By overriding local zoning laws, it can create chaos in our planning and development processes. It allows multi-story housing developments to pop up on properties that were never intended for residential use, without regard for infrastructure needed to support them. Roads, water, sewer, schools, emergency services. None of these things magically appear because the state says, build here. That's why local governments carefully plan development based on what their communities can support. And let's talk a little bit about fairness. Why should religious organizations and schools get special privileges? Why should their privileges be greater than private landowners when they don't get this dispensation? If we truly want to increase the housing supply, why not get rid of all the red tape that is claimed to exist that prevents all property owners from building anything they want at any density anywhere? Why not let the market, completely supported by local governments that know their citizens' concern best, work through this problem? Instead, this bill picks winners and losers. It creates arbitrary carve-outs that distort the market rather than freeing it. Housing development should not be dictate of the whims of the state lawmakers who are disconnected from the realities of the ground on local governments. We're not disconnected from those we serve, but we are certainly disconnected from the processes that take place within local governments that have evolved over many years. They can always be better, but we shouldn't be trying to make them worse. This should be driven by local leaders, planners, by builders, by the very people who understand their community needs. The notion that a small group of legislators in this building knows better than every city council, every county commission, every planning board across the state is just absurd, and it needs to stop. If we truly want to address our housing crisis, we need to get serious about removing barriers that prevent housing from being built in the first place. This means rolling back excessive regulations that mandate cost drive-ups. I know this bill claims to be taking off some of that red tape, but it does in such an uneven and ungainly manner that it really makes things worse. This means letting builders build and letting communities plan responsibly. It means recognizing that government interference is the problem, not the solution. This bill is a step in the wrong direction. It ignores core issues, tramples on local control, continues the failed policies that have done nothing but make housing more expensive and harder to find. We need to stop pretending that more government intervention from the state level will fix what government intervention has already broken. I urge my colleagues to stand with local communities, stand with the people who actually know how to develop land, and vote no on this bill. Thank you.
Thank you, Representative Richardson. Representative Brooks.
Thank you, Madam Chair. You know, in many ways, I was taking a lot of notes. Thank you. So in some ways, I'm not exactly sure where to start, but I think it's probably more accurate that I don't know where we end. You know, this is yet another attempt, and I get it. I can go very high level, say it's yet another attempt to just erode local control. That argument has obviously fallen on deaf ears because it continues to happen with impunity, and we're not too terribly concerned about that. So I'll try a little bit of a different track. You know, some examples were given, and I appreciate the examples were given specifically in one of the bill sponsors' areas, in the bill sponsors' community. They had this difficulty, 90 days, 9 months. I forget what it was. It was 9 months. It was an excessive delay, and that's not right. And that's not right. And that's unfortunate. But you know, why do we need to then say this is a state problem? Is that not a problem for an individual community? Is it not a problem for the individual community to fix? Why is this a state issue? Why is this something that we say because it was an example or a problem that can be shown as an example in a few different communities, that now this is something that we need to fix at the state level, and we need to fix this so that that way there's no local control, there's no local zoning. There is a constitutional protection, the Colorado Constitution, for home rule. We have elected officials. Many of you served locally first. I'm getting a couple of head shakes. I know not everybody served locally, but there are a lot of people that did serve locally. And you know, and at least I would imagine that you know somebody who serves locally. They have a job to do. They're elected. They are the grassroots of our community. They are the ones that are most responsible for ensuring our communities are functioning the way that they're supposed to be. And if they're not, well then, let's press on them. Let's get them out of office. Let's get somebody in there who understands that there is an expediency that we need to look at when it comes to these things. We can absolutely have members of this body serve in 2 different roles. We can change the charters to allow people to serve in 2 different roles to make sure that we're fixing things at the local level. Well, it doesn't need to be fixed here. It's the wrong answer. We don't know what the schools are going to do with their property. To say that the schools can build housing that will be used for kids to be able to access the schools. Well, first of all, there's not going to be a school there because there's going to be multifamily housing in that area, right? So we don't know that that's what it's going to be used for. We're not saying that that's what it's going to be used for. I know that there are some AMI area or area medium income kickers in this to ensure that they're affordable units, but we don't know to whom those are going to be rented or sold. There are multiple problems with it. At the high level, it's erosion of local control. This is 213, embodiment 213, coming back in bite-sized little Snickers, you know, the little ones you get. You're always bummed about getting those, you know, at Halloween. You want the full candy bar. This is just a little piece, 213, coming back into a little piece of erosion of local control. Little bite-sized, more easily digestible erosion of local control. It still is not particularly appetizing to me. So I have served, I was a local government elected official. I still actually serve on Castle Rock Town Council. My district, House District 45, is primarily Castle Rock. It's Pradera and South Pinery. But the municipality that I serve is Castle Rock. Castle Rock stands in opposition to this bill. Castle Rock has stood in opposition to any attempt to erode local control. As a member of Castle Rock Town Council, I have been proud
Rep.
to
Brooks,
serve.
can you give me a moment, please? Members, I can hear you from up here, so please keep it down. Thank you.
Madam Chair, thank you. I appreciate you ensuring that everybody has their attention on this very emotional and very important speech that I'm giving here. So thank you.
You're welcome.
I served on the Douglas County Housing Partnership. I still serve on the Douglas County Housing Partnership. The Douglas County Housing Partnership is all about affordability, trying to bring affordability to Douglas County. We have local solutions. Actually, I'll be honest with you. It was not my intention to serve on the Douglas County Housing Partnership. It kind of ended up happening on accident, and it has been far and away the most rewarding position that I have served on as a member of Castle Rock Town Council. To be able to work locally on the affordability crisis, I understand that there is an affordable housing problem. We've had the opportunity to solve it here, but there are very powerful lobby groups that keep strangling the life out of those ideas to try to fix the middle housing, to try to fix condo construction. We've been trying to fix that, so it does seem a little disingenuous to me that we can say that we've got such a terrible affordable housing crisis that we need to solve by saying municipalities can't say anymore what is best for their communities because we haven't been able to figure out how to address the middle housing piece. We haven't been able to figure out how to tell a powerful lobby group, no, we need to fix this for all of Colorado. It's back again. You're going to hear about it again, and I hope that it passes finally because we need to get that passed. This is not the answer. Douglas County Housing Partnership does a fantastic job in working locally to ensure that affordable housing is being built. We opted in as a county, all of Douglas County opted in collectively to Proposition 123. Proposition 123 provides an incentive for municipalities, or as we have, all of Douglas County as a group, to hit a number over the course of 3 years for affordable housing units, and then you receive a financial stipend back from the state for having hit that threshold. It provides an incentive to build affordable housing. Douglas County is going to meet that need. Douglas County is going to exceed the number, easily exceed the number over the 3 years. We are providing affordable housing solutions for our community. We are doing the right thing. We do not need to be told by us here under a one-size-fits-all, which is not true. We don't need to be told that a one-size-fits-all approach is the right thing to do at the state level. A quote from the bill sponsor, "You're not done on this bill." Well, let's get it back to committee. I know that's not an idea that anybody is going to support, but why does something that you're not done with to come forward if there's still work yet to be done? You know, earlier today, our prayer that we heard before the Pledge of Allegiance mentioned that the Padre mentioned that they hope that there could be guidance given to those who have not yet decided on something, that are not yet decided, resolute in their minds on a specific item. You know as well as I do, that was that day. I wish I could take that little piece of that prayer straight to everybody's hearts, to God's ears, because I think we know all too well that everybody's mind is already made up. The most passionate, the most reasonable, the most sensible, the most logical words that I can speak here, and they all are, just pretty much falls on deaf ears because we've all made up our mind already. It's coming from that side. Let's go ahead and push it through.
To the bill, please. Thank you.
I'm sorry?
To the bill, please. Thank you.
Yes, ma'am. To the bill. I don't like the bill. And I would encourage a no vote on the bill. This circumvents any sort of public input. If we're not allowing the processes that local government provides, our own residents, our own citizens, hello, voters, are not going to be able to come out and speak against something, speak for something that is right for their community. We're saying that the solution is better made here, that we don't even care what our constituents have to say. In Castle Rock, we have a minimum of 3 neighborhood meetings that are required for every development process, 3. From there, we go to a public process to where it goes to a planning commission. The planning commission is volunteer members. They will make a recommendation. From there, it goes to a town council. All along the way, there is an opportunity for public input. There is an opportunity for the public to come out and say that they do not like something or they do support something. We are circumventing that completely. We're telling them, you know what, we've got the answers here. We know how to do it better than you do, but yeah, by the way, will you vote for me again when my term comes up? Why would we ask for people's votes if we're not listening to them? Why would we take away the very process by which they can express their concern or support and then go back and say, yeah, you know what, send me back up here for another couple of years?
Representative Brooks, please,
Yes.
to House Bill 251169. Thank you.
Yes, ma'am. House Bill 251169. We're talking about removing all local control. Home rule municipalities cannot override state rules on the right to counsel, sentencing limits. Oh, actually, that's 1147. I have something to say about that one, too. The bill erodes local control completely in favor of property rights and affordable housing. There's two also distinct different pieces of this, right? There is the piece that is for religious land. Let's let religious institutions build where they wish to build. In Castle Rock right now, there is actually a church. It's called the Rock Church. They want to build a multifamily housing development right there on their land. It's a gorgeous piece of land. It's huge. Yeah, I think it's like something like 80 acres, and the church is only a little piece of it. They've got all this beautiful land all around it, and they want to build multifamily housing. Now, I'm going to be perfectly honest with you. I understand the mission. I understand the calling. I understand his vision. It is the wrong place to do it because it is surrounded completely by single-family housing. If I had $1 every time that I was in a council meeting and somebody came up and said, hey, you know what, if you do this, if you approve this antenna, this cell phone relay thing, it's going to drive our property values down. Now, that's not necessarily always true. However, I'm telling you that if you drop multifamily housing in an area that was already zoned for single-family housing, you are destroying the very fabric of that neighborhood. You are eroding at the very cornerstone of people's personal financial stability. We are eroding at the single-family unit, the single-family neighborhood. You're talking about multifamily housing in single-family neighborhoods. It doesn't match. Municipalities take great pains to ensure that density is feathered and density is matching as you move from one area to another. There's a very specific plan for that. This erodes completely, throws it in the trash, that plan. We need to stick to that plan. It has been successful. The other piece of it, let's go ahead and get away from the religious part of it. Let's go ahead and get away from the yes in God's backyard part of it. The other part that I would wish could be considered is for the educational land. We have a lot of work to do in front of us with the long bill. We know that we're still-ish $600 million to $1 billion shy in where we need to be. We've got a lot of work to do there. The number keeps growing. I just got the ticker update. It's even bigger. It's a problem, and it's going to require a lot of work to fix. Here is where the educational land becomes very problematic. We are in the process, and by the end of the time that we get to balancing the long bill, we will have put a hurting, if not an evisceration, on K through 12 funding. I believe that that's very intentional, that if we erode K through 12 funding at the state, you know what happens is that they end up with MLOs, they end up with all of the different little pieces that we can fix at the county level. We have shown in Douglas County through ballot measures the last couple of election cycles that we are willing to try to fix the shortcomings of the state in funding our school district. So we can just fund it locally, right? At some point, we're not able to do that anymore. At some point, when we have to cut K through 12 education to the point where it's not just to the bone, but the marrow is exposed, we are going to leave school districts in a very bad financial position. What they're going to be left with is to have to sell their property. When they sell their property, it's going to go to the highest bidder. That highest bidder may then very well, in turn, decide to maximize their profits to build the highest density property that they're allowed. In Castle Rock, there are nearly 24 parcels of land, and it's an automatic piece, right? You have a development, we set aside land for a future school. School districts aren't building schools anymore, man. They don't get the money to build the schools. They're not going to be building schools, so school districts are sitting on parcels of land that they are going to be forced through being in a financially untenable position to have to sell those pieces of land to the highest bidder, and then we have yet again another opportunity for multifamily housing in a single-family neighborhood. You have them all in your areas. As you drive through your communities, you all have future school use dedications for school districts. They're not going to build schools there, folks. This passes, they're going to be building multifamily housing there. If you don't think that's a problem in your community, well then, go ahead and wait. One of the bill sponsors said, you know what? I believe that this won't be that. To look at the long-term implications. I understand that we have an affordable housing crisis in this state. I understand that the intent here is to try to fix it. I also understand that this is.
That's when the pre-application meeting request was sent based on Church of the Rock's development plan to allow for additional uses in my colleague's district. November 2nd, 2023, you might notice that that's a bit ago, and the implication and the timeline for developing housing with a 2 to 3 year timeline is ultimately a deal killer. That's what can sink affordable housing proposals in our districts. Now, I want to also recognize something my colleague mentioned, which is that this is single-family zoning. And the line I took down in particular to building multifamily in these areas was that it would destroy the fabric of the neighborhood. That building multifamily where there are single-family homes would destroy the fabric of the neighborhood. I want to tell you a little bit more about the people that Church of the Rock seeks to house with their development. And I want to ask you, candidly, if this is destroying the fabric of our neighborhoods. To house seniors, older adults, destroys the fabric of our neighborhoods. To house people with disabilities, destroys the fabric of our neighborhoods. To provide workforce housing for folks we desperately need, destroys the fabric of our neighborhoods. To provide community services, food storage, gardens, recreation, and parking, to provide housing options that include guest suites for short-term stays, assisted living, destroys the fabric of our neighborhoods. That is the headwinds that projects in this space face. Since 2023, this congregation in my colleague's district has been trying to do this work on behalf of its community, recognizing that for so many, congregations are already perceived to be the social safety net when it comes to food, when it comes to housing the unhoused, when it comes to providing transit and bus passes. That's been the expectation of our congregations for a very long time. And here we have a congregation that is willing to offer up land to house seniors, to provide workforce housing, to provide housing for folks with disabilities, to provide community spaces. And somehow, the notion isn't that this is an issue because, oh my gosh, we have to solve this affordable housing crisis. The takeaway that I have is that this would destroy the fabric of our neighborhoods. Colleagues, I reject that. That is why this bill exists. I ask for a yes vote.
Thank you, Rep. Basenecker. Rep. Sukla?
Thank you, Madam Chair.
Thank you.
I'm going to read the bill, the title of the bill, Housing Developments on Faith and Educational Lands. And I would like to talk about the educational land parts. So in the state of Colorado, we are made up of townships. And in every township is 36 sections. And in every section, the 36th section is state trust lands. And those lands were set aside when we did the Colorado Constitution for schools and for schools only. A section is 640 acres. 640 acres. There is school lands in Denver. There is school lands on the eastern slope. There is school lands on the western slope. So if you was to add up those 640 acres throughout the state of Colorado, we are talking about tens of thousands of acres of land. My concern from rural Colorado is we are now taking those thousands, tens of thousand acres of lands that were designated with the Colorado Constitution for the future of our schools, and now we are going to possibly turn them into a housing development. That's my concern. Thank you.
Thank you, Representative Sukla. Representative DeGraff. And then Representative Bottoms. Thank you.
Thank you, Madam Chair, and to my colleague for not paying attention so I could come up. Oh, sorry. All right. One thing I don't see, one thing my colleague mentioned before it was turned into an emotive cudgel by the by the bill sponsor about the fabric of a single-family neighborhood. The fabric of a single-family neighborhood is the fact that it's single-family and it's a matter of density. Neighborhoods already are made up of a broad spectrum of people, and I think that's an appeal. But there is an aspect of density. And when people signed a contract with the state, with the city, with the county, it was for, if you signed up for single family. Now, I get it that this body has a real desire to go back to the feudal society with the abolition of private property, because somehow they think that would be equitable in creating everybody into a tax-paying widget/slave. This is part of that movement, to eliminate property. So it's not a matter of the individuals that will leave there, but I do notice going through the bill, I did not see that there was any specifications that these were seniors, old adults, folks with disabilities, workforce. What assurances are there in this bill for that, other than the sponsor's a motive cudgel? None. Let's say the church decides to, next to the school, decides to reach out and become a rehab facility for sexual offenders. Is that okay? There's nothing in there. So this continual appeal that it's going to help veterans and small disabled mammals is really just saying you lack the arguments. And this is a end run around local zoning. This is zoning by Denver bureaucrats. This is zoning, and the idea that this room that has created unaffordable housing is going to solve affordable housing is really laughable. We're going to take the abject lack of market knowledge and lack of development into and just apply it. Because your ideas don't work, the solution is to apply them more broadly and put a barrel of a gun behind them. It's always the solution. Yes, ma'am.
Please stick to 1169.
We're sticking to 1169. So we talk about property that's been open for 70 years. Why has it been open for 70 years? Because the city has plans, possibly. When land was cheap, they thought ahead and they said, hey, we should set aside this parcel of land so we have a place to build a school when we need one. Now what this body wants to do in its brilliant analysis and foul up the market beyond anything recognizable is then put housing on that. So now when the Denver needs a school, or these other, well, usually it's for Denver, when the other municipalities need a school, where are they going to put it? Are you going to go through and you're going to say, now we're going to evict everybody on that property? How's that going to go? If the city doesn't need that property, sell it. Just sell it. Now, the big advantage here, and I'm not sure it's an advantage talking about the tax law because how that's going to work, but overall, this property, maybe not the income from the property, and somebody will be able to, Rep. Bottoms will be able to explain that a little bit better, obviously, but the property will be tax-free. So if you need to make property affordable by making it tax-free, here's an idea. Wyoming just did this. Wyoming just cut their property by half.
Rep. DeGraff, to
Yes, ma'am.
1169, please.
Yes, ma'am. This bill purports to create affordable housing. There are ways to create affordable housing that do not involve fouling up the market beyond anything recognizable, like this bill does. And I would encourage this body to actually look at what it does. Why has this body made unaffordable housing unaffordable, and then comes in with a solution to bad legislation to be worse legislation? Now, one thing this bill will solve is the religiosity of Colorado. It will solve that. Now, the sponsors did mention
All righty, Rep. DeGraff.
I'm speaking to the bill. Ma'am, I just thought you couldn't hear me, so I wanted to wait until you could hear me.
Thank you, Rep. DeGraff.
You bet. It's my pleasure.
You're welcome to
Now,
move forward.
not every church is going, I agree, not every church is going to go down this path with development, but I will be really surprised if every development doesn't become a church. If I had a development, if I was a developer, I'd put a chapel in every corner. I'd put a trailer in every corner. Never, and now all of a sudden everybody, and what's the advantage of that? Oh, now that property is tax-free. Why don't we just make the property tax-free? If you want tax-free property, this room can make tax-free property. Our government can make property tax-free. Now, here's a crazy thing that you'd actually have to do to start making property affordable, to make property tax-free, is you'd have to stop spending money. I know that's not on the table. That is definitely not on the table in this room. The only ideas that come out of this room are digging deeper into the pockets of citizens. If you got property open there 70 years, sell it. That's part of fiscal responsibility. So yeah, I see the purpose of this bill. Something like this is to destroy single-family neighborhoods, just like ADUs, just like making properties no limit occupancy, no definition of family. It's all to destroy the idea of private property because that's what Bolsheviks do. Now, the sponsor talked about a November 2023 meeting, and I guess everybody was supposed to know about that to be able to go to appeal this decision. I'm not sure why this conversation is happening right here, but it is. 2 to 3 year timeline. I don't want to interrupt.
Rep.
wait.
DeGraff, please, no, go ahead.
Well, ma'am, I'm afraid I'd be interrupting this conversation right here in front of me. This one? Yeah, this one, right here.
Rep. DeGraff, please, to the bill.
It's just kind of distracting, that's all. 2 to 3 year timeline. You know who can fix that 2 to 3 year timeline that the government created? The government. Who's not interested in fixing that 2 to 3 year timeline? The government. And so instead of fixing the problem that you create a new problem. And you compound it. Now, the sponsor mentioned that we have like 100,000 units that are outstanding. Like, we're missing 100,000 units. And that is blatantly wrong. I don't know where those numbers are pulled out of, but it's not facts. They're pulled out of somewhere. We had a 40,000 unit surplus in Colorado. And when they do these analysis and say all of a sudden that we're short of housing, the people that want to develop these, the people that are going to be making churches across the state, we're going to have churches popping up across the state, every corner of every parking lot, some little mini home, little chapel in the corner. All to circumvent property tax, because why? Why are rents going up high, Colorado? Well, big reason your rents are going up are property tax. because taxpayers are a bottomless pit, industrial tax widgets are seen by this body as a bottomless pit of money. When this body needs more money, what do? Go to the taxpayer.
To the bill, Rep. DeGraff. Thank you.
We're talking about affordable housing, ma'am, and how to create it.
To the bill, 1169.
All right, but the sponsor mentioned a 2 to 3 year timeline. This body could help reduce that. How? By reducing regulation. Is it going to happen? No. Why? Because the goal of this bill, the goal of those, is to eliminate private property, the abolition of private property, number one on Uncle Carl's list. There's nothing in this bill that says about who's going to be housed in these, or how many, what the zoning is. It's not part of the consideration. The consideration is this, the consideration goes as far as we feel good about this, therefore we need a law. We're going to take it. We are so confident that what we need to do is we're going to take our idea, our good intention, all the way to the State House and have it imposed on all of Colorado because it is such a good idea. Has it been tried? We had a November 2, 2023. So where are we? On a 2 to 3 year timeline. We're inside of 2 years. So what's the result of this housing area? What's happened with it? Oh, we don't know because it hasn't been done yet. What are the ramifications of it? We don't know. So, like any other bad idea in this body, the impetus behind it is to push it as fast as possible before the results catch up with the reality, before reality catches up with the intentions. Just go as fast as possible. We're going in the wrong direction, but we're making good time. That is this bill. If you want to make affordable housing, cut property tax, cut energy rates. Everything this body does is driving up the cost of energy, driving up the cost of regulation. What have we done? Are all of these homes going to be handicap accessible? Are we going to add that cost to them? Are they going to be WUI compliant, Wildlife Urban Interface compliant? Are they all going to have EV stations out front? Are they all going to have a plug-in for their EV? Oh yeah, those monies are going to dry up, fortunately, because that fraud pool has been found. Where this body can actually make cuts, make a difference, it has absolutely no intent to do so. Now, paying attention to good ideas also not. I mean, we did start, it is ironic that we started off the year with things that had to be fixed because there was no appetite to pay attention to the amendments. Again, what's going to happen? You pass this bill, I think a shed with a steeple on the top of it is going to show up in the front of every development and they're going to claim to be a 501(c)(3). Every developer is going to become a pastor, going to go online and get themselves certified. That's all you need to do. You're a religious organization. Boom, done. And that'll kind of be a great thing. And then the property tax is going to go down, the schools are going to take a hit, and then what's the solution going to be to the bad idea that caused it all? Oh yeah, you'll blame Tabor. If you want these places to be more affordable and have less property tax, get rid of the property tax. Easy as that. Just get rid of it. That's what this is intended to do, is to circumvent that. This body created the unaffordable housing crisis. And what is affordable housing? When you look at the cost burdened is if your housing is somewhere around 50%. Well, how did this body help that last year? Well, affordable housing that has absolutely nothing to do with income level, because affordable housing is not low-income housing. It just means it's less than a third. So you can build affordable housing that is luxury housing. You just have to appeal to the market that can afford that housing with less than a third of their income. That's it. Does this solve the problem? No, it's not intended to solve the problem. It's intended to prop up the developers that paid for this bill. So what did we do last year? What did we, as in, when I say we, I mean you. What did you do last year, or maybe the year before? Groundhog's Days all kind of run together. I think it's 2025. Anyways, there was a motion, and it passed, that landlords could no longer demand to see that your income was 3 times what the rent would cost.
Rep. DeGraff, can you please get to residential development on qualifying properties, please, and thank you.
Yes, ma'am, but the sponsor himself referenced the affordable housing crisis and the housing burden as the reason.
As it relates to 1169, please and thank you.
The General Assembly finds and declares that Coloradans are overwhelmingly burdened with the cost of housing. 45% of renters spent 30% of their income on rent in order to afford a median rent of $1,700. So we are talking about really the qualifiers. We're talking about the heart of the bill. $70,000. Further, to purchase a median-priced home in Colorado with a 20% down payment without being cost burdened. So the cost burdened is in here, so cost burdened is going to be around 50%. And what happened when that passed, when you said no longer can a landlord require a verification of 3 times rent, it can only be 2 times. What that gave the renters, what that gave the landlords to help was an immediate bump from being able to charge an average rent of 33% of the market to an average of 50% of the market. So you go from 33% to 55%. That's a 50% increase. Boom, done right then. So that good intention jacked up the rent prices by 50%. Just like making these properties, trying to say that these single-family housing, turning it into multifamily is going to save money. No, it just drives up the rent. And it makes it less affordable. And when you have less affordable, based on based on really bad decisions made out of this General Assembly, the solution is to go back and make worse decisions and then bring a bill like 1169 to the floor. Every single time. The solution to bad legislation is worse legislation, every single time. And the way you pass bad legislation is you wrap it up in some emotion. You put an emotive hook on it, and this room will swallow it to the sinker every single time. Every single time. And that is to the bill. We're going to make an Affordable Housing Act. We're going to make it ADA compliant. We're going to do all these wonderful things. But we're going to make it temporary because it's not on land that was zoned for it. This bill is a slumlord dream. I think maybe we should call it the Slumlord Dream Act. I think maybe I'll do an amendment. I'm sorry, Madam Majority Leader. But all I can go back to is when the outcome is evident, the intent is inferred. And if you're going to do something that has the predictable result of creating slums, of defunding our schools, of turning every development into a church with a shed with a steeple, don't think I'm the only one that thought of that. You know how you decrease the delays in a housing project? You get rid of regulation. Those regulations we know cost $25,000 more on the house. That also makes it less affordable. So you decrease all this excessive regulation, all of the good intentions that come out of this room. You decrease those, you decrease costs. You decrease costs, you decrease the time frame to get these projects done. You increase the availability of housing, and when you increase the availability of housing, you have a higher supply for the same demand, and there's this Econ 101 thing where you have the supply and demand, so you create more of a supply for the same demand, and the price goes down. So the solution is obvious. I mean, it's obvious to anybody that has an understanding of free market. That's not this room. So here we are. I mean, the only way to get out of these bad ideas is for litigation. That's another tax on the citizens of Colorado. A bad idea tax that's imposed on the citizens of Colorado to try to get outside of bad legislation like this that's going to lead to worse legislation, which at some point it's hard to believe that they could get worse legislation. But I understand you bring it forward. This is a bill for the developers. You put a pastor on it. You put an emotive hook on it.
Rep DeGraff, I'm sorry. You're impugning motives, and that's offensive, Rep DeGraff.
Ma'am, I don't know why the motive. I'm not speaking to the motive. I'm speaking to the outcome of a bill like this and how it gets to this point.
Please stick to the bill and be respectful of your colleagues. Thank you.
I feel disrespected by this bill. My community feels disrespected by this bill. We used to have this thing called home rule. We used to have a government that recognized that maybe one-size-fits-all solutions from a group of individuals not qualified to make those decisions is a better way to handle the market. That way, if you have a bad idea, it affects one community. Instead of imposing, but now we've just gone varsity, and we're going to impose bad ideas at the state level. And the only way to escape state-level bad decisions is to leave, which I'm not sure. Is that the motive? I don't know. But if you can't look beyond the first-order good intentions, then at least have the respect for your colleagues not to turn something into an emotional cudgel in order to justify the bad decisions. The outcome of this bill is obvious. It's an erosion of private property rights. It's a denigration of local rule, of home rule, of individual sovereignty, of local sovereignty. It's a further creation of a feudal society in Colorado because the Bolsheviks in the room think that's a great idea. I ask a no vote on this bill to save Colorado from these really, really well-intentioned bad ideas.
Thank you, Rep DeGraff. Rep Bottoms.
Thank you, Madam Chair. So I'm a subject matter expert on this in a few different ways. I was actually kind of leaning toward this bill, and I don't know if I actually told the sponsor this, but I was leaning toward this. I did an interview about this saying I kind of would like it, but it needs to be amended a little bit. And then today it was amended, so I'm strongly against it. But here's some reality. So I'm involved in this right now. One is I'm an active CEO of a active 501c3, faith-based organization that has property. That's one way that I'm involved in this conversation. The second way I'm involved in this conversation is that we have been for a year and a half, a little bit more than that, our church has been in the process of changing zoning so that we can sell a piece of our property. When we did this,
And this is why there is the bill, and then there is the verbalization from the sponsors that are not actually matching up to what the bill does, what actually is law, and then what they're verbalizing. When we started this process, we started getting bombarded by the city planners in Colorado Springs to build low-income, high-density housing. I have emails to prove this. I have that they were very pressured. You need to do this. And we kept saying, no, that's not what we're going to do. Well, you need to do this. This is what this is about. You need to do this. Well, it's still our property, and we can still choose. Now, here's an interesting thing about this, because the Bible actually says that we as a church have some obligation to the community in certain ways. And here's the starting line for that conversation. It's straight out of the Bible, that we're supposed to take care of the widows and the orphans. So a church says, we need to take care of the widows and the orphans, so let's put some housing on our property. Except that once they put the housing on the property, they cannot put widows and orphans in there. They can only allow whoever else wants to go in there by the pressure from all outside entities. And I know this because we've just been having this conversation for a year and a half. In fact, what happened was, because you have to post all this stuff, we posted this, and so then there was a town meeting, a community meeting about our rezoning in our church. About 200 people showed up, and I think one of them was happy. And the rest were extremely unhappy about this conversation. And so we explained to them that the city had been pressuring us to put high-density housing, like apartment complex and things like that. Now, we're right across I-25 from the Air Force Academy, so we have height restrictions. You can only go so high because planes run into things. And so we were already limited with that, and we had already told the city we are not going to put housing on this property. All of the people showed up and were upset because we were going to put housing on our property. And we explained, we've already told the city we're not going to put housing. So then they got upset because, and I'm not making this up, this is exactly the quotes that were said multiple times, where you're just going to put porn shops and marijuana shops. We sit across the road from a school, and we are a church. You cannot put either one of those things anywhere near those two organizations. It's the law. Now, we try to explain to the community. So here's where it comes to this bill, this vote, specifically for me. Now, time-wise, this bill will be irrelevant to me, but if, for some reason, we were just starting the process, it would behoove me to vote yes on this bill. Because then we could look back at the community and say, you pound sand, we can do whatever we want. But what we did as a church is we listened to all the stuff. We had meetings with people in our community and said, what would you be okay with us having and what would you not? Because we want to sell it so that we can build our church building, because we grew out of that years ago. And all of the rules that come out of this house have made it almost impossible for us the last 5 years to build. Every year we try to build, another 10 regulations come out of this room, and it stops us from building our church building. Another 10 regulations stops us building. So we're trying to sell the property to build our church building. The city is pressuring us to do what this bill theoretically says that you're going to do. The problem is this bill will not do this. These churches will have no authority whatsoever on this, and we know because the city explained this to us at the public meeting that once we sell this, we have very little control over who, if we put housing, which we're not, who could go into that housing. So we would not be able to help the widows and the orphans. We would have to help whoever the city decided could go into there, or whatever laws come out of this building that says you have to let these people go in there. Oh, and then, by the way, with all of the other things that we've done over the last 3 or 4 years in here, they don't have to pay rent for months. They don't have to give any background stuff. So how are these churches going to make sure that they can actually pay for this stuff? The answer is they can't, and the building that is trying to make this law has already made it impossible for this law to actually be enacted in such a way that it will not destroy the church in the process, unless that church/religious organization is a scam from the beginning, and then it all will work just fine. So here's the other side of this. We tried as hard as we could to do this. It's still pending. The sponsor said earlier that this property group that he was talking about, church, that they had taken 10 months to do this. And because of I'm assuming, and he can answer this or change it or whatever, I'm assuming that actually the 10 months, they actually got the process done. Because he kept saying it would have stopped it, it would have hindered it. Here's the thing, ask any builder, you guys all have builders in your district, ask any builder with all of the regulations that we have run through this house, all of the threatening things that shut down business, that shut down housing, that shut down all of the things that this bill is supposedly about. Ask them how glad they would have been if they could have done it in 10 months. It takes years now because of the regulations coming out of this room. This is bill looks like one thing, but it is actually totally different. It is a smokescreen to force high-density housing and force people that the church does not want in there. And when the sponsor gets up and says, well, should we allow this? Well, it looks good. This would be good housing. How could you say it's not good housing? It doesn't matter what anyone in this room thinks. The church has the right to put whoever they want on that property, and this bill will take that away. It is their property. It is not our business. Who's going to do what with this? We personally told the city this. You cannot force us to do anything on our property. Why? It is our property. Now, the good thing about this is I get to go back to all of these people that came into my church and were very mean to me, and I get to say to them, I actually voted no on a law that would have made it, given me the ability to tell you I can do what I want to. But here's the reality. I still have a lot of leeway. If a church wants to build a house on their property, they can do it. If anybody tells you they can't, they don't know the law. This happens all the time. I am going to put on my property what I want on my property. That's the law. Churches build houses all the time. I've been in 3 different church settings where we built a house on the property. This is not against the law. This is already within the law. So if the bill is not actually addressing a legitimate issue and saying, let's put housing, it must be addressing something else. And what it's addressing is to force high-density housing with no regulation from the governing church to be able to say who goes in that housing. And you say they shouldn't have that right? Well, then let somebody move into your garage, but I get to choose who it is. That's what you're saying. This bill is a very, very bad bill. It's going to do a lot of things that is not being verbalized, but is in the bill. And I know this because I'm doing this every single day right now. And I can spend a lot more time explaining that if that's argued against.
Thank you, Rep. Bottoms. Representative Luck. Thank you.
Thank you, Madam Chair. Shifting gears, I'm wondering perhaps if the bill sponsor will entertain a couple of my questions. So in the legislative declaration, section C, it talks about how, well, I'll just read it. As Colorado grows, so does the challenge of providing affordable housing to its residents. While land that is available for new housing in established communities is in short supply, many qualifying organizations own underutilized properties upon which housing could be built. And I think for me, the crux of this bill is really in that word could. And so I'm wondering if the bill sponsor, apart from the situation of the 2 rock churches that have been discussed, one in Castle Rock and one, I think, in Boulder, is that, or somewhere up, the one in Castle Rock. Well, there's also this one that, the village at Solid Rock, on Solid Rock Christian Center. In any case, apart from those 2 instances, I'm wondering if the bill sponsor knows of qualifying organizations with these underutilized properties that actually want to build housing that their counties or municipalities or whoever is making those decisions have said, nope, sorry, you can't do that.
Representative Basenecker.
Yeah, thank you, Madam Chair. Thank you to my colleague. I'd have to read back the committee testimony, but those folks came to committee, shared their experiences either being successful in some limited instances, but largely either speaking to the precarious nature of their process, which ultimately drives up cost because of unknown delay or other mitigating factors. And then also I would say we had a number of folks, including a pastor who was here on the State of the State address from Colorado Springs, who spoke to his, I think, frustrations with how this hasn't played out according to expectations. So we do have examples both from committee and also just in terms of the amount of property available in the Denver metro area alone that speak to, I think, the frustrations our congregations, public schools, public universities have faced in this space.
Representative Luck.
Thank you, Madam Chair, and thank you for that answer. In terms of, so the next section, as you gave me a nice segue. In Denver, Jefferson, Arapahoe, and Douglas counties alone, faith-based organizations own more than 5,000 acres of undeveloped land, some of which has never been developed, and some of which has been vacant for over 70 years. In many cases, faith-based organizations are mowing or maintaining these lots at significant cost with no real benefit to the community. Again, this is pointing to a dynamic, to a situation that, in my view, is being posed as a problem. And I would dare say that it's only a problem if the owners of those properties actually want to build and they're being precluded from building. But I am reading this in a concerning way. It concerns me the way this is framed, because it makes it feel like there is an identification of, hey, we could solve this problem if only we could use this property. And I just want to make sure that the bill sponsors are not contemplating future iterations of this policy such that it would actually mandate, as we're seeing in other jurisdictions. I mean, the representative who spoke before me, there's a case I know in the center of Colorado where local communities are saying to churches or to these property owners, if you want to build or expand in any sort of way, then you also have to have corresponding affordable housing. And I just want to make sure that I'm not reading something into that that's not actually intended.
Representative Basenecker.
Thank you, Madam Chair. Thank you to my colleague for the question. The bill is completely optional for our public schools, public universities, and our congregations. Should they desire to offer a portion of their land up to 5 acres as amended, they would have the opportunity to do so. At the request, candidly, though, of organizations that tend to trumpet the value of local control, we did add affordability provisions in place to say that if this is something you wish to do, then it needs to meet demonstrated community need or align with the affordability provisions at a statewide level, or that a local government could utilize inclusionary zoning, deed restrictions, community benefit agreements, or other things that they would normally put in line with a project to impact affordability. But again, it's completely optional. If a congregation, school doesn't want to do it, they don't have to. Were you to ever take that next leap, I think the bill would be unconstitutional on face as a takings.
Representative Luck.
Thank you, Madam Chair, and thank you for that answer. The next question I have is as relates to qualifying properties and the inclusion of only faith-based organizations. Sorry. So my next question has to do with the definition of qualifying property being limited in part to only faith-based organizations. And I'd like to understand why the bill sponsors decided to not make it just generally nonprofits, 501c3s, et cetera, because you have, Girl Scout troops or Boy Scout troops that have longstanding camps in certain parts of the state that also might be developable in certain places. And so I'm just wondering why we're narrowing this as an option, as a benefit only to faith-based entities and not to overarching nonprofits and 501c3s.
Thank you, Rep. Luck. Rep. Mabry.
Thank you, Madam Chair. I honestly don't hate that idea, but this bill is right-sized for the problem we're trying to address right now. As you can see, we've already had quite a discussion. We had quite a discussion in committee. I think expanding it to that point would have broadened the conversation so much that we probably wouldn't have been ready to take all of that on. But I don't hate that idea as a concept, but this is the scope that we decided to go with this year.
Thank you, Rep. Mabry. Rep. Luck.
Thank you, Madam Chair, and thank you for that answer. In terms of the amendment that was made in committee that was related to the prohibition on discrimination, I'm trying to contemplate whether or not the bill sponsors mean to say that if a church wants to create a seminary on their property, which has a host of housing units, whether apartments or what have you, for their students, that this bill is not suggesting that they have to allow into that seminary or into those housing units people who are not actually conforming with their faith position.
Rep. Basenecker.
Yeah, thank you, Madam Chair, and thanks for the great question. So the bill specifically contemplates those anti-discrimination pieces in relation to the Fair Housing Act, ADA, or applicable state and federal law, when a congregation offers up housing for commercial purposes, so for sale or for rent for the general public. Those provisions would protect against discrimination in those instances. Congregations can already, and the ability to do so would not be impacted by the bill, house folks for the purposes of religious education, build a parsonage. Some congregations choose to do that. This bill would not complicate those efforts. It just simply says that when a congregation, school, or university takes that next step and builds something, even in the public education space, past a teacherage, then it would be applicable in terms of Fair Housing Act.
Thank you, Rep. Luck.
Thank you, Madam Speaker, and thank you for that answer. And again, just to clarify a little bit further, so if a ministry says we want to provide gap year program for foster kids and we want to make it such that they pay a degree of rent and we help them transition from the foster care situation into their own independent living, or for abused women, or for any category of people, this bill would not preclude them from providing those resources under their banner of ministry.
Representative Basenecker.
Thank you, Madam Chair. I would need to see the specifics of the contract, but I can say generally that the allowable uses that currently exist are not impacted as long as it relates to, as you see on page 5, and I'm looking at the pre-amend version.
I don't have that.
It's the definition of faith-based organization. As long as it relates to the purpose as defined here, this definition came from the Division of Property Taxation. So that's how we define both the organizations and sort of their understanding as an organization, how that activity might be related to the edification of folks based on their faith. So we need to see the specifics, but generally, this is just that broader pool of folks for whom you say this apartment is available for rent.
Okay. All right. I think for now that actually, oh, sorry.
Representative Luck.
Thank you, Madam Chair. Sorry for that. It's just in the middle of conversing, and I think, looking through my notes here, that summarizes the questions that I had. Thanks, guys.
Thank you, Representative Luck. Any further questions, discussion on House Bill 1169? Representative DeGraff.
Thank you, Madam Chair. All right, so this is a demographic question, and these demographic questions have been answered. Denver, Colorado, excuse me, I mean, not everything is about Denver, right? Has a demographic problem, but it's not growth. Now, that was an old problem, and it kind of suffers from, so let's look at some demographic information. I've just got a 17-page paper on this. I could read that if you'd like.
No, thank you. Please stick to the bill. House
All right, thank
Bill
you.
1169.
Thank you, Madam Chair.
Thank you.
All right, so let's look at the summary. Let's look at the summary. Housing unit growth did not keep up with housing formation during the last decade due to the Great Recession. I wonder who created the that'd be government that created the Great Recession. Creating a tight housing market and escalating home prices. Now, some of that, of course, was having a massive California infection, from which we still suffer. Creating a tight housing market and escalating prices. Since 2018, Colorado has built more housing units than new housing growth. So if you have more housing units than housing growth, what you end up with is a surplus of homes. Now, it's not necessarily bad. If you have a surplus of homes, then prices go down, but what you don't really want is a bubble. Bubbles are really pretty until they burst. Then they're just kind of messy. Since 2018, Colorado has built more housing units than new housing growth, making a dent in undersupply. In 2023, housing growth increased by 45,000, and in 2024, housing is expected to increase by an additional 40,000 units. Cool. Recall that the population grew by 36,000. So the population grew by 36,000. A lot of those would be children. Children don't tend to buy homes on their own, so they became part of a home that was existed. So in 2023, when 45,500 homes were built, the population grew by 36,000. That is roughly 10,000 units in surplus, at least 10 to 20. Primarily driven by births, while deaths were 26,000 more than net migration. Deaths were 26,000 more than net migration, meaning that there was a decline in adult population. So let's look at that. We have a decline in adult population. Adults are the ones that buy homes. We built 45,500 homes. So is it really likely that we need to turn every development into a church with unlimited occupancy? I guess that would be the Church of Woke. Just branches of Church of Woke. The increased supply of housing units and slowing demand by new population growth. And here's something, in talking to the demographers with these meetings, that are projecting things like a 100,000 unit shortage. What was that 100,000 unit shortage based on? That 100,000 unit shortage was based on an expected influx of a large number of fertile females. Now, I don't know where you go out and find this large number of young fertile females, but that sounds like trafficking to me. This will help alleviate the supply-demand mismatch and allow those who have had to double up on housing and the potential opportunity to find housing. New households were estimated to have an increase by 27,000 in 2023 and are forecast to increase by 25,000 in 2024. 25,000 in 2024, and we're expecting a 40,000 unit increase. So most of those new houses forecast increase by 27,000 are forecast to increase by 25,000 in 24. So that would be the population. So most of those households are going to be probably more than one person. The ratio of household population to household units reached a low of 2.18. Population to housing units reached a low of 2.18 in 2023 after hitting a high of 2.31 in 2016. The 35-year average is 2.25, indicating that currently the housing supply is slightly looser than the historic average. Household formation is forecast to grow annually by an estimated 32,000 over the next 10 years as job employment and labor force growth meet forecasted levels. Now that's all based on not completely fouling up the market beyond anything recognizable. And the largest cohort of millennials are in their 30s and primarily the first-time home buyers. The leading edge of millennials is in the early 40s, entering the highest earning age cohort and prime second home buyer. The largest and fastest household growth will be in the 65 plus
Rep. DeGraff?
unit. Yes, ma'am.
Thank you so much for the research. Do you think you can get back to 1169? Thank you.
Ma'am, I never left. Never left. We're talking about a bill that purports to, I'm assuming, well, I mean, that's not really the purpose of the bill, is to address a housing shortage. So yeah, this demographic information is about the need for the bill. And if we look at some of more of the demographic information, Colorado, 28 of the 64 counties, or 44%, saw a decline in population. In Colorado, 28 of 64, 44%. I'll be on this in a minute. With variations observed by county. While Jefferson and Arapahoe declined, there were increases in Douglas, Weld, Adams, and El Paso. Interesting. So we had a 40,000 unit surplus, and the population growth was 10,340, 6,268, 4,084, 4,068, 3,500. So that comes out to 20,000, about 27,000. So of that surplus of 40,000 units across the state, the population increased by 27,000. So if you turn those into households with families having the average of 1.25 children or something like that, then you'd take that population growth, divide it by, say, just 2, a little bit more than 2, 27,000, 14, you got 10,000 homes, and we have 40,000 surplus. So apparently the influx of young fertile females has not happened. Now, a relief valve for Colorado right now would be Washington, D.C., where they have a surplus of houses on the market suddenly. Thousands of property have inexplicably gone onto the market in Washington, D.C. So people that are unable to find a home in Colorado will find a buyer's market in Washington, D.C. So what happens when you create a large surplus? Well, I think you would meet the you'd notice the governor's intent of the gaslighting address a couple years ago, and that would be to devalue the housing market, is to lower the price of housing by gutting the value of people's houses. So in doing so, when you create a large supply and then you decrease the demand, you lower the price. That's great, but what it tells us is that we do not need to force rezone by bureaucrat, the housing. Because our population growth in Colorado is significantly influenced by two primary factors and related groups. Births, which have been declining since 2007, both in the United States and Colorado. Second, the 65 plus demographic has shown substantial growth. There's not a lot of births associated with 65 plus, increasing by almost 29,000 between 20 and 21 and projected to grow by 35,000. Obviously, that is a self-limiting problem because the growth in the 65-year plus group is going to be a decline in overall population. An estimated of 69,000 Coloradans turned 65 in 2022, with another 68,000 expected to reach this milestone in 2023. We could have helped the problem by making the senior homestead exemption portable, long-term instead of temporary administratively, but the impact of this growth is evident in the strong labor force, leading to a large rise in retirements. Large rise in retirements, so people will be looking to move someplace where their income is not taxed. So what we're creating in Colorado is a housing surplus that is unsustainable. And an unsustainable housing surplus is going to lead to my amendment. So, Madam Chair, I move L019 to House Bill 1169 and ask that it be properly displayed.
Thank you, Rep. DeGraff. L19 has been moved and properly displayed to the amendment.
Thank you, Madam Chair. I just thought I would like to make my previous motion permanent, because when the outcome is evident, the intent is inferred. When you have a population that is growing, or I'm sorry, Madam Chair, I'm sorry. I'd like to rewind that, but I suppose that's not possible. When you have a population that is getting older and will be declining, and you have a declining population overall, and where you have a net increase in homes, one thing that you don't need to do is you don't need to turn every empty lot into a massive.
Rep. DeGraff, please hold on. We need to go to a quick recess.
Sorry about that diversion. But the outcome of the bill.
Rep, wait a minute. Thank you. The committee will come back to order. Representative DeGraff.
Thank you, Madam Chair. I was
To the
not
amendment.
aware. I would say it's the outcome of the bill, but that is considered offensive. So I ask that L019 be withdrawn.
L0019 has been withdrawn. To the bill, Rep. DeGraff.
To the bill. Thank you, Madam Chair. I will contend that I am also offended on the behalf of my constituents and which is all of Colorado, that it is offensive that this legislative body is 100% overriding the citizens and the self-rule of every municipality in Colorado. Every single one.
Rep. DeGraff, give me a moment. Colleagues, I can hear you all the way up here. Please, thank you. Rep. DeGraff, you're welcome.
Thank you, Madam Chair. I would like this body, it would be ideal if we would actually look at things that would reduce the cost of housing for Colorado instead of engaging in these charades. That was the purpose of the amendment. The purpose of the amendment is to identify the outcome of the bill.
Well, Rep. DeGraff, thank you for withdrawing the amendments, but we're to the bill at this point. Please and thank you.
Thank you, Madam Chair. I would like, so this bill is an affront to home rule. It is an affront to local zoning. It is an affront to every single municipal government out there in Colorado. What will it achieve? It will achieve circumventing the property tax rules of Colorado. So I do like that on the face of it because this bill is saying, hey, property taxes are killing housing prices in Colorado. Now, the fortunate thing is that there is a relief valve. I don't know, maybe I shouldn't say the relief valve of Wyoming because they just cut their property taxes in half. I know lots of people are fleeing to Wyoming to escape the oppressive gun regulation. This would be another reason. But we don't want to call them out and chase our businesses or locals up there. Because that would create more housing availability, which will drive down the prices. So this is all about communal housing, communal transportation, climate goals. I know they're not in there, but this is all the same stuff. All the same stuff, the abolition of private property. I ask for a no vote on this bill. I ask for some recognition that the municipalities of Colorado can actually govern themselves and don't need the nanny state to hold their hand for every little thing, especially something that is only going to make the problem worse. So please vote no on this bill.
Thank you, Rep. DeGraff. Is there any further discussion on House Bill 1169? Seeing none, the question is the adoption of 1169 as amended. All those in favor say aye. Aye. Those opposed, no. House Bill 1169 as amended is passed. Mr. Shebo, please read the title to House Bill 251147.
House Bill 1147 by Representatives Mabry and Velasco, also Senators Amabile and Weissman, concerning measures to ensure that municipal court defendants are subject to similar conditions as state court defendants.
Thank you. Representative Mabry.
Thank you, Madam Chair. I move House Bill 1147 and the committee report.
To the committee report.
Thank you, Madam Chair. In the committee, we made several amendments in response to stakeholder feedback. First, we made some technical clarifications at the request of CML to clarify the scope of the bill, specifying that what we were talking about is in municipal courts and ensuring that a failure to stream live court proceedings because of technology outages won't be considered as violating the law. We then brought another amendment that was another point of clarity requested by CMJA. This amendment codified current practice and clarified that people out of custody are not automatically presumed indigent and thus not automatically entitled to court-appointed counsel, but then clarified that these people do have a right to court-appointed defense counsel if they faced a possible jail sentence and the court determined after the fact that they were indigent. We then brought another amendment to preserve good defense counsel contracts. This was another issue identified through stakeholding. There are some jurisdictions who pay a guaranteed minimum rate to defense counsel for weekend bond hearings. These contracts are different from flat fees that disincentivize spending time on a case because they instead pay counsel to present for hearings when a jurisdiction doesn't know how many people will appear on a given day. This amendment ensures that those good contracts can continue. We brought another amendment working with our sheriffs that stated that there are limited municipal jails that operate, and this amendment ensures that municipal jails have the same obligations under our bill as county jails to help bring accused folks before a judge. Then with the help of our colleague from North Denver, we brought a legislative declaration to clarify the intent of the bill, noting that fairness and transparency in all court cases across Colorado are issues of statewide concern. And we made a connection between the work that we did in a bipartisan way in Senate Bill 21-271 and this bill are all about our shared goals with the governor to reduce unjust sentencing disparities. And then we had another amendment that was an anti-delay provision clarification. We, in recognition that municipal courts are not able to move cases along, our amendment clarified that municipal courts must make diligent and reasonable efforts to move municipal cases, but they're not obligated to resolve a case when there are systems that prevent it or make it impossible. And with that, we urge an aye vote on the committee report.
Representative Armagost.
Thank you, Madam Chair. So hearing this in judiciary, the opposition to this obviously were the municipalities and the chiefs, everyone that interacts with people on a criminal level in their municipalities versus what's happening in the state. The issue was that there are problems that are being resolved between certain municipalities and their counties, but the vast majority of the counties and the municipalities work together well to make sure that those municipalities are able to charge appropriately to address the crime issues that they have. Municipal sentencing is a matter of local concern, does not deny defendants equal protection. Where examples of longer jail sentences offered to support the bill are rare exceptions, only used in extreme cases where the facts support the longer sentence. This bill could have negative consequences, will have negative consequences for state courts and community safety. It's premature, given the 3 pending cases in Colorado Supreme Court that could resolve the issues. Those issues and discussions have to take place after the Supreme Court rules. These are things that we need to wait on. It was even mentioned in committee that we need to wait on what happens in our state with the ability for municipalities to be able to charge appropriately to address crime issues in their cities and not have to follow into the same guidelines that our state does in soft on crime issues that we have. We're dealing with that on a federal level right now. We're dealing with that in our state. We're dealing with that around this building. Colleagues want to walk across the street and tell me you don't see it, or you don't feel it, you don't hear it. So we have members getting spit on, we have members getting assaulted, we have members seeing dead bodies in the street. This is an issue where municipalities should have the ability to simply address crime the way that they need to fix the simple crime issues that they have that are accelerating and getting exacerbated by the legislation we're making in this building. We have to be able to do something. The biggest thing that is offensive is it creates unfunded mandates, it creates issues for our municipalities, and it even affects representation for people, for defense counsel. So on the committee report, I need to offer some way to fix that, so I move L008 to the committee report and ask it to be properly displayed.
L8 is properly displayed. Representative Armagost.
Thank you, Madam Chair. Simply put, the amendment provides funding for legal representation of municipal offenders through the existing Colorado Public Defenders Fund. It ensures equitable access to legal counsel for indigent defendants in municipal courts, aligning municipal defense representation standards with those of state courts. I encourage and I vote.
Representative Mabry.
Thank you, Madam Chair. Members, we're going to be requesting a no vote on this amendment. Not only does it unnecessarily put a fiscal note on this bill on a program that is going to be cut by the JBC this year, it requires the state to provide indigent defense for municipal defendants staying in jail. So muni courts will not only control county budgets by sending very low-level and often homeless offenders, homeless folks to county jail, but they will then also control the county budget, the state budget, by requiring the state to pay for the indigent defense that people are already entitled to under the Constitution. We've worked closely on this bill with Defense Council. Defense Council, they're not very engaged in our bill, but they are supportive of our bill, and they have not asked for any changes. The Constitution requires the state of Colorado to provide indigent defense and requires municipalities to provide indigent defense regardless of this amendment, and this adds unnecessary cost, and we ask for a no.
Representative Armagast.
Thank you, Madam Chair. I hear about stakeholding with the Defense Council. Clearly, there was not standard or substantive stakeholding with the municipalities, so I ask for a division.
Representative Mabry.
Members, I honestly really don't appreciate that comment. When I just read through a list of amendments, many of the amendments that we brought were from CML, who we did not move on the bill. They still opposed the bill, but of course we stakeholdered with them. We couldn't give them everything they wanted. We're not going to gut the heart and soul of our legislation. Eventually we're going to reach an impasse, and their position is the litigation that's taking place at the Colorado Supreme Court right now should be borne out, and they have told people, they probably told people today, if the Supreme Court rules against them and tells us we have to pass the bill that we're presenting today, then they'll work with us on it. And so we've had conversations with CML, and we have stakeholdered with them in good faith, but we reached an impasse. And so I don't appreciate the notion that we didn't stakehold on this legislation. And again, we'll just reiterate that this amendment is not necessary.
Thank you. Representative Barone.
Thank you, Madam Chair. I stand here, see, I heard that this amendment would bring a fiscal note. This is a good amendment to this bill. Just because it brings a fiscal note shows to how this bill is unnecessary. Unnecessary because it is unfunded mandates. Just because it brings a fiscal note, we're not going to accept it. This bill bringing a fiscal note makes it a good bill. Just because it has a fiscal note, we're not going to accept it. That says a lot to it, a lot. It's unfunded. It's a bad bill. We can't do this. This amendment will bring a fiscal note. It'll make it a good bill, though. So I stand and ask for an aye vote on this amendment.
Thank you. A division has been called. The question before us is the adoption of Amendment L8. All those in the chamber not entitled to vote, please sit and remain seated. All those in favor of L8, please stand and remain standing in one place, or raise your hand and keep it raised until the count is taken. You may be seated. All those opposed, please stand and remain standing in one place, or raise your hand and keep it raised until the count is taken. You may be seated. L8 is lost. To the committee report. Seeing no further discussion, the question before us is the passage of the Judiciary Committee report. All those in favor, please say aye.
Aye.
All those opposed, please say no. The committee report is passed. Representative Velasco.
Thank you so much, Madam Chair. So this issue was brought to my attention by attorneys in my district who were defending people against extreme sentences for petty offenses, such as facing 8 months in jail just for stealing a lipstick from the grocery store. In that case, the attorney was able to successfully lower the sentence, but we know that not everyone gets quality legal defense. In particular, folks who are low income, who are unhoused, who have developmental disabilities, who are suffering mental health crises, or who may speak more comfortably in a language other than English. In Grand Junction, which neighbors my district, is currently under scrutiny for abuses that were recently published in the Denver Post. In spite of being entitled to legal representation, the Denver Post found that poor and unhoused people are pleading guilty and being sentenced without legal representation in an overwhelming majority of the cases, with long sentences for petty offenses, sentences that far exceed what an individual could be sentenced in state court for the same or similar offense. The American Civil Liberties Union of Colorado and the Colorado Freedom Fund said in a letter to Grand Junction leaders that it is likely that all or the vast majority of people who appeared before the city's only municipal judge were convicted and sentenced unconstitutionally. The same pattern has been found in several other municipalities in Colorado, and it is likely much more widespread. This bill, House Bill 1147, addresses two major issues. The fact that municipal defendants are not getting legal representation, especially low-income and indigent defendants. And two, municipal sentences for these individuals are so extremely inflated that petty offenses are being sentenced more harshly than felony cases in state court. We're talking about harsh sentences for poverty-level offenses, theft of basic necessities like food and toiletries. The impact? Increasing poverty, exacerbating mental health issues, keeping people away from their children and families, wasting public resources on jailing individuals who should be at home in the community with sentences commensurate with the severity of the offense, and creating more barriers for these individuals to getting jobs, accessing services, and having stable, healthy lives. So I am proud to work with Rep. Mabry on this bill that creates parity between municipal and state courts so that across Colorado, sentencing is applied fairly to the same offenses. Our bill will also ensure the right to counsel for low-income and indigent defendants in and out of custody so that our constitutional right to counsel is upheld and our constitutional right to understanding the charges against an individual to not self-incriminate are also upheld. So we ask for an aye vote.
Representative Mabry.
Thank you, Madam Chair. Before I dig in to the meat of the policy and the reasons behind bringing this legislation, I just want to highlight a few things. I anticipate that we're probably going to hear a conversation about public safety. And of course, all of us care about public safety. My co-prime and I would not be on this bill if we believed that it made our communities less safe, and neither would the counties. The counties are actively supporting this bill. We had sheriffs come and testify in support of this bill. They testified in support of this bill because they want to reserve jail beds for people who pose a public safety threat and not have their jails used as homeless shelters by the city at county and taxpayer expense. There's also a misconception that this legislation lowers the penalties or makes it tougher for municipalities to crack down on petty theft, and that is not the case. What we're saying is you've got to follow the state sentencing guidelines, which were set up in a bipartisan way in 2021. policy that almost unanimously passed out of here. We heard worries that, okay, there are repeat offenders, people who are stealing multiple times. Nothing prevents a state or municipal court from aggregating multiple thefts in order to increase their theft classification. We hear that the worry with this bill is about going after people who are causing real harm in communities, repeat offenders. Well, CRS 18.4.401.4a and 4b provides two methods of aggravating theft so that they do not apply as petty offenses. Theft committed 2 times or more in a 6-month period can be aggregated to raise the level of theft. We heard a cautionary tale against this legislation about there was a defendant who had stolen 18 times, done retail theft 18 times. Well, if somebody did retail theft 18 times, you could pool their offenses and put them in jail for 120 days or a year. I'll also note that that same section of law says 2 or more thefts can be aggregated and charged in a single account if they are committed against the same business. That's Colorado Revised Statute 18.4.401.4b. And that doesn't have the 6-month time limit on it. So what we're talking about here is people who are in poverty. Municipal courts overwhelmingly prosecute poverty offenses. Serious offenses should be appropriately funneled to state courts. And I want to highlight a few stories. There was a woman in Westminster who was accused of stealing goods worth less than $300. When the Westminster police arrested her, they had 2 choices. They could charge her either under state law, the one that I just cited, 18.4.401, or they could charge her under the Westminster Municipal Code. They chose the Municipal Code, which means that this woman faced a possible jail sentence 36 times longer and fines more than 9 times higher than are allowed under state law. Colorado is only one of 6 states that allows municipal courts to sentence people or hold people for up to a year in jail. And this law does not change that. It just clarifies that you need to follow the state sentencing guidelines. This woman is not alone. In Longmont, a woman is challenging a 30-day jail sentence for a probation violation that would have been limited to 10 days in state court. In Denver, a person accused of obstructing the street faced a maximum sentence 30 times longer in municipal court than if the officer had chosen to charge them in a state court for identical conduct. A person accused of trespassing in Aurora faced a maximum sentence of 364 days in jail that would have been limited to 10 days in state court. I also want to talk about 10 days in state court. I think you're going to hear that 10 days in state court isn't enough punishment. 10 days in state court for a petty theft, goods under $300. Think about that. If somebody makes minimum wage and works full time, their time that they are taken away from their life is worth more than that $300, not to mention the fact that they're going to lose their job, lose their housing. These sentencing disparities violate the equal protection guarantee of the Colorado Constitution and the preemption of our state laws. The unique structure of municipal court, including their entanglement with prosecutors who appear in those courts, reduced procedural requirements, lack of external oversight, and lack of well-resourced, fully independent defense counsel makes them a risk to the right of the accused people who appear before them. And that risk is compounded by the fact that those accused people tend to be society's most vulnerable: the unhoused, the mentally ill, the extremely poor, the racially marginalized, and the disabled. To allow the arbitrary and personal decision of one police officer to determine the types of prosecution and penalties a person will face is not only wrong, it is unconstitutional. Coloradans should not have to worry that they will have the full protections of state law when they face the judicial system based on the decision of the police officer. That should be decided by a court process. And do not take my word for it. Mark Sears, the president of the Aurora Fraternal Order of Police Union, acknowledged that Aurora police officers recognize that there are 2 different courts when they make an arrest. And they said officers are encouraged to send people to municipal courts because the courts generate funds for the city. This is a quote. You are encouraged to write things in municipal court instead of county court because who is going to get the money? The municipality is going to get the money, and that is the cold, hard truth of it. Politically, people will say different things, but they are full of censor. That is the president. That is the president of the Aurora Fraternal Order of Police. They acknowledge that the police are making these arbitrary decisions. Again, these municipal courts primarily adjudicate low-level offenses like traffic offenses, sleeping in parks or on medians, loitering, trespassing, and petty theft. Municipal courts are structured, funded, and supervised by the city. And there's an incentive. There's an incentive for the police officers to send people to municipal courts. In Colorado state courts, indigent defense counsel are automatically appointed to represent all in-custody defendants and during every in-custody appearance. This practice comports with the Constitution, the constitutional mandate under Gideon, and serves as a bulwark against plea coercion and other constitutional violations. Few in-custody defendants waive their right to counsel in state court, and when they do, it's only after an advisement. But this is not always true in state court. And members, bear with me. I know I'm laying a long record here, but it's critical because we're talking about people's constitutional rights. In Grand Junction, during in-custody docket days, there is no city attorney or defense counsel present. When defendants ask for a lawyer, which happened frequently in court audio obtained by an organization, and by the way, this was reported on by the Denver Post, the court most often responded that there are no public defenders in the courtroom and informed defendants that if they wanted a lawyer, the court would have to set them for another court date. So what that meant is defendants had to worry if they insisted on having a lawyer, that they would be held until the next available court date. That means you face more time in jail for asserting your rights. That's wrong. Jail stays and criminal convictions have enormous real-life consequences for defendants. And that should not be dependent on the arbitrary decision of a police officer. You should have the full guarantee of constitutional protections. We have two distinct systems of justice happening in Colorado side by side. People who are in the same county, charged for the same conduct, housed in the same jail, can face vastly different sentences and face different protections. And we have to guard against these violations, especially when we are exercising the full power of the state to take away somebody's liberty. Whatever your personal feelings about the appropriate punishment should be in each of these cases, I hope that we can all agree that you shouldn't face a vastly different sentence for the same crime. If you commit a crime on one side of the Arapahoe Road, you should be treated the same as if you committed the crime on the other side of Arapahoe Road. Our ability to exercise constitutional rights should not depend on whether we are in state or municipal courts. Everyone deserves equal protection under the law. And again, there are many tools to hold actual dangerous criminals accountable. The reason why counties and sheriffs are behind this is because some municipalities are taking up their bed space in their jails with people who are not dangerous, with people who are poor and people who are being charged with crimes that are associated with poverty. And so, members, we strongly urge a yes vote on 1147.
Thank you. Representative Taggart.
Thank you, Madam Chair. It's an honor to serve with you,
It's an honor to serve with you, sir.
and I'd like to spend a little bit of time, and hopefully you can give me a little bit of time, to set some facts straight.
Okay.
Because what has been said about the judge in Grand Junction is totally false. And I want to read you a portion of a letter that was sent to the Colorado Freedom Fund and was never responded to in October, where my friend, City Attorney John Shaver, wrote a 10 or 12 page paper going through the assertions that this group created. Falsely, I should point out. And again, brought to this dais by two individuals that also brought false information. So if you would bear with me, I'd like to read the letter, just the portion having to do with sentencing. I'm going to keep the defendant's name out of it. The judge, I should point out to you, when I was mayor of the city of Grand Junction, I hired her, along with two other individuals on city council. She is one of the most compassionate people that you will ever meet. And one of these paragraphs in this particular article, or this particular letter, I think will help that. The letters, which is from the Colorado Freedom Fund, categorical assertion that Judge Erett's sentences are cruel and disproportionate to the crime fails to acknowledge that the court has constitutionally derived authority as established by and through the City Council of Grand Junction to enact ordinances, rules, regulations, and administer the law of the city. The letter does not cite any instance that a sentence exceeded the court's authority as the same as established by the city charter and the Grand Junction Municipal Court. Now, on the defendant's matter, referred to in the letter as substantiation of the claim of cruelty and disproportionality of sentencing is in fact a telling example of the complexity of cases that a municipal court hears. And while the letter takes exception to the defendant receiving a 9-month jail sentence on 2 municipal theft charges because of his repeated lack of accountability, the sentence is not inappropriate under the Grand Junction City Charter and Grand Junction Municipal Court. Whether the sentence may be different under state law is not relevant, as the sentence was lawful under that jurisdiction. The defendant was first seen as in custody on December 14th, 2023, on case number, and I won't give that to you, as a result of an affidavit for arrest warrant issued on December 5th of 2023. He was also seen on case number, again, I won't give you the number, which was scheduled for arraignment on January 16th, 2024. Mr. Schroeder, the defendant was provided with video advisement, and the jail appearance report confirms that the judge advised him of his rights, including his right to obtain an attorney. At no time did the defendant file an application with the court for court-appointed counsel or ask to consult counsel that he may have had in state court proceedings. The record does not show that at any time he asked for an attorney, but he was denied counsel. So that's not true, as is claimed in the letter that was sent to our judge and city attorney. On December 14th, 2023, the defendant entered a plea of not guilty on both cases, and trials were scheduled. Trials were scheduled for January 30th, 2024. He received, and I pointed out to these two individuals, he received a PR bond. He was not detained and was released on the municipal cases. The defendant failed to appear at the trials, and warrants were issued on both cases. On March 26th of 2024, the defendant appeared in custody on both municipal cases on failure to appear on warrants. He pleaded guilty and was sentenced on both cases to pay fines, court costs, warrant fees, restitution,
with a 60-day suspended jail sentence and 364 days of unsupervised probation. From March 26th to May 7th, the defendant failed to pay any part of the sentence, nor did he file a motion to reconsider or otherwise communicate with the courts. The court authorized the fines, costs, and fees could be converted at that point to useful public service. Again, no detention, no fines. His cases were set for status conferences on April 23rd, for which, again, he failed to appear and warrants were issued. On May 5th, the defendant appeared in custody following his arrest on failure to appear on warrants issued by the court and 3 failure to appear warrants in Mesa County. So not only the 2 warrants in the city of Grand Junction, 3 in Mesa County. Cases of burglary and theft, drug paraphernalia, etc. Judge Arrett issued cash bonds on both municipal cases. Again, he was not detained. And I really don't much care what the Denver Post says, by the way, because this is facts from our city attorney. Due to the defendant remaining in custody on the non-municipal cases, that being Mesa County Court, which is a state court, by the way, Judge Arrett saw the defendant in custody, went to the county jail on May 7th. She inquired why he had not taken any steps towards completing his sentence at the municipality. The defendant represented to the court that he had a warrant on a different case and was arrested on that case, and asked that the court reinstate probation and that he be granted more time to complete useful public service. The defendant stated that despite his open theft case in another court, he hoped to get back on track with his municipal cases. The judge expressed concern regarding the multiple theft cases that the defendant has on his record and those currently pending, the number of victims of his actions, and his inattention to addressing the criminal matters in both municipal and state courts.
Representative, I'm curious if you...
Just 3 more paragraphs.
Okay, if we could get... And
Judge-
before you continue, I wanted to get to a place where if you heard something and you wanted to refute it, we can give you the latitude to put that on the record. However, I do hope that we do not relitigate this case. So that's why, we're allowing you to talk here. But after this, we need to get to the content of the bill. But please continue.
I appreciate that. Thank you. Judge Arrett informed Mr. Schroeder that due to his noncompliance with court orders, especially non-payment of restitution, his multiple failures to appear, and his extensive criminal history, she was going to convert his sentence to jail. The defendant disagreed that he has an extensive criminal history. However, notwithstanding that disagreement, his history includes 10 prior theft convictions, 7 of which he received jail time and or credit for time served from a different court. He also has convictions for 5 drug offenses, 2 criminal mischief, 1 harassment, 1 obstruction of a police officer, and 1 trespass.
Representative Taggart, I can also appreciate that we tried to redact some information, but since that has not happened, I'm going to ask you to limit your responses, or I'm sorry, your discussion in regards to someone's criminal record.
Okay.
If you could get to the content of the bill.
So, In conclusion, this bill was formed around a situation, one of them being in Grand Junction, Colorado. It was totally false. And I hope by reading some of this you realize the complexities of legal issues that our municipal courts in fact face. If I listened to my sponsors on this, they would have said to this individual, 10 days is fine. 10 days is not fine when you have been, in fact, when you have the kind of record that this individual had. 10 days is not fine when you're putting the citizens of Grand Junction and Mesa County at risk. This is an outstanding judge. And I know it because I've sat in her courtroom and I can see her compassion. And she follows the law in terms of talking and making absolutely certain that those defendants know that they have every right to counsel. Now, in that particular case, if that counsel is not in the courtroom, it might take a delay of a day to get that done. There's nothing wrong with that. To paint a picture that there's something wrong with that, it's just patently ridiculous.
Representative, I would, again, I understand we are not here to, I understand that you found a challenge to what they're saying. We have provided a lot of latitude to confront that. This is not a sworn space, but now we're beginning to talk particularly about people and cases. And again, I just want us to move back to the content of the bill, if you may.
The content of the bill, quite honestly, is not needed. It is not in the best interest of Colorado citizens. It is in the best interest of Colorado citizens to have judges like Tammy Arrett that in fact take the time, go visit them, try to work out a situation, give them the opportunity to in fact not avoid jail time, avoid fines. This bill takes those rights away from us as home rule cities, and it takes it away from very, very competent judges. And I do not understand what we are doing here. Why we continue to put bills in front of this House that inasmuch say we at a local level, in this particular case a judge, are not capable of developing justice for our citizens. I take tremendous offense to that, and I will fight against this bill if it takes me 4 hours to do it. Thank you.
Again, members, we need to talk about the content of this bill. I want to explain also why we allowed that latitude, but it will not be continued to be given. The content of this bill is equating municipal offenses to state-level offenses. So I also hope that we are not litigating crimes in here. Again, I will direct us to the content of this bill. Representative Mabry.
Thank you, Madam Chair. Members, I just want to make clear, nothing in this bill prevents a municipality, a municipal court, or a municipal judge from holding people accountable for charging people for multiple offenses, for pooling multiple thefts, for following the state sentencing guidelines. All we are saying here is that municipal courts need to follow the bipartisan state sentencing guidelines that we passed in 2021. 20 states in our country don't even have municipal courts. Most states, of the other states that do have municipal courts, they require municipal sentencing limits to be much lower than what we allow in Colorado. That includes our neighboring states of Wyoming, Utah, New Mexico, Oklahoma. It also includes Texas, Georgia, West Virginia, Mississippi, Missouri, Alabama, and Louisiana. We're just saying that you have to follow the state sentencing guideline. And I'm not going to relitigate any particular case because this bill isn't about any particular case. What this bill is about is a pattern and practice of courts that we and others believe violate constitutional rights. And the Denver Post article was based on 7 days of August in-custody docket audio recordings that were given to a law professor from the University of Michigan who specializes in indigent defense, and that law professor stated that it seems pretty clear that there are severe violation of individuals' constitutional rights on a regular basis in this specific courtroom. So we don't need to relitigate any specific case. The people who do this have listened to hours and hours of audio and said that this is a problem. And again, we are not tying their hands. We're just saying follow the state sentencing guidelines that were set through the CCJJ. If somebody has done more than steal less than $300 worth of goods, there are plenty of tools to hold them accountable. We've provided for them under state law. And that's what this bill is about. That's it. Municipal courts will still be able to hold people accountable within the guidelines of the state law so that we have equal protection, so that if you happen to do something in Grand Junction or in Delta or in Denver or on one side of Sheridan or the other, that you have the same due process rights. That's it.
Representative Velasco.
Thank you so much, Madam Chair. And in committee, we did have a lot of really good testimony from around the state, not only from urban communities, but also rural communities. And I think there's a couple points I wanted to make. One is that home rule cannot and does not mean that cities can adopt any criminal enforcement policy they wish, regardless of jail impact, and expect county taxpayers to blindly foot the bill. And also that cities are not free to make decisions about criminal legal enforcement that put substantial burdens on other local governments and other levels of government. So we urge a yes vote.
Representative Taggart.
Thank you, Madam Chair. I would not have litigated this particular case had it not been for the sponsors of this bill to initiate that litigation. And I'll let that sink in. I did not initiate it. I just merely tried to get to the facts. Now, what was just said, home rule cities have the authority to set their own, by way of city charters, their own set of guidelines as it relates to municipal courts. So what was just said is not true. We have that right. And we do it very, very carefully. What I was hoping to do by taking you through that a little bit is to give you an indication of how complicated situations can be in a municipal court. State law cannot put in one size fits all. That's the role of a judge. That is the absolute role of a judge. In my particular city, it can't extend more than a year, and the fine can't be more than $1,000. And it can be anything in between, including probation, including public service, et cetera, et cetera. We do not need this bill. This bill takes away from some of the most competent judges that we have across the state. And it is a direct infringement on home rule. And we as a body, from the Constitution of this state, do not have the right to do that. Please, do not succumb to this situation. This is not needed. We have great municipal judges that are fair. And I would much rather work with, I know my municipal judge because I know her character.
Representative Armagost.
Thank you, Madam Chair. So there's a lot of issues. Everything I've heard so far, it seems like we're kind of going into a deeper and deeper hole of problematic language and problematic even buzzwords in this bill. I think hearing things in committee, when I hear things that preface a bill, when I hear things on the House floor that preface a bill, it immediately puts up my little antenna and my little spidey sense goes off like, oh, let's listen to see what this is going to be. One of those things is when I hear simple bill. That's something that I always know it's going to be the exact opposite. Another thing is when I hear this is a public safety bill. Ladies and gentlemen, when we're talking public safety, you would think you'd probably have some chiefs on board. You'd think you'd have law enforcement on board. We had one sheriff show up in support. Everyone in the chiefs of police was opposed to this bill and adamantly opposed to this bill. That is opposition from public safety itself. The entity of public safety in Colorado opposes this bill. That is not a public safety bill. We are talking about something that offends public safety. We're talking about something that in a soft on crime state that we legislate ourselves into, we have municipalities that are trying to do the right thing. We have municipalities that are trying to charge in a way to minimize their crimes that we've created, and the amnesty that you have in Colorado to commit crimes and get low-level punishments. Those municipalities want to do something better to hold people accountable in their ordinances. We heard that from Aurora, we heard that from Pueblo, we heard that from a lot of different municipalities around our state in committee. And we're still saying, no, 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 this is a public safety bill. No, this is not. This is not a public safety bill. This is simply a bill that gives the state more ability to say, no, these are not the crimes you're looking at. These are not the crimes you're thinking of. This is a Jedi mind trick to wave a wand in front of somebody and say, no, it's not as bad as it looks, like Denver is dealing with right now. Look outside the windows and any angle outside of this building and see what we're dealing with in the municipality of Denver. This is going on throughout our state because of what we're legislating in this building. And now we're trying to say municipalities have to do the exact same thing. They can't exceed that. They can't hold the criminals accountable in their municipalities to be able to get something through, to be able to stop crime, because people in this building think that there's a downward trend in national crime, that, by the way, Colorado is the slowest decline among any other state in the country on that reduction in crime. No, we are horrible. The governor knows it, everyone knows it. We are horrible in our ratings in this state for crime, for public safety, for theft, everything. We are ranking the top of crime in the country. That's horrible. That's not something to be proud of. That's not something to keep legislating our way through. That's not something that we should be arguing about in this building. We should be doing everything that we can to improve public safety in our municipalities, in our state, in our counties, everywhere. We should be empowering our law enforcement to do their job, not tying their hands or making their job less valuable because they have to keep seeing the same people day in and day out because they get a simple infraction, a summons to court, and they're back out. Because there's no punishment for a crime that they're committing, habitually or not. It's offensive, and this is what we're up against. And the insult to injury on this is, this bill has a safety clause. This is something that we deem necessary to have a safety clause. So I'm sure my colleagues over here are going to have a lot more to say about this, but in the meantime, let's at least take a little bit of an attempt at fixing some of that. And by doing that, I move L10 and ask that it be properly displayed.
Okay, L10 is displayed. Representative Armagost.
Thank you, Madam Chair. This takes the safety clause out, makes it a petition clause. I encourage an aye vote.
Representative Mabry.
Thank you, Madam Chair. Members, again, we're bringing this legislation because people's constitutional rights are being violated by the arbitrary decision of an officer who arrests somebody. That determines what sort of process they get in court. I believe that that warrants a safety clause, so we'll be asking for a no vote.
Representative Taggart.
Thank you, Madam Chair. I wholeheartedly second this amendment. And I know you don't like this, but when somebody stands up here and says, we're not doing something that's constitutional, that is a totally false statement.
I'm sorry. The committee will go into a brief recess. The committee will come back to order. The question before us is the passage of Amendment L10. Is there any, I'm sorry? Okay. Blah, 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 blah. Apologies. Members, we are back to debate. A division has been called. Members, we are back to business. The question before us is the adoption of L10. A division has been requested. All those in the chamber entitled to vote, please sit and remain seated. All those in favor of L10, please stand and remain standing in one place or raise your hand and keep it raised until the count is taken. You may be seated. All those opposed, please stand and remain standing in one place. Raise your hand and keep it raised until the count is taken. You may be seated. L10 is lost. To the bill, Representative Caldwell.
Thank you, Madam Chair. I'm going to start off by first saying I appreciate the conversations that are being had here at the beginning of this debate about this bill, because as a member of judiciary, we sit through these committees and we hear testimony on very specific cases sometimes, and it's important to hear both sides of the story. So I appreciate my colleague from Grand Junction coming here to offer another side of the story, because we need to make sure we get the facts right, because we make decisions based off of this testimony that we hear. So I appreciate him clarifying the record. I'm going to do something I normally don't start off doing. I'm going to talk about the good things that I like about the bill. I'll start off with, this is from the ledge deck on page 2 of the bill. The bill clarifies that municipal court defendants have a right to counsel and that municipal defense counsel have the same notice, case information, and opportunity to meet with their clients as do state level defense counsel. Now, what we heard in testimony is that that is already happening. Just on the basic principle here of the right to counsel, as somebody who used to work on defense counsel teams in the Air Force, that's a principle I think we should all agree with. So that's a part of the bill that I actually like. Moving down a little bit longer in the ledge deck is another statement that I agree with, which is all municipal court proceedings are required to be open to the public observation. Virtual observation is required for all in-custody proceedings, and prompt resolution of municipal cases is required. We like transparency. We always talk about transparency here.
Representative, I'm
Yes, ma'am.
sorry to interrupt you. Hold on one second. Members, we are back to debate. Please take your conversations to the side. Representative Caldwell.
Thank you, Madam Chair. So that's where I'll start off at, but that's about where it ends at as far as what I like about this bill. Moving on to what I do not like about this bill. So we've heard a lot of talk here about the Colorado Constitution, and I should say we've heard a lot of talk about constitutional rights here on this debate so far. And I always appreciate when we're talking about the Constitution, but it's important to bring up here when we're talking about the Constitution is that it is my opinion that this violates the Colorado Constitution because the Colorado Constitution expressly authorizes home rule municipalities to establish their own penalties for violations of municipal ordinances. So this is established long ago with home rule laws in the Colorado Constitution that municipalities can do this. Now, why do we do that? Why do we give municipalities that kind of, I don't know, authorization, I guess you could say, to make these kinds of rules? And it's like my colleague from Grand Junction said earlier, which is one size does not fit all, right? What is good for Monument is not necessarily good for Fort Collins, or what is good for Denver is not necessarily good for Aurora. And so that's why home rule is so important here. And this bill just completely strips that kind of leniency for our local areas to enforce such things. And, you know, I have to say, I'm going to give you a little bit of a preview of a conversation you're going to hear from one of my colleagues from Douglas County. But I cannot let slide that there was a bill the day before we heard this legislation that talked about increasing state penalties for certain crimes. And the argument was used that if this is a problem in those municipalities, then they can address it because they have home rule authority and they can make those kinds of decisions if it's a problem in their community. And lo and behold, the very next day, we're hearing the exact opposite argument. We're hearing that we need to bring the municipalities in line with the state law. And I mean, you can't even make this up. It was literally within a 24-hour period in the same committee, two completely different arguments. We don't need to increase state penalties because cities can do that themselves. We need to tell cities that they can't increase penalties above what the state has. Literally two completely opposite arguments from the same committee members within a 24-hour period. I'm not going to go too much more into detail because I have a feeling that one of my colleagues across the aisle, whose bill it was to increase state penalties.
And I do hope when we come up, we will be debating House Bill 1147.
Yes, ma'am. 1147. So simply put, municipal sentencing is a matter of local concern that does not deny defendants equal protection. Now, something else I want to address here is there was a lot of sensational arguments here and examples of longer jail sentences offered, and what I would say is very rare exceptions, right? We kept hearing, you know, in Aurora, you can be jailed if you steal bread 2 times. You can be jailed for 90 days or something, whatever their max is, for 2 times for retail theft. And what we heard from Aurora City Council members themselves is that's not happening, right? When municipalities, when they say if you steal something, some kind of retail, the first time offense, it's 10 days. If you do it a second time, it's 90 days. If you do it a third time, it's up to 1 year, right? That does not mean that if a hungry mother comes in and steals a loaf of bread, and it's the second loaf of bread they've stolen, that they're gonna get 90 days in jail, right? That's why we give judges that discretion, because judges do not treat that the same, you know, a hungry mother stealing a loaf of bread. That's not being treated as the same as the person who walks into a big box store and takes a shopping cart and fills it up with $298 worth of goods and then just tries to push it out and throw it in the back of a car so they can go sell it at a pawn shop or something like that. That's not the same. That's why we give that discretion to the judges. They're not locking up mothers for 365 days because they stole a loaf of bread because they're hungry, right? That is not what is happening here. And again, this goes back to the local control. what I said earlier about what is good for Monument is not necessarily what's good for Aurora. We heard testimony from Aurora City Council members that they had a problem with retail theft. And so they increased the penalties for retail theft. And it was so well received by the local businesses that they were putting signs in the windows of their stores saying, if you steal, you will be prosecuted. The community, the businesses actually took pride in the fact that their city council, using their local control and their home rule, was actually increasing penalties on a problem that was very serious in their community. And what we're doing now is we're saying, nope, you can't do that anymore. Sorry, the rules that Aurora is gonna now fall under is the same rules that fall under Grand Junction and Monument and everywhere else. And that just completely goes against, again, the Colorado Constitution that explicitly gives that authority to our local municipalities. And again, no one is being jailed for 90 days because they stole a loaf of bread. So with that, I'm going to urge a no vote on this. I may be back to talk about a little bit more. And before I leave, I will just say, if this is such a popular bill, then I'm just curious, while Arvada, whoever represents Arvada, Fort Collins, Pueblo, Thornton, Westminster, are all opposed to the bill. Colorado Springs is an amending position. Fountain, Woodland Park, Firestone are all in monitor positions. So, you know, this seems like a really popular bill is what I keep hearing, but most of the cities oppose it. So with that, I urge a no vote. Thank you.
Representative Kelty.
Thank you, Madam Speaker.
Madam Chair.
Madam Chair.
Awesome.
Apologize. Well, if this bill were a book, I guess the title could read, how to make Colorado even more unsafe. I sat in on the committee for this, and let me tell you what we experienced throughout that committee with this bill. There are tons of. It was mentioned in the committee that higher consequences, higher penalties for crimes that people make isn't proven that it actually causes a deterrence. Well, there are a lot of studies out there that absolutely show that it does. You can go to www.ojdp.gov and the National Institute of Justice, and they will tell you right there. As far as, we had so many people come in and testify over this bill. We had panels of professional testifiers telling us how bad and disastrous this bill is, letting us know there will be lawsuits. Lawsuits that Colorado just cannot afford. People in the trenches who, with real-time data, spoke to us for hours, letting us know it will increase problems and it will increase crime. With their decades of experience, I believe them. They are the experts on the field. We're not. Yet I believe that this body, just like in committee, you're going to ignore them. You're going to ignore all of their voices, I believe. And you're still going to cram this bill through, and you're not going to understand what it's going to do until it actually destroys Colorado, which I believe it will. We already have a current court proceeding related to this bill in the Supreme Court, or Rule 21. Over this bill, we heard over and over from tons of experts, all the sheriffs, except for the one, oppose this bill. But guess where that sheriff is at? People across the state, from business owners, law enforcement, commissioners, judges, residents, constituents, schools, literally everywhere, from everyone that claim that crime is not just a problem, but it's reached a critical level. Walk outside. I'm very much into situational awareness. And I tell you, my antennae are up all the time the minute I step out this door. Yet time and time I see and watch, these are the people who come to testify on these bills, just like this one. Their pleas get ignored, and the criminals are given priority over our safety. You pass laws to protect criminals, not law-abiding citizens, and the people have noticed. Let's see how your passing laws like this make Colorado less and less safe. I hope the people finally take action on their own and force out those who refuse to help fix Colorado and the crime within it. This bill will have the opposite effect on safety it claims to have. Voting for this shows those who are against safety, which is why I'm a huge no. Safety in Colorado has to come first. Not all of Colorado is like Denver. And we keep trying to make everywhere else like Denver. And I hate to tell you this, we don't want to be like Denver. Down in Colorado Springs, we're not doing that great either, but we're definitely not Denver. If you look at the crime ratings that bills like this create, online, Denver is a big fat F. Colorado, we've got to do better, and this is up to you guys. You can help us do better, but passing this bill will not. And I'm asking you, please listen to the people and the experts that came to testify, the witnesses that were there. Listen to all the sheriffs, all the law enforcement, all the commissioners, the judges, everyone who know this exact field right here that we are not an expert in, but they are. Listen to their voices, and please be a no on this bill. Thank you.
Thank you. Members, I know we are having conversations about what's true or not. We do want to be able to have room for policy debate and underlying issues. However, I will point out that county sheriffs are in a monitoring position, not opposed, and so we just want to be able to keep it to a place where we know we can demonstrate what we're talking about. Representative Mabry.
Thank you, Madam Chair. Yeah, members, the sheriffs are not opposed to this. One sheriff came out to testify on this bill, and they testified in support of this bill. I'll also note we just heard claims that, these instances that we're trying to address aren't actually impacting low-income folks. There was a chief of police that came out that openly said, well, it's good that we do this because there are people who are homeless and they can spend the night in the jail, and it's somewhere for them to be. That was literal testimony that we heard in committee. If we want to talk about the testimony that we heard in committee, one of the arguments we heard in support is that homeless people can be inside of the jail. I also just want to recognize that, again, all of us care about community safety, and I think nobody would disagree that the Colorado counties, when they come to this building collectively, that they don't care about public safety. So in a letter about this legislation from our counties, they urge support because the bill upholds fundamental rights, ensures fairness in municipal courts, and prevents unnecessary financial burden on counties. It aligns municipal sentencing with state law. That's it. It does not say that you can't hold somebody accountable. It doesn't even get rid of the discretion of a judge. A judge has discretion in an individual case on how they're going to sentence somebody under this law. They just need to follow the state guidelines. The discretion that we're eliminating is of the charging officer checking one box or another and then somebody getting different process depending on where they're at. And I'm not even talking about allegations that we discussed earlier. It's just inarguable that the process is different in municipal court and state court. That's just by design. Home rule cannot and does not mean we can adopt any criminal enforcement policy that a municipality wants, regardless of the jail impact, and expect county taxpayers to blindly foot the bill. Counties across Colorado, including La Plata County, are often forced to house municipal offenders at county expense. Our bill limits unnecessary incarceration, which frees up space in county jails for criminals who actually pose a public safety risk. If you're out there committing crimes that are dangerous, violent crimes, you're going to be able to be charged for those violent crimes. Already those crimes are not adjudicated in municipal courts. The only things that are adjudicated in municipal courts are petty offenses. You're still going to be able to sentence somebody for a year in jail in your municipal court, but follow the state sentencing guidelines. We all care about public safety. Our counties care about public safety. The sheriff that came to testify in support of this bill cares about public safety. And, you know, I find it offensive that somebody would allege that I do not care about public safety, that the sponsors of this bill, that the backers of this legislation do not care about public safety. Of course we do.
I'm sorry, Representative Mabry, we can't hear you. Members, please bring the noise down. Continue, Representative Mabry.
Thank you, Madam Chair. Again, another thing I want to emphasize, we're one of the few states in the country that allows different sentencing between municipalities and state courts. Of those states, we are one of the only that allows a municipal court to go beyond what a locality, what the state guidelines are. I think this is entirely reasonable that we set a standard when we're taking somebody's freedom away, that we set a statewide standard. Please vote yes.
AML Winter.
Thank you, Madam Chair. So you know I talk about representative government all the time, and I represent 7 full counties and 2 partial counties, and one of the counties that I'm honored to represent is Pueblo. And you all know I stick around for committee hearings, and just the other night, I sat and listened to the mayor of Pueblo, the police chief of Pueblo, and the newly elected DA of Pueblo County talk about how this bill will prevent municipalities from addressing problems in crime-plagued cities through municipal ordinances. They sat here. They told us this. And they believe if this bill passes, the cases will not be prosecuted and criminals will continue to run amok. This is local government officials talking about this. And to be honest, I'm shocked that the state senator from Pueblo would put his name on this piece of legislation when officials from his home community come here and ask that we not pass this legislation. To me, that's the farthest thing from representative government. I've talked to them. They told me, in their point of view, that this legislation interferes with home rule and takes away discretion from municipal judges. Now, we don't know if it's going to happen yet, but we know the JBCs happen to make tons of reductions this year. And there may be a chance that they have to make a reduction to the alternate defense counsel on first appearance fund, thus putting unfunded mandates, which in turn puts financial strains on cities. They just want to be able to prosecute crime in their communities and make it safer. And although some communities along the Front Range may be okay with the lack of consequences for crimes, not all communities are the same. I'll say that again, not all communities are the same.
If you could stick to that instead of saying what we care about and don't. I just want to.
Sorry, ma'am, I was
Get
just
close to
speaking
that.
for my communities, those in
Gotcha.
House District 47.
Gotcha.
Thank you.
you.
So I wanted to be here. I wanted to chat and talk about what I heard from the largest part of my district that I represent. And I wanted to address those concerns on the microphone for the good folks and elected representatives out of Pueblo County. And for those reasons and more, I urge a no vote.
Thank you. Representative Luck.
Thank you, Madam Chair. And just springboarding off of that conversation, I wanted to make note that my understanding, because I also represent the County of Pueblo in part, my understanding was that the City of Pueblo was opposing this. And then when I heard that CCI was supporting it, I was a little confused, and so I reached out to some county commissioners from Pueblo County and was informed that no, in fact, they're not supporting this as a county, and so I just want to put that on the record, that both the city and the county are not supporting this bill. Thank you.
Okay. Representative Kelty.
Thank you, Madam Chair. Everyone, I wanted to make an apology. I misspoke a second ago. I said the sheriffs. What I meant was the chiefs of police. So I didn't want to. I wanted to come up here and correct myself. I'm a person that will actually admit when I said something wrong. I couldn't read my own writing, but I did mean the chiefs of police. Thank you very much, and sorry to the sheriffs.
Thank you. And again, Colorado Counties Incorporated is listed as supporting on this bill. Representative Bradley.
Thank you, Madam Chair. I'm going to read from the bill. The bill caps the maximum incarceration sentence for a municipal violation that has a comparable state law crime at the same length as a state level offense. When there is no comparable state level offense, the maximum period of incarceration is capped at the maximum for a state level petty offense. So less than $300 for retail theft is a petty offense, and they know that, so they're coming to my district and districts all around Colorado to steal because they get off with a petty offense, because this bill will now make it comparable. And I tried to pass a bill that would make it harder, and now we're going back to making that less than $300. And when I tried to make it a felony or misdemeanor, I was told that if there's a problem in my county or my municipality, that I needed to figure it out for my municipality. And then the very next day, this bill dropped. So imagine my surprise. And if you'll give me a little leniency, when our counties come to us and our districts come to us, and we are talking about crimes that compare to state levels, we have to remember what is happening in our state. We have been soft on crime, and the statistics show it. If you look at the FBI and U.S. News and our own public safety, they have rated us the second most dangerous state in the country. They have rated us #1 in bank robberies. They have rated us second in car theft. They have rated us 4th in property crime, 4th in rape. We're the 8th highest in violent crime, 10th highest in human trafficking. I believe I tried to pass the bill for that last year, and 4th in road rage. Local levels aren't capable of providing justice and public safety for its constituents, and now they're tying their hands to be able to do that because we're not doing it at the state level, and now we're telling municipalities that they're not allowed to do it. So I guess my question is to the sponsors, if you have a problem in your district, if they're not doing it right, and our own state isn't doing it right, we're gonna legislate on the entire state, we're gonna legislate what's going on in my county? Because I tried to bring forth a great bill to be tougher on crime. And I was told to leave it to the municipalities, and then the very next day a bill says, we're not gonna leave it to the municipalities, we're gonna leave it to the state. So you can imagine the hypocrisy I felt and all the witnesses that came to testify felt. If petty offenses are sentenced more harshly than felony offenses in your district, then pass an initiative in your county. There's no reason to legislate what's happening in your district onto my district that's doing things pretty darn well. And I'll also tell you, we don't have any laws against gift card theft.
Representative Bradley.
Yes, ma'am.
Please debate 1147. I was present for your bill, so I would like you to debate this bill, if you can. I just wanted to get ahead.
Thank you, Madam Chair. We have been soft on crime in the state. And I just repeated the statistics. We are now killing bills that will make crime harder. And now, the very next day, this bill presents to now take it out of local municipalities' control to do the very same thing. In fact, Aurora is doing it great. They are prosecuting retail theft and gift card theft, and now we're going to tell them they can't do that. Now we're going to tell them, instead of doing misdemeanors and felonies, because organized retail crime has hit their city so bad, and they have passed good laws so that now it's down. Now that the theft is down, and now the very next day, we're going to pass a bill that says, sorry, Aurora, you're doing it so well, we're not going to allow you to do it anymore. Instead, we are going to tell you no. We're going to tell you to go back to petty offenses, because that is what the state charges for retail theft crime, and just slap your criminals on the wrist. It's ridiculous. It's ridiculous to say that the state's doing a good job and then to admonish the municipalities that are doing a really good job because one district has a problem in it. It's pathetic at best. I urge a no vote.
Representative Soper.
Thank you, Madam Chair. It's an honor to serve with you.
It's an honor to serve with you.
Members, I rise to talk about this bill. It's one that, certainly I have mixed feelings on. Overall, I'm very supportive of the concept of having some uniformity and parity, and knowing that due process of law applies as you leave a city into a county or another jurisdiction within the state. We should expect the sentencing for similar offenses to be similar throughout the state, and to have, for example, within a municipality, a higher sentence than you would receive under a state court, to me seems quite mind-boggling. However, the part of the bill that I do find troubling in this space is the Colorado Supreme Court has accepted 3 cases to be able to really decide this issue of where home rule sits in terms of due process of law and equal protection under the Constitution. And I believe this bill is one session too early, that we have a Supreme Court that is ready, willing to weigh in, and either we pull out the provisions on, for example, page 4, lines 4, page 2, lines 26 through 33, page 7, lines 13 through 27, page 8, page 9, 1 through 18, which refer to what's currently being argued before the state Supreme Court, and then keep the rest of the bill. Or we have a clean bill next session. This is definitely a ripe issue. Otherwise, the Supreme Court would not be accepting oral arguments in this particular space. But the fact that if we were to pass this bill, what would happen is the Supreme Court would no longer have a live, ripe case that is ready for adjudication, and we wouldn't know their reasoning or their rationale in terms of interpreting a 1902 amendment to the state constitution. And I believe that that's wrong, that we should be entitled to that answer. But I also believe what's included in the bill is the correct path. I mean, we should expect sentencing parity between offenses that are similar on the same factual basis between state law and municipal law. Or same when it concerns the right to counsel. We should expect that if you're going to have your liberty taken away, that you should have the right of counsel present at all proceedings of the case in which it matters. So from arraignment all the way through trial. And transparency. I mean, ever since the early 80s, the United States Supreme Court has held that courtrooms must be open to the media and the public. And then as a General Assembly, we also added cameras as well for the courtroom. And we should expect that that be honored, that at least these structural parodies be included. So those are my frustrations and my appreciations with this bill. And I think anyone that stands and is so black and white as to say it's entirely on one side or entirely on the other, I think there's a much more nuanced approach that we have to reason, and one that we should be able to say there's a lot of good in here, but there's also some questions where we shouldn't be cutting off the state Supreme Court from ruling on an important question that I would like to hear the answer to. I know my colleagues would. I hope all my colleagues would like to hear the answer. Let the Supreme Court decide. That's what I say. Thank you.
Is there any further discussion? Representative Hartsook.
Good afternoon, Madam Chair, and thank you so kindly. It's a beautiful, sunny day today. So I'm curious. I can't help but wonder how we would feel as a state, or how other states would feel, if the federal government issued down how our state laws had to comply. If they chose to make uniform laws. Now you have federal laws that apply evenly across the states. You have state laws that apply within their states, and then within the states you have the municipals. And whether people support it or not, the concept that we want everything driven by what is deemed here at the state to be the best course of action and implement that with counties and municipalities is an interesting road to debate. In this particular piece of bill, we want to limit what the municipalities can do. Some of them are supportive of it, some of them oppose it. But nobody's asked, is it still the right thing to do? We as a state wouldn't like the feds, I don't think, at least I wouldn't. We wouldn't want the feds implementing and saying all 50 states have to have uniform laws. This is how everything has to apply, because states are different. Municipalities have different problems. They have different crime rates, they have different issues, they have different demographics. And state to state, each municipality within the given state decides how they want to prosecute and implement similar laws, but they're not all identical. That's kind of the beauty to the process, is we let each entity figure out what works best for them. Now, if some think that it's a great bill and some oppose it, all of us will decide and we will vote on it. For me, I will be voting no. But I would ask you, how would you feel if the feds told us to do the same thing? How would we react if we were told at the state level we had to comply and do everything the feds told us? I'm just going to venture a guess here that some of my colleagues wouldn't be too thrilled with that. I wouldn't be too thrilled with that. I don't think we as a state should be telling the 64 counties and the countless municipalities the same thing. Whether they support it or not, I don't think should be the debate or the question here. The question is this the right thing to do? Are we doing what we would want to have done to us from the feds? And I don't think we would. I don't think we should be telling all the counties and municipalities, here's your standard, you cannot deviate out of that. If a municipality has something that they feel, or a county has something that they feel, should be dealt with more harshly or differently than someone else for whatever reason, as long as it's not breaking another law or a constitutional issue, then they should be able to do that. That's the point of having that freedom out there, having that ability to do different things. And this piece of legislation takes that away. And that's a dangerous road to go down. I urge a no vote. Thank you.
Representative Espinosa.
Oh, wow. Thank you, Madam Chair. I've heard a lot of people come up here and talk about what the committees were and what these issues are. And I want to speak to you as someone who's worked in a municipal court. My first job out of school was as a municipal prosecutor, but in one of those states that put specific limits on what municipalities could do. And those limits aligned the criminal statutes and authority that we had with what the state authority was. Here we're talking about the question of preemption. And I'm prompted to speak today, speak right now, as a good representative who, I'm forgetting which county you're from, Douglas County, who just talked about what would we do with the federal government versus the state government versus the state government and the municipalities. This is the issue of preemption. And the question becomes, it's a standard question of preemption. And we know often in this chamber, we are addressing the question of whether the federal government has preempted a state's authority to do something. Part of the purpose of this bill is to articulate that when the CCJJ had representation from municipalities on the commission as part of what they did, holistically, in a bipartisan manner, we made a determination of what the sentencing should be for the crimes that were articulated in the CCJJ. We did not talk about what any of the crimes outside of those misdemeanors should be labeled as. So to the question of home rule, we would only be preempting those issues that have contemporary charges or equivalent charges and elements in the state statute. We don't touch home rule's authority to do anything outside of that statute to address the rights of the municipalities to continue to exercise their authority. In addition, what's important that I heard of the committee was there are some amazing things that municipalities are doing to address the concerns that they have by alternative diversion programs and alternative methods. Those would not be touched, and I specifically asked, is there anything in this bill that would preclude you from continuing to do those kinds of programs that the representative from Mesa County talked about in terms of the rights and authorities of those good judges? And as a former judge, I will tell you, the importance of being a judge is that we have guardrails and we have rules on what we can and cannot do. And correctly, today, the judges have a freedom to sentence someone who would be sentenced under a state statute to 10 days, to sentence them up to 364 days. But those municipalities are not even paying for those people for the 364 days. After 72 hours under that same authority, they must transfer those individuals to the county jails. So it becomes another issue of local control in terms of, should we as a state, first of all, have equivalent sentences for equivalent crimes, and that's all this bill is doing. If there's another crime, and I think of animal control being one that's usually in the purview of municipalities, every municipality is free to adopt their own standards because we don't have a state statute that regulates that issue. For anything that we don't have a state statute for, local control continues to exist, and this bill does nothing to touch that. But again, it's important that the judges be given guardrails, and those guardrails should be consistent with the policy that was adopted with municipal representation when the CCJJ established those sentences for these crimes. So that is the basis upon which I am urging you to think about the fact we are not taking away local control. We are not telling good judges that they're not doing a good job. Right now, what they're doing is fully within their authority. But what we are saying is that authority should be equivalent if you're on one side of Arapahoe Road, as one of my fellow judiciary members asked, or the other side. And it shouldn't be just left to which box on a ticket a sheriff checks to determine whether you'll be in jail for 10 days or you'll be in jail for 6 months. So that is why we're doing this, and I would urge this body to adopt this bill because it is providing all the other benefits that my other colleagues talk about in terms of equal protection, but also clearly designating that what we did here in 2021 was the intent of the legislature on those crimes that were articulated and developed for the sentencing at that time. Thank you.
Thank you. Representative Luck.
Thank you, Madam Chair, and thank you for this conversation, colleagues. I'm wondering if there's anyone in the room who can help provide some historical context to this beyond just the last couple of years. We're having a conversation about equal protection and constitutionality, and I'm wondering, Colorado has been in existence for 150 years. Why is this bill only now coming forward? Why is this conversation only now being had? Perhaps it isn't the first time. Perhaps there were other times throughout history where this conversation has been brought before this body, and perhaps there was a law like this that then got repealed. I don't know. I'm just curious if anyone in the room has that historical context, because it is curious to me that it's coming at a time, frankly, when there are changes being made and when particular municipalities and local governments are clamoring for changes to come from this building that have yet to come. And so they have made decisions as to how to best keep their people safe. And now we're saying that those decisions are not appropriate to make. And so I'm just trying to understand why only now we're having this particular conversation. And if anyone could help me with that, I would greatly appreciate it. Thank you.
Representative Woog.
Thank you, Madam Chair. And I speak for the city of Longmont here. They are in my district and respectfully disagree to my good colleague from Denver. They say 1147 is an unfunded mandate, conflicts with home rule authority, directly and explicitly violates the Colorado Supreme Court Chief Justice Directive 23-02, which currently limits live streaming requirements for criminal proceedings like evidentiary hearings, trials, and jury selection, bench conferences, communications between counsel and clients, in-camera hearings, and problem-solving dockets, which have been put in place partially so that victims of crimes are not subject to greater public exposure. So in speaking for my municipalities, they certainly are against this bill, and I urge a no vote.
Thank you. Representative Armagost.
Thank you, Madam Chair. So I think just to understand everything, a lot of different opinions on what is what as far as what this bill does for municipalities versus the state. I don't think it does anything good for the municipalities, which is why they're opposed. I think this also hinders our police departments, our chiefs, which is why they oppose. I think all in all, it offends the idea that we had the greatest thing that happened for our public safety and our municipalities was the home rule. Giving us home rule, I think, was one of the better things that could have happened that created that ability for them to have discretion in charging, discretion in sentencing, and reducing their crimes and their issues, whatever those might be in their communities. The sad thing is that not only this bill, but a lot of other bills that we see in this legislature take away from that. They create a nanny state versus a home rule state. And this bill, in and of itself, does that. So with that, I move L11 and ask that it be properly displayed.
Okay. L11 is properly displayed.
Thank you, Madam Chair. So this amendment basically changes the titling of the bill to Home Rule Abolition Act, and this is something that I think can help describe it more efficiently and effectively to what it is doing, not necessarily what the intent is, but what it's doing. So I encourage an aye vote.
Okay. On the mic.
We believe that this doesn't fit under the title, so we went to a title challenge.
Committee will go into a brief recess. Committee will come back to order. Chair rules that this does not fit under the title of the bill. Back to House Bill 1147. Is there further discussion? Representative Luck.
Thank you, Madam Chair. And adding to my list of questions to the body, during a conversation prior, there was a conversation related to the municipal decisions place a financial burden on the county jails. I am just wondering if there is anything that precludes the counties from charging the municipalities for housing those particular individuals and creating some sort of an IGA to relinquish or remove that particular barrier.
Rep. Caldwell, Representative Caldwell.
Thank you, Madam Chair. So speaking to the importance of home rule again, just some context for those listening to this debate we're having here. Home rule in Colorado was voted into the Constitution in 1902 for towns and municipalities. In 1970, Colorado voters did the same thing, amending the Constitution for home rule for counties. So this is a long storied history here of what we do. And I just want to address something that was said about what other states do. So we heard that Kansas and Wyoming and all of these other states, they don't allow their cities to enforce stricter penalties than what the state has. And to that, I would just say, well, they also don't have soft on crime state policies. So I think we need it here. I think we need it to give our options to our cities to be allowed to enforce those stricter penalties. So again, I am against this bill. I do think it is detrimental to home rule, and it's detrimental to our cities who are dealing with crime problems and who are saying we need to be able to take a harsher stance on these problems that are in our cities. And we heard testimony on this bill in committee that they said the message is out there in places like Aurora. Do not come to our city and commit things like retail theft, because the penalty in Aurora is going to be way stricter than the penalty in Denver or wherever else. So that message was sent, and they are proud of it. And again, their businesses, their community was proud of the actions they took, because they literally went and put signs up and said, if you steal here in Aurora, you will be prosecuted. And so we're taking that away from them, and we're saying the penalties at the state level is all you can enforce. And I don't think that's good for home rule in Colorado. So I urge a no vote. Thank you so much.
Representative Luck.
Thank you, Madam Chair. I know you all have been in suspense around these questions. I did just get an answer, not from anyone on the floor, but someone who is listening in, because they listen in. In my district, it's like the daily soap opera. And anyways, the answer to that second question is, in fact, municipalities are, in many instances, already paying counties to house their inmates or their folks. So at least one answer. Other questions still outstanding. Hope that someone in the room or outside can answer that one. Thanks.
Is there any further discussion as Days of Our Lives on House Bill 1147 continues? Representative DeGraff.
Thank you, Madam Chair. I just wanted, after listening to the conversation, I'd just like to weigh in on the side of local control here. A beautiful part of local control is that you have the ability to try out a lot of different options in a lot of different places, and those municipalities can all try and see what works in different locations. And when we centralize control, like we've been so inclined to do, if that is a bad decision, then that bad decision is promulgated immediately throughout. And the opportunity to recover from it is limited. So I think we need to trust our local governments. Say, you have the opportunity to to do what you're tasked to do, and stop thinking in terms of the state General Assembly being the higher level of intellect. Our local governments have the ability to govern themselves. And if they don't have that ability, they are responsive immediately to their community. So I think that government is best which governs least. I think the best thing that we can do is govern less and allow our municipalities, allow our counties, allow our cities, allow them to be just to try out different forms, find out what works for them, find out what works for rural, find out what works for cities, find out what works for that municipality, instead of taking a very limited scope, imposing it on the entire state, and then having to try to fix it for the entire state when it goes wrong once again. So if this is not something that's working in some of these municipalities, those municipalities have the ability to more directly affect their government, vote out those officials, and then try something else. You know, we just had it with another bill, I think 1208, and it was the thinking was that the state needed to step in and save Denver from Denver. And Denver's position was that Denver needed to save itself from the state. So this is no different, really. We need to let our individual municipalities make their own determination and stop trying to and just move outside the nanny state mentality where we consider this room the end-all be-all for good ideas. So our municipalities have a lot of good ideas. They have a lot of good people. If we're just going to override them on everything like zoning, law enforcement, then we might as well just disband all of them and then pass their decisions on to them. But if we're going to have a local government, the way our government functions, those entities should be left on their own. Thank you.
Is there any further discussion? Seeing none, the question before us is the passage of House Bill 1147 as amended, I believe. All those in favor, please say aye. Aye. All those opposed say no. No. 1147 is passed. Madam Majority Leader.
Thank you. Thank you, Madam Chair. I move to lay over Senate Bill 28 and House Bill 1203 until tomorrow.
Senate Bill 28 and House Bill 1203 will be laid over until tomorrow. Madam Majority Leader.
Thank you, Madam Chair. I move the committee rise and report.
Hearing no objection, the committee will rise and report.
The House will come back to order. Mr. Schiebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to report as under consideration the following attached bills, being the second reading thereof and making the following recommendations thereon. House Bills 1147 as amended, 1169 as amended, and 1201 as amended, passed on second reading, ordered and engrossed and placed on the calendar for third reading. Final passage, House Bill 1203 and Senate Bill 28 laid over until March 6, 2025.
AML, oh, over there. AML Bacon. Members, you have heard the motion. We do have an amendment at the desk. Mr. Schiebel, please read the Armagost Amendment to the Committee of the Whole report for House Bill 1147.
Representative Armagost moved to amend the part of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Armagost Amendment L8 to House Bill 1147 to show that said amendment passed and that House Bill 1147 as amended passed.
Representative Armagost.
Thank you, Madam Speaker. I move the Armagost Amendment, ask that it be properly displayed to the Committee of the Whole report.
It is properly displayed. Please proceed.
Thank you, Madam Speaker. So again, this amendment provides funding for legal representation of municipal offenders through the existing Colorado Public Defenders Fund. It ensures equitable access to legal counsel for indigent defendants in municipal courts, aligning municipal defense representation standards with those of state courts. And again, I ask for an aye vote.
Representative Mabry.
Thank you, Madam Speaker. Members, this is an unnecessary amendment that adds a big fiscal note to the bill. We're requesting a no vote.
Seeing no further discussion, the motion before us is the adoption of the Armagost Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
No.
Representative Lindsay votes no. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Representative Zokai is excused with a $6 fine. Please close the machine. With 23 aye, 39 no, and 3 excused, the amendment is lost. Seeing no further discussion, the motion before us is the adoption of the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Camacho Espinoza. Please close the machine. With 40 aye, 22 no, and 3 excused, the Committee of the Whole report is adopted. Members, we have some business to tend to. Mr. Schiebel, please read the reports of committees of reference.
Committee on Health and Human Services, after consideration on the merits, the committee recommends the following. House Bills 1204 as amended, 1213 as amended, 1279 as amended be referred to the Committee on Appropriations. House Bill 1223 be amended as followed and also amended be referred to the Committee on Finance with favorable recommendation. And House Bill 1256 be postponed indefinitely. Committee on Judiciary, after consideration on the merits, the committee recommends the following. House Bill 1212 be amended as followed and also amended be referred to the Committee of the Whole. Senate Bill 24 be referred to the Committee on Appropriations with favorable recommendation, and House Bill 1255 be postponed indefinitely. Committee on Transportation, Housing, and Local Government, after consideration on the merits, the committee recommends the following. House Bills 1207 as amended and 1247 be referred to the Committee of the Whole, and Senate Bill 6 be referred to the Committee on Finance with favorable recommendation.
Printing report.
The chief clerk reports
Printing
the
report
following.
will be printed in the journal. Signing of bills, resolutions, and memorials.
The speaker has
Signing of
signed.
bills, resolutions, and memorials will be printed in the journal. Message from the Senate.
Madam Speaker, the
Message
Senate
from
has
the
passed.
Senate will be printed in the journal. Message from the reviser.
We herewith transmit
Message
without
from the
comment.
reviser will be printed in the journal. Madam Majority Leader.
Thank you, Madam Speaker. I move that the following bills be made special orders on Wednesday, March 5th, 2025 at 3:09 p.m. House Bill 1109, House Bill 1185, and Senate Bill 39.
Seeing no objection, the bills listed by the Majority Leader will be made special orders on Wednesday, March 5th at 3:09 p.m. One announcement, members, Representatives Sirota, Byrd, and Taggart will be excused at such time as needed so that the Joint Budget Committee can meet. Representative Camacho. Members, seeing no objection, Representative Camacho will take the chair.
All right, colleagues, the committee will come to order. With unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee reports are printed in your bill folders. Floor amendments will be shown on the screen on iLegislate and today's folders on your box account. Bills will be laid over upon motion of the Majority Leader. The court rule is relaxed. Mr. Schiebel, please read the title of House Bill 251109.
House Bill 1109 by Representatives McCormick and Brown, also Senator Weissman, concerning the designation of a decedent's gender identity on the decedent's certificate of death.
Representative McCormick.
Thank you, Mr. Chair. Hope you have fun up there. I move House Bill 1109 and the committee report.
That is a proper motion to the committee report.
All right. In committee, we adopted 2 amendments to make sure that this bill could work with CDPHE and they could implement the bill effectively. The bill, and in that amendment, it creates a separate gender field in the vital records database and requires CDPHE to add gender field to the printed death certificate that families receive when a loved one dies. We also added clarifying language to specify that the individual that is completing the death certificate, it was very clear that it's the person actually completing the death certificate. And we made it clear that documentation memorializing a gender transition is to be provided to the individual completing the certificate of death, and that person does not have to go looking for it from the family. And I move L006 to the committee report and ask that it be properly displayed.
That is a proper motion, and amendment L006 has been properly displayed to the amendment.
Thank you, Mr. Chair. L006 will strike the misdemeanor penalty from the bill. We heard a lot of discussion around this particular portion of the bill. We want to make sure that the law is adhered to, but also recognize that a misdemeanor might not be the most effective or appropriate way to achieve that goal. And the primary focus of the bill is to honor and respect the gender of the deceased, as well as reduce the harm done to the transgender, non-binary, and intersex individuals in our families during a very difficult time. And it makes sure that the main goals of the bill are not overshadowed by a controversial penalty, keeping the focus on dignity and accuracy, and we urge an aye vote on L006 to the committee report.
Is there any further discussion on Amendment L006? Representative Garcia Sander.
Thank you, Mr. Chair. I'd like to offer a substitute amendment. I move a substitute amendment. I move L009 to HB 25-1109 and ask that it be properly displayed.
That is a proper motion. Amendment L009 has been properly displayed to the amendment.
I lost a copy. Okay. Sorry, I'm glad to see the amendment that was brought forth. So my amendment differs just a bit. So on, let's see. Oh, I'm looking at my bill. Sorry. Okay, so this bill amends and also strikes the misdemeanor, and there is a slight difference, and I don't have the other amendment in front of me to compare what's different. Sorry. So on this amendment, page 3 of the bill strikes line 11, strike 1E, 1F, and 1G and substitute 1E and 1F. Page 3 of the bill, line 13, strike identity hyphen misdemeanor. Page 2 of the report, strike lines 5 and 6 and substitute a colon. Page 6 of the bill, strike lines 21 through 23. It's very similar, but there are a few things that we're adding in this one. And I ask for an aye vote.
Representative Brown.
Thank you, Mr. Chair. We are interested in this amendment. We are still trying to figure out how it differs from our own. We would ask for a no vote at this point because we don't understand the differences.
Is there any further discussion on Amendment L009? Minority Leader Puglisi.
Thank you, Mr. Chair. I do just want to put on the record that we generally share all of our amendments. It would be really nice if the other side would also share theirs, and that would help alleviate these issues where we can actually come together and work on amendments that are substantially similar. So in the future, maybe we can continue to have those conversations before these bills come to the floor, and then we can collectively and collaboratively work on amendments that make bills better for the people of Colorado. So with that, I hope that the sponsors and my member have an opportunity to have this conversation about what is in the bill and how they can collectively make this better. Thank you.
Thank you, Madam Minority Leader. Your comment will be noted. Representative Brown.
Thank you, Mr. Chair. We still ask for a no vote. We would have loved to see this amendment ahead of time. Thank you.
Representative Luck.
Thank you, Mr. Chair. I'm just wondering if this or the other amendment were to pass, what enforcement mechanism is left in this bill? Is it just a statement of desire, or is there an enforcement mechanism for this?
Representative McCormick.
Thank you, Mr. Chair. So yes, there is still a penalty under current law, and in Colorado law, any person who willfully violates the provision or refuses or neglects to perform the duties required under Article 2, which has to do with vital statistics, is still subject to a petty offense. So this just lines up with all other vital statistic documents that is already in law. That umbrella of that part of statute covers this. So we don't need to add this, and it's consistent with how all vital statistics certificates are currently handled. And I would also like to respond to the substitute amendment. The only difference in this amendment versus our amendment is it's striking the word identity on page 3, line 13 of the bill that goes with gender, and it's important that those two terms are together to be consistent throughout the bill. So I urge a no vote on the substitute amendment.
Representative DeGraff. Representative Luck.
Thank you, Mr. Chair, for that, and Representative from El Paso County letting me go first. I'm just concerned. I have the pre-amended version, so presumably the one that includes the committee changes, and on page 3, line 13, it already has struck identity after gender, and so I'm curious as to the conversation that was just had and how that interacts. So it's right.
Representative McCormick.
Thank you, Mr. Chair. So since the amendment was to the committee report, and it's striking that line 8 on the committee report, which is what I'm looking at.
You're looking at.
It's not to the bill, it's to the committee report.
Okay.
The committee will go in a brief recess. All right, the committee will come back to order. Representative Garcia-Sander.
Thank you, Mr. Chair. I'd like to withdraw amendment L009.
That is a proper motion. L009 has been withdrawn. We are now on amendment L006 to the amendments. Representative McCormick.
Thank you, Mr. Chair. I just want to explain to all the thousands that are listening that we were actually all on the same page there. And the L006 accomplishes what we were all talking about the last few minutes. So I urge a yes vote on L006 to the committee report.
Thank you. Is there any further discussion on amendment L0? Representative DeGraff.
Thank you, Mr. Chair. There's just a question around a comment by the sponsor, because this is going into vital statistics, but my understanding is this is going to be different than how the vital statistics are tracked broadly at the national level. So how is this, unless this is a different box, and maybe there was an amendment that I missed in committee, but I thought this was the singular box, male, female, the chromosomal, heterogamic, homogametic. How is this
Apologies, Representative DeGraff. Are you talking to amendment L006, which is before us right now?
Yes, sir, because the sponsor mentioned that this is to correspond with the Bureau of Vital Statistics, and so I just wanted to know, are we going to be using the same classifications as the Bureau of Vital Statistics? Or, I mean, I suppose we can move that later on, or if the sponsor has an answer for it. I'm just curious how that lines up, because this amendment is supposed to be about...
Representative DeGraff,
yes,
what
sir.
I understood from that is what they were talking about, the discussion during committee, but it is not germane to amendment L006. Can you please... It is to the committee report, however. Could you keep your comments to L006?
Okay, it was to the comments by the sponsor, but I can ask I think I can ask the question at a later time.
Any further discussion on amendment L006? Seeing none, the question before us is the passage of amendment L006. Those all in favor say aye. Those all opposed say no. The ayes have it. Amendment L006 passes. To the committee report. Representative McCormick.
I urge an aye vote on the committee report.
Is there any further discussion on the committee report? Seeing none, the question before us is the Seeing none, the question before us is the passage of the committee report. Those all in favor say aye.
Aye.
Those all opposed say no. The ayes have it. The committee report passes. To the bill, Representative McCormick.
Thank you, Mr. Chair. So this bill and this policy change will have to do with having the decedent's gender identity on their death certificate. And this will help not only those family members that many of us have, but also individuals that have experienced this unnecessary obstacle in getting their legal documents. And it centers around how we honor the loved ones in our family, recognizing that throughout their life, respecting their identity is important while they're with us, but also after they have passed on in death. And this bill will ensure that that person feels secure, that all of their legal documents will be consistent and match their demographic information throughout life. And like I said before, it's not only important to that person, it's important to who they've left behind as well. And making sure that government documents are consistent also is logical and makes sense. It is important for receiving benefits for those left behind and for preventing fraud. Colorado has had the legal ability for people to amend their birth certificates for quite some time. We also have the ability to change our driver's licenses to match their gender identity for years. And the U.S. government also has the ability for passports to reflect gender. So creating that same continuity for that demographic information to be carried through on one's death certificate is now needed to make sure that they all are matching up for any particular person. The change in having the correct gender on a death certificate will not interfere with the Centers for Disease Control ability to collect important data
regarding various causes of disease related to biological sex or chromosomal makeup. We know that tracking important diseases, disease trends that have to do with genetic makeup is incredibly important for us to have scientific advancements in new treatment regimes, and we have to continue to supply that information to the CDC from the state of Colorado. And having your own or your loved one's death certificate marked with the correct gender is completely different and separate from the biological sex reporting data that State Vital Records Registrar reports to the CDC. So with this bill, Colorado can stay compliant with the CDC reporting requirements and provide consistency in gender identity for individuals. I also want to make it clear that this bill applies. We've had lots of discussions with our hospitals and doctors throughout the state, and I want to make it clear, and has been made clear with them, that this bill applies to the folks that fill out the demographic part of the death certificate data entry system, which is typically the funeral directors, funeral home directors. The doctors or the coroners, they fill out one part, cause of death and many other things. So this particular part is what will be filled out by the funeral home directors, and the information that needs to go to the CDC goes there, and the information that is printed on death certificates for families will have the needed information there as well. So I urge an aye vote on the bill. Very important to me personally, but also to many people that I know.
Representative Brown.
Thank you, Mr. Chair, and thank you to my good colleague from Longmont. I am so honored to be able to be a part of this bill and a part of making sure that people have dignity in their death. Colorado has led the way in affirming the dignity and rights of trans people and the entire LGBTQ plus community. And this bill continues that tradition. It's no secret that if you are transgender or non-binary, you face significant challenges in having your identity recognized in your life. And this bill makes sure that that identity is not erased in your death. Providing a clear process for gender documentation helps prevent family disputes and misrepresentation after death. We all have people in our lives who are trans or non-binary, and when those folks pass on, it is important that their memory, their identity continues to be affirmed in death as it was in life. I am happy and proud to stand with my colleague in support of folks and the recognition of their gender identity after death, and I would ask for an aye vote on this bill.
Colleagues, please, as a reminder, please keep all conversations down or move them to the side. Thank you very much. Representative Johnson.
Thank you, Mr. Chair. I move L008 to House Bill 1109 and ask that it be properly displayed.
That is a proper motion, and L008 has been properly displayed to the amendment.
Thank you, Mr. Chair. This amendment will strike the safety clause and move it to a petition clause, recognizing that what we are talking about is a sensitive matter and that we want to have all of Colorado be able to have their voice on this. We want people to have a say on what's happening in their state government. We are moving so fast in this state legislation, as we've seen today, where this got moved to seconds, and people who have jobs, who are living outside of this gold dome, cannot keep up with the speed in which we are doing things. We just heard this in committee last night, and we are on seconds today without notice until we are on the floor. We are asking for something as sensitive as this, something that's going to affect not just families, individuals, but businesses, how we operate, how we see things in the state. We are asking to allow all of the voices of Colorado to have the chance to have a say on this piece of legislation, which is why we do want to move it to the petition clause. Allowing this to be moved to the petition allows for a voice for all to have a say in their state government on issues that will affect more than just one sector of the state. It will affect, like I said, businesses. It will affect individuals. It will affect families. It will affect doctors. It will affect coroners. The list goes on. So let's make sure that we are embodying what we're supposed to do here, and that's to be a voice for all. I urge a yes vote on this amendment.
Representative Brown.
Thank you, Mr. Chair. I really appreciate my good colleague from the Eastern Plains and her commitment to making sure that every voice is heard in Colorado. It is extremely important that voters are engaged in the work that we do here in the Capitol, and I don't disagree with her intent. That said, people in Colorado deserve to be recognized in death as they live their life. I know that we will have people who will pass away, unfortunately, between now and the end of, and when this petition clause would go into effect. And so therefore, I will ask for a no vote on this particular amendment so that we can honor people as soon as this bill goes into law.
Representative Weinberg.
Thank you, Mr. Chairman. I appreciate you. I just want to rise in support of this amendment. I don't understand why we are afraid at times to put this back to the voter and make sure that they have a voice. It's really irritating coming down and listening to this over and over and over again. We should not have a problem with allowing the voter to be able to speak. I would urge an aye vote on this amendment.
Representative Soper.
Thank you, Mr. Chair, and it's mostly an honor to serve with you.
It is always an honor to serve with you, Representative Soper.
Thank you. Members, I also rise in support of this amendment. What I will say is the petition clause is appropriate in this particular case and not a safety clause. Safety clause are when we're talking about preservation of budgets, when we're talking about the health, safety, or welfare of the state, or perhaps in a certain change to criminal law for public safety. What we're talking about in this particular bill is changing death certificates to add gender identifying information on the death certificate. Information which, by the way, is not currently included on a Colorado death certificate. So to say that we need to immediately put this into force as law upon the signature of the governor, there actually has to be a change. There has to be a change first in the death certificates, and then this law has to come into force. So there's actually a natural delay element that has to occur anyways. So that's why a petition clause is incredibly appropriate here. The other reason for why it's appropriate here is no one's going to die if this bill doesn't pass. No one is going to lose their budget if this bill doesn't pass. But it is the first in the nation to have this policy change. And because of that, we should also give the public the opportunity to petition, to put it on the ballot, if there's members of the public who want to do that. Anytime there's a massive public policy change like we're seeing here, the public should have the opportunity to weigh in and to decide if this is a policy that they want to support or not. I will tell you, only twice has a bill actually gone to the voters through the petition clause since 1932. And in both of those cases, the people were unable to overturn the act of the legislature. So the risk is incredibly low here. That's why I would advocate that we should support this amendment and say yes. Thank you.
Representative DeGraff.
Thank you, Mr. Chair. All right. I'm at a loss to figure out what about this bill merits a safety clause. This bill does not deal with an emergency. Let's be honest with the citizens. They have a constitutional right to disagree with this. That would be the First Amendment. that if they want to petition their government for the recourse of grievances, they can petition the government. That's why we have a petition clause. That's why, in general, we need to, now, obviously, it's kind of a perfunctory thing because it rarely happens, but it could happen, especially when we're looking at imposing values on the majority of Colorado. So Article 5, Section 1, Paragraph 3 states that the legislation passed for the immediate preservation of public peace, health, or safety is exempt from the power of the referendum to overturn it by either signed petition of registered electors or the General Assembly. Now, perhaps there's a riot coming. I don't know. I would hope that we could discuss our differences a little bit more calmly. Health. I don't think anybody's going to die from being dead. Or safety. Whatever brought them to the point of having their name on a death certificate, safety is no longer an issue. This is an end run. It's an abridgment of our First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or the press or of the right of the people to peaceably assemble and to petition their government for a redress of grievances. Plural. Sorry. Other than a personal preference, the sponsor gives no justification. We do allow this for financial things and there are some times where maybe we stretch this a little bit, but now in this case, life, health, or safety around a death certificate. This safety clause is the antithesis of a safety clause. So right now we're just talking about the overall policy. This bill is about death certificates. There is nothing safety related to death certificates. We took an oath to uphold the Constitution of the United States and the Constitution of Colorado, which are founded on or built on the foundation of the principles that governments are instituted among men, deriving their just power from the consent of the governed. This is a law. This law, the safety clause, is about taking each individual one by one into the powerful hands of the government and imposing the value and saying, this is what you shall say. This is about imposed speech. This is about usurping. This is about usurping the rights of the living. This is about usurping the rights of the living for some sort of machination about life, health, or safety of the dead. This is compelled speech. So this is a violation of the First Amendment on other grounds as well. This is an assumption, and as the sponsor laid out, that this is a punishable offense. Now, reporting incorrectly to the Bureau of Vital Statistics, something that I don't know how it corresponds with the Bureau of Vital Statistics when this box is going to be ever morphing. I don't know why we wouldn't just remove it. If this box is going to be irrelevant, then let's just remove it. If it's a vital statistic, we need to look at why that statistic is vital. Why do we have statistics that say this is something that we need, and then we just go ahead and say, well, we're just going to fill it in with we're going to go from two options that are chromosomally based, XX, XY. I mean, they don't really look like X's or Y's, but you know, that's what they're called, XX, XY. Homogametic, heterogametic. Maybe I'm saying that wrong. But there's a very, very, very high correlation between the physical expression and the genetic reality. So what we're doing on the death certificate is it is currently annotating the genetic reality
Representative
as opposed...
DeGraff?
Yes, sir.
The amendment before us is whether or not to apply or to remove the petition clause, not the bill. Can you please keep your comments to the amendment?
Sure. So this law is about taking each individual one by one into the powerful hands of government. In this case, compelling speech. This is about compelling speech and molding the individual according to the proclivities of the sponsor. And the sponsor saying, I believe this. This is my belief. You will submit.
Again, Representative DeGraff, the motion before us is the addition of a petition clause. Can you please speak to the amendment?
Thank you, sir. It is about, and I'm trying to make my case here. We are covering, this is not about life, health, or safety, is the point. This is about imposing the preferences of the sponsors into compelled speech for the state of Colorado in a manner that is going to be very contrary to whatever happens at the federal level. Does the federal level, I mean, I don't know which, do we have an official version of the numbers of identities out there? Do we have an official idea? Because I've seen 90, I've seen 256. Which ones are on the Bureau of Vital Statistics? Why don't we just limit this instead of imposing values? Not everybody believes. Not everybody is in this camp. And you're asking people, you're demanding of people, under penalty of law, of risking their livelihood. So in the antithesis of this, antithesis of the safety clause, it's a demand. The reality is reality. Identity is not reality. Identity is not reality. So I object to having a safety clause on here as some imposition that life, health, or safety is somehow at risk of people who are already beyond life, health, or safety in order to impose on the very living rights of the citizens of Colorado in a manner that is going to be likely completely contrary. So we'll talk about the rest later. But if we're afraid to present a law for the consideration by the governed, absent of some truly emergent reason to preserve the public peace, health, or safety, it should be assumed to be in opposition to the consent of the governed. So if you're not even willing for the governed to look at it, I think it's safe to say that you're not interested in the will of the governed. And the purpose of this body, that to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed. So if you're going to step outside the consent of the governed, what you're doing is you're setting up an unjust law. So effectively, you're saying this is an unjust law, and I agree with you. But it's an unjust law just by nature of your demand of the violation of somebody's First Amendment rights. It is not a matter of safety. It's a matter of preference. Preference is not a valid reason for the use of the safety clause. This is not in accordance with any of the just powers allocated to us. This is a preference. This is a preference imposed on the citizens of Colorado by the Church of Woke. Today, we commit, so I would like to second this amendment or request that this amendment be passed and replaced with a standard clause to allow the citizens of Colorado to exercise their fundamental right, their foundational rights, even if they're not going to execute them, even if they're not going to exercise those fundamental rights, it is not up to us to override them. It's unlikely to petition the government for the redress of any potential grievances for which they would find with the good intentions of this edict, and it is an edict. It is a demand, it's directive, it's dictating, it's dictatorial. It's compelled speech, it's a fetter to liberty. It's not a matter of life, health, or safety. So in that regard, outside the intent of the bill, whatever the bill is that we're talking about, I object to the use of the safety clause because it's not about safety. It's not about the life, health, or safety of the citizens of Colorado. So take off the safety clause. Let's stop playing these games with the safety clause and recognize that the citizens of Colorado sent us here to represent their rights, to secure their rights, not to bulldoze them. That to secure these rights, governments are instituted among men. We're not here to govern, we're here to represent their rights, to protect them, to preserve them, not to override them.
Is there any more discussion on Amendment L008? Seeing none, the question before us is the passage of Amendment L008. We'll go into a brief recess. All right, the House will come back to order. The question before us is the adoption of L008. A division has been requested. All those in the chamber not entitled to vote, please sit and remain seated. All those in favor of Amendment L008, please stand and remain standing in one place, or raise your hand and keep it raised until the count is taken. You may be seated. All those opposed, please stand and remain standing in one place, or raise your hand and keep it raised until the count is taken. You may be seated. Amendment L008 is lost. To the bill. Representative Bradley.
Thank you, Mr. Chair. I brought this up in committee, so I'd like to bring it up to the committee of the whole. As a healthcare worker, changing gender on death certificates, what would happen? It's a medical and scientific risk. I talked to many healthcare professionals about this, and so I wanted to bring it in front of the whole body. Coroner and healthcare professionals emphasize that maintaining accurate biological sex data on death certificates is critical for public health, medical research, and epidemiological accuracy. The trend of changing gender markers on death records presents significant risks to scientific integrity, disease tracking, and healthcare policy. So why is this dangerous for science and medicine? You have a distortion of sex-based disease patterns. And since we're going to be the first state in the country to do it, let's talk about that. Medical research relies on biological sex to study disease prevalence, treatment responses, and mortality risks. Many conditions, including cardiovascular disease, cancer, osteoporosis, and autoimmune disorders, manifest differently in men and women due to hormonal, genetic, and physiological differences. So I'll give you an example. If a biological male who identifies as a female is recorded as female on a death certificate, it skews the data on diseases like prostate cancer or heart disease, which have sex-specific risks. This leads to false trends that may result in the misallocation of research funding and ineffective public health strategies. So if Colorado suddenly has an intake of men dying from ovarian cancer, we're probably going to have a problem. Compromise epidemiological tracking. Epidemiologists use mortality data to track and predict health trends. If death certificates reflect gender identity instead of biological sex, it disrupts accurate data collection, leading to flawed models of disease spread and life expectancy. Example, consider maternal mortality rates, and we have a ton of them, especially in rural Colorado. If a biological female who identified as male is classified as male on their death certificate after dying from pregnancy complications, I would say that's going to distort maternal mortality statistics and prevents proper policy interventions. Undermining genetic and familial health risks. A person's biological sex is fundamental in assessing hereditary health risks for their relatives. Death certificates serve as official records that help family members and doctors understand genetic predispositions to diseases. Example, if a biological woman dies of ovarian cancer but is recorded as male, her children and descendants might not be properly warned about their inherited cancer risk, leading to delayed screenings and preventable deaths. Inaccuracy in medical research and drug development. Many medical treatments, including medications and therapies, are tailored to biological sex due to hormonal, metabolic, and genetic differences. If mortality data is compromised, researchers may draw incorrect conclusions about drug efficacy and disease progression. Example, a new stroke medication may be more effective in one sex due to hormonal factors. If death certificates misclassify sex, studies could misinterpret survival rates and fail to optimize treatments properly. To preserve scientific accuracy while respecting gender identity, there was a two-tier classification system for death certificates. We said, have the death certificates include biological sex at birth for epidemiological, genetic, and research purposes. This ensures that sex-based medical data remains reliable and scientifically valid while preventing distortion of mortality statistics so that we all aren't in jeopardy of the inherent risks of what is happening in Colorado, since we're going to be the first state to try this out, and then add a separate gender identity field for social recognition. While gender identity is a social and legal concern, public health depends on biological accuracy. Changing sex on death certificates introduce severe risks to medical research, disease prevention, and healthcare policy. Implementing a dual-tier system protects both scientific integrity and individual identity, ensuring that medicine remains grounded in biological reality while addressing social considerations. And we brought this up in committee.
Representative Bradley, one second. Colleagues, if you could please keep your conversations down or move them to the side, we'd appreciate that. Thank you.
Thank you, Mr. Chair. And there is no reason not to do that. There is no reason not to have scientific research based on biological sex. You can still honor the dead by having a box for gender identity. And they just threw that to the wind. 2 doctors threw it to the wind. So I am now going to move Amendment L013 to House Bill 1109 and ask for it to be displayed.
That is a proper motion. Amendment L013 is properly displayed. To the amendment.
I think this should be redescribed as the Deception and Death Act, since we are now going to take away vital research. Let's call it what it is. I urge an aye vote.
Representative Brown.
Thank you, Mr. Chair. We ask for a no vote.
Representative DeGraff.
I was hoping for a little more justification. One of the things when I first saw this was the assertion that genitals don't equal gender, chromosomes don't equal gender, male-female doesn't equal gender. But now we're going to conflate all of those things, and we're going to say that is gender, or gender identity. And it's an identity, it's not something, it's a mutable characteristic, it's not an immutable characteristic. It's not, there are reasons that we have this box. There's a reason for it. And one of the first things you need to do is go back and we need to have a really good discussion about all the reasons why this box is there. Why are these statistics considered vital? If it's not a vital statistic, then why report it? You know, for so long, it was always heard about how women's health care was not issues, were not represented properly. And now we're just going to erase them. And the immutable characteristics of humanity. Now, of course, not all animals have the XXXY, but mammals do. And outside of a very, very small number, I think the geneticists in the room would agree that XXXY has a very high correlation to the physical expression of genitalia. And there's a reason that we've been tracking this vital statistic, and now we're just going to say it's not a vital statistic, so let's just leave it off. Let's just leave it blank, because you're saying it's meaningless. This box is now meaningless in Colorado. So whatever your preferences are, whatever the reason in the healthcare world, whatever other reasons that we have this vital statistic, I mean, if we're just going to say this statistic is no longer vital, then just get rid of it. Why report a non-vital statistic? So what we're talking about, this box, M/F, we could change it to XXXY if that's less offensive. I don't know. Then at least we would know what we're talking about. But if we're gonna make it irrelevant, let's just get rid of it. Instead of forcing your views onto somebody else and saying my views, my religion overrides your religion, my sensibilities override your sensibilities, and you must conform. So you're talking about sex on the death certificate. There are two sexes. There are two sexes. That's it. There are two representations because we're mammals. There's a reason for that box. There's value in that box until this bill goes through, then that box is meaningless. Except the only meaning that box has after this point is compelling the speech of another set of people. Of saying that you must conform to our beliefs. You don't want to conform to my beliefs, I don't force them on you. But you want everybody to conform to your beliefs. I believe there are two sexes, male, female. I can back that up scientifically. There's a box, male, female. You can look at that. There's value in it. This is a conversation that we don't need to have. It's certainly not one around life, health, or safety. So if you're going to put when you have a reality, male, female, that is the reality. Those are the two options when you're looking at sex, male, female. If you're going to put something else in there, you're speaking life. You can make somebody believe absurdities, you can make them commit atrocities. This is forcing somebody to adhere to your values. Outside of scientific reason, if you are offered, add another box. Add another box, gender identity. It can be one of however many you want. That was rejected. Rejected, and then so now taking the stance that, and taking this incoherent stance that sex determines gender. Now you're saying that sex does determine gender, but doesn't determine gender, so you're asking us to believe multiple things at the same time to adhere to your worldview. It's deceptive. So if you want to this is a good amendment in that because we are codified, this would be codifying federally that Colorado's death certificates, that vital statistic in the corner, male, female, means absolutely nothing. So let's at least be honest in our deceit and annotate it that, yes, we are in fact lying. You could have had a separate box that could have said whatever you want. I mean, why? Oh, I heard you. No, it's me. Okay. I'm just trying to figure this out. Why is it being demanded that we have these multiple simultaneous conflicting views of reality? We're talking about on a box, vital statistics, male, female. Now we're talking about box that's male, female, or, I mean, it's probably big enough for one letter, and now you're gonna have, I don't know how many. I mean, there's no limit. There's no limit to the number of identities, and some of them I've read are just being inhabited by a spirit of something. So I think this is at least an accurate way to represent that that Colorado is now going to be imposing a worldview, making their death certificates and probably most other documents completely useless.
Representative McCormick.
Thank you, Mr. Chair. I wanted to clarify for everyone. There's quite a bit of information that we've heard that actually what folks are saying is what's happening in this bill. There is another box when a person that is going to fill out a death certificate. There are several different people that engage in that process, and it's an online database system. And once a doctor, a coroner, or a funeral home director logs into the CDPHE database system, it will ask you, who are you? and then it'll bring up the part that you need to fill out in that, on that death certificate data input. And there is a box for male, female, the sex part, and that's important for all of the reasons you've just heard, tracking diseases that are associated with male, female chromosomal makeup. You're talking to two scientists here. We want to make sure that we track that information. It's important for development of new pharmacological agents and treatment options, all that stuff. We need to do that. We need to keep doing that. This bill does not interfere with that. It adds a gender box for when, and there's 3 options for that, not 100. M for male, F for female, and X as that kind of non-binary marker, just like we have on our driver's license and passports, et cetera. And we're not the first state to do this, by the way. I know I heard that a couple of times. We are not the first. And so just want to make it really clear that that data information that follows the person, if they happen to die of prostate cancer and their gender identity is female, that's important information for us to have. And actually, this is adding more information to data collection from the standpoint of, what kinds of disease things are we seeing in the transgender community or in the intersex community. It's important to be able to track all those details, and this will add even more details to that. So I wanted to clarify that part of it, that we're not eliminating a box, we're adding a box. And so back to the amendment, I urge a no vote on this amendment.
Representative DeGraff.
Okay, I want to be very accurate. I think that's what we're talking about, and maybe there's something I missed on it, and that's why we have these discussions. What I'm talking about is, I'm not talking about the online, we're talking about the death certificate. If the online portion wants to have all kinds of extra data, demographic data, that's why. So what I'm curious about is the paper death certificate that is presented, is that male, female, other, the actual paper document, the one that you don't need to have a online account or anything like that. That's what I'm trying to figure out from this bill. So if you want to have all kinds of other data, I'd probably be okay with that. I just want to know on the paper document, the one that you don't have to have a login for.
Attention colleagues, the question before us is the adoption of Amendment L013. A division has been requested. All those in the chamber not entitled to vote, please sit and remain seated. All those in favor of Amendment L013, please stand and remain standing in one place, or raise your hand and keep it raised until the count is taken. Thank you. You may be seated. All those opposed, please stand and remain standing in one place, or raise your hand and keep it raised until the count is taken. Thank you. You may be seated. Amendment L013 is lost. To the bill. Representative Johnson.
Thank you, Mr. Chair. I move L012 to House Bill 1109 and ask that it be properly displayed.
That is a proper motion, and Amendment L012 has been properly displayed. To the amendment.
Thank you, Mr. Chair. This amendment is the severability clause. So we've mentioned that this is the first, Colorado is doing this first out of the nation, and there are a lot of what ifs. Should the courts decide that something in this bill is non-constitutional, then everything in this bill would not be in play anymore. Should the federal government come down and decide to do something, that might take away our funding if we keep this bill, might strike some other things, might be in conflict with this. It's just to say that if something is in contentious with this bill, then this bill is no longer going to be active. Because we are the first in the nation to do this, I feel like it would be prudent of us to have this safety network in place to assure we're not going to spend a lot of taxpayer money that we do not have in a budget that we are trying to make cuts everywhere. To ensure we save money from the courts, let's be proactive and prudent and make sure that we have this clause in place. I encourage a yes vote.
Representative Brown.
Thank you, Mr. Chair. We asked for a no vote on this amendment. We appreciate the sponsors' commitment to having a conversation with us. We are not the first state to do this. There are 2 other states that have done this, and there are others that are working on it. So we appreciate working with our colleagues from the other side of the aisle, but we ask for a no vote on this amendment.
Minority Leader Puglisi.
Thank you, Mr. Chair. I'm curious, the bill sponsor just said there were 2 states that already had this. I was just curious what those 2 states were. But in addition, I think we all want to make sure the laws that we pass are constitutional, and if they're deemed unconstitutional, I don't see why the bill would exist. And so I think if we all want to follow our constitutional duty, we should vote yes on this amendment. Thank you.
Representative McCormick.
Thank you, Mr. Chair. I know that Rhode Island, Oregon, California, Arizona, those are some of the states. At least 2 of those have gotten it through. I can't exactly remember which ones. Also, death certificates are a state document and not a federal document, so we don't have to, we're not under federal jurisdiction. So I still urge a no vote on this amendment.
Is there any further discussion on Amendment L012? Seeing none, the question before us is the passage of Amendment L012 to House Bill 1109. All those in favor say aye. Aye. All those opposed say no. No. The noes have it. Amendment L012 is lost. To the bill. Representative Bradley.
Thank you, Mr. Chair. This is going well. I move Amendment L015 to House Bill 1109 and ask for it to be displayed.
That is a proper motion, and L015 has been properly displayed. To the amendment.
Loss of federal funding. If any provision of this act results in the state losing any federal funding to which it is otherwise entitled, this act is invalid in its entirety. The Director of Research of the Legislative Council of the General Assembly shall notify the reviser of statutes in writing if the director determines that the state has lost or will lose federal funding as a result of this act by emailing the notice. This will invalidate the bill if any provision of the bill results in the state losing funding. And I'll just remind you, since we are in a $1 billion budget deficit, some will say $5 billion, how much we receive in federal funding. $12.8 billion total in statewide federal dollars, $871 million Department of Ed. I'm pretty sure that's probably going to be cut. $9 billion healthcare policy and financing. Pretty sure that's on the chopping block. $600 million human services, $200 million in labor and employment, $325 million CDPHE, $860 million Department of Transportation. Gender identity is all through this bill, and we have a president who has said no more. So I urge an aye vote.
Representative McCormick.
Thank you, Mr. Chair. Luckily, we are a republic, and our state is allowed to do, we have our own budget, and this particular item is not tied to federal funding, and I urge a no vote on this amendment.
Representative DeGraff.
So now we're a republic. The beauty of a republic is, well, the difference is a republic will protect an individual from the mob, a democracy will feed him to it. So yeah, we are a republic. We have democratically elected representation. We also have things like the First Amendment that preclude compelled speech. So there is an issue still.
Representative DeGraff, the
Yes, sir.
amendment before us is a loss of federal funding, not the First Amendment. Can you please keep your comments to the amendment?
Well, my comments, sir, to the amendment are contingent on the First Amendment. This amendment are contingent on the First Amendment in our Constitution. So could I just have a little leeway to make my case?
Please proceed.
Thank you. So looking, and I think I have a good answer that I think, as I understand it, the death certificate would have, the paper death certificate would have an extra box. And that's a good thing. So we still have the useful box, and then we would have another box, a virtue preening box. But that other box also involves compelled speech. It involves telling somebody to represent something that perhaps they have an objection to, a moral objection to. And that could potentially end up being litigated. I don't know. So in a sense, this is an innocuous amendment because unless that box is contended, I think the federal would just look at it and say, well, you have an extra box on your death certificate, so we don't need to worry about it. But if that does become a matter of contention, if, say, a coroner has an issue and says, I do not feel comfortable, this does not comport with my conscience, this does not comport with what I believe to be right and wrong. I'm just hypothesizing here. I can't speak for everybody. I'm just taking this where we're looking at going, because then if the sponsors, again, if a good intention was a good idea, it wouldn't need a gun. This one needs a gun. It has enforcement behind it. It has I don't think there's any grandfather clauses in there so that somebody who wants to go in and be a mortician would be able to say, ooh, I don't want to go down that road. What you're doing is you're changing it midfield. You're not saying, okay, anybody that's already in that field is grandfathered. What you're saying is anybody in that field must conform to our belief system.
Representative DeGraff, I've given you quite a bit of leeway. I understand you have an interpretation of the First Amendment, but as you've articulated, that does not relate to the loss of federal funding, which is the question before us. Please stick to the amendment.
Okay, so if there's a lawsuit around the First Amendment, so I was just trying to explain why somebody might have a problem with this, why a lawsuit might arise. If somebody has a problem with this, and at the bidding of the sponsor, the law goes after somebody and says, you must do this thing to which you have a moral objection, to which you have a conscientious objection. And they say, you are fired. We are going to deprive you of your pursuit of happiness, of your property, of your way of life, for the purpose of comporting with our value system. It is possible that there would be a lawsuit around that because the individual would have lost their livelihood for the expression of their First Amendment rights because they violated the sponsor's preference. Not a matter of scientific fact, nothing immutable, something very mutable, something that can change on a regular basis. There could be a lawsuit around this. So if you take this, then the state is not at risk. If you do take this, it's really just saying, yeah, it's a matter of confidence. It's really a matter of confidence to say, I don't think there'll be a problem with it. This is just a safety, this is an escape clause if there is an issue with it. Because if there is a lawsuit around the First Amendment and the violation of the First Amendment leads to the deprivation or the denial of federal funds. Now, I'm not a big fan of federal funds and but we're in that situation. I was not a fan of federal funds and cowing to the federal system anyways, but here we are. So if there's a lawsuit around the First Amendment and that lawsuit leads to the denial of federal funds to which we've become subject, all this would do is say we'll be able to get out of it without taking this all the way to the mat. So I think it's a safe one to take because it doesn't challenge any part of the bill. It just allows the reality that that sanity might prevail. So let's just take this amendment and have that escape clause just in case. Doesn't say anything about the bill. It just is an escape clause.
Representative Bottoms.
Thank you, Mr. Chair. I do believe in this golden age of politics and America that we're already seeing things roll down from the top, and it was a little confusing and discouraging to me that it was said that we're Republican, we don't have to worry about federal funding, and that this is not tied to federal funding. Everything's tied to federal funding right now. Pay attention to the world scene. Pay attention to the scene of the United States. Everything is tied to federal funding. And when we keep doing silly bills like this there's no actual truth in the whole thing. It doesn't matter what they say. This is not a truth-based thing. And then on top of that, it is illegal to lie on a death certificate. I can explain that later when we get to the bill. But we're pushing a lie mentality. We're pushing a self-deception mentality, and that is going to roll down from the federal government. We're already seeing this. And so there are things, and when you say, well, this is not tied to federal funding, when you play games like this with truth and reality, and then you force it into the arena of law, now what happens is you are forcing the hand of the federal government to come down and say something. You're forcing this. So this bill will actually, and this is why the amendment, this bill will actually push against Washington, push against common sense of pretty much all humans. And then what will happen is federal funding will start to recede. We've already seen it in Colorado. We've already seen it. Denver Health came out with a statement about federal funding. And so we're already seeing it. And so this is directly tied to federal funding, and we're going to start losing our federal funding. But apparently in a republic, that's okay. And so it depends on what you want the budget to look like. It's going to be a lot worse than it is now. I urge an aye vote on this amendment, partly because this is kind of the law already, but we never, ever go by this in this House, ever. And so it'd be nice to actually have it written in a bill.
Is there any further discussion on Amendment L015? Representative DeGraff.
So just to follow up on the follow-up to my follow-up is that the purpose of government, to secure these rights, governments are instituted among men deriving their just power from the consent of the governed. In theory, we take a oath to that. Some of us mean it, but if you look at the federal level, and you look at the executive level, and you say, and that executive takes the action and says, and actually believes that the purpose of government is to secure the rights of citizens, among which is the First Amendment, and then having the ability to enforce the First Amendment as has been sworn, then federal funding is a really easy cudgel to use for a state that is denying the First Amendment rights. Now, would that have to be proven in court? I don't think it would even have to be proven in court. I think at this point, the person, the agency, the office that is in charge of executing the federal funds could look at that and say, the role to which I have sworn an oath is to secure the rights, to secure those rights, life, liberty, and property, the Bill of Rights, First Amendment, freedom of speech. This is compelled speech. This whole thing is about compelled speech. And there is a very easy way, not threatening, I'm just postulating why you might want to take this. You don't take this. You take this and it's a vote of confidence. You've taken this, you put this in the bill, it's a vote of confidence that nothing like this will happen. You reject this and the federal comes down and says, we think you're violating if the president, the executive of the United States in charge of allocating those federal funds says you are violating the First Amendment rights of the citizens of Colorado, then it is not only an option, but it would be incumbent to put a little pause on those funds until we have that conversation. That's all. That's all I'm saying. This amendment is to try to protect this state in the event that that would happen. So it wouldn't even have to be a lawsuit, because at that point, then the state would have to sue the executive of the federal to take that up and say that, no, it wasn't a violation of speech, and then it would be contingent on the state to prove that it wasn't a violation of speech, because the executive, in executing the federal funds, as far as I understand it, I mean, I went into engineering because I didn't want to do any of this stuff, that the executive would have that authority. And then the state would have to sue the executive to prove that this would not be a violation of free speech. So good luck with that. Let's hope it doesn't happen. This would preclude anything bad from happening. It would preclude you from having to come back here and void the bill if it did become a problem.
Representative Johnson.
Thank you, Mr. Chair. And colleagues, I just want to put the premise out there that I wish we could say local control would have most of the power. I wish state would have second power. And I wish federal had less power than it did. The way we currently operate, though, in the nation is that federal sets a guideline, and I say this having worked at both the federal and state level writing policies, federal states the basis of a guideline. And if we're not at that basis and we fall short, should this bill, for instance, fall short of what they're setting to us, we lose funds. And the federal can tell us whether we lose funds because it comes from death certificates and it only applies there, or they could tell us because we did something wrong, it cuts funds for federal across the board because the federal still has more power. I wish they had less. Again, I wish the state had more power than the federal. But the way Civics 101 is going right now is the federal sets the minimum standard. Sure, as a state, because we have that state authority and why we're called the United States of America, is we can set over that. We can go over regulations than what the federal sets, but if they tell us at a bare minimum this is where we have to be, and our administrative at the national level tells us this is where we have to be and we fall short, we lose funds. This amendment is just assuring that if that happens, we do not lose those federal funds because right now at the state, we are facing cuts. We cannot fund our own state and we're looking at where to take cuts. We will need those federal funds. This amendment assures that we will not lose those should, again, I'm saying should because we should be prudent and proactive, should our national level be it Congress, being it our administrative, be it our President Trump, tell us we have to set this minimum and we fall short, I don't have a glass globe that I can tell you what's going to happen, but I want to add this precautionary amendment. Should this happen, we are protecting ourselves as a state. I urge a yes vote.
Representative Brooks.
Mr. Chair, thank you. Look, I get it. I am not going to attempt to be as loquacious as some of my colleagues. I will lose those verbal Olympics. But I will tell you this amendment, this is a real thing. So I sat in committee and I was trying to, and I'm not going to get into the details of what I was trying to run, but it was a repeal of something that had passed last year. And I was told by a number of folks in the Democrat caucus that, hey, you know what? It's not that necessarily we don't like this idea. The problem is that we are terrified right now of what President Trump's administration might do. But I won't go into the specifics of the bill because it's irrelevant, but it was that there was a real palpable fear of what the Trump administration would do, and that basically we still needed to justify a $7 million insurance policy in case that some three-letter agencies were being dissolved. If we are truly afraid, if that was a legitimate argument in committee, if we truly feel like we're afraid of what the Trump administration might do, then why would this not be a very sensible, a very prudent insurance policy? You want to talk about safety clause, that's a safety clause. That's the safety clause right there. That if President Trump brings a tremendous amount of pain, that of which a lot of folks are afraid of, so afraid that we're willing to spend a $7 million insurance policy, it's kind of like the Phantom Menace from Star Wars, but if we fear that that's going to happen, then why do we not want to enact this safety clause to say if all hits the fan, that we have an out? Because folks, there's a reckoning coming. We cannot continue to thumb our nose the way that we have and not think that a reckoning is coming. If you're going to say that we need a $7 million insurance policy against something that we do not need, then we absolutely need an insurance policy in case of what happens. Loss of federal funding is a very real possibility, and it will be very painful. I know we've been able to operate here with a certain level of impunity for a number of years, thinking that we just do what we want, but I'm telling you that there's a higher power of which, and they are watching. They are watching, and they are going to hold silly rules, silly laws accountable. Why would we not want to ensure that we have an out in case that level of pain is brought to us? I would urge an aye vote on this.
Representative Brown.
Thank you very much, Mr. Chair. I certainly appreciate the spirited debate on this. I also appreciate the recognition by our colleagues that the federal government is contemplating severe cuts that will severely hurt Colorado. And I look forward to working with them to protect federal funding for things like health care and education that are being contemplated by our federal government right now. I ask for a no vote on this amendment. It is unnecessary.
Representative DeGraff.
Thank you, Mr. Chair. I think that mischaracterization is worth discussing. The Federal Agency for Fiscal Oversight, aka DOGE, is, oh no, I guess that wouldn't apply to that. Sorry, my bad. The federal level, the commander-in-chief, the chief executive, as elected by the people of the United States, has a duty, has a sworn oath to protect and defend the Constitution of the United States against, and as the military commander-in-chief, that is against all enemies, foreign and domestic. So what is in the Constitution? Well, in the Constitution, we have the First Amendment. If the executive has the idea that this could be a threat or a usurpation or a deprivation of the First Amendment, then the President of the United States is not only within his duties, but he is within an obligation to act. And there is no easier way to act than the withholding of federal funds. It's just the easiest way. That is, I mean, that's why all debate aside, but that's really why the federal government has gotten states hooked on federal funds. And we should take that, if we're concerned about federal funds, then we should probably have that conversation that we don't want to be hooked on federal funds. But this is not a matter of the president, of the chief executive executing the obligations of his office and then depriving it. It is a matter of this body choosing whether they want to risk the perception of violating the First Amendment, of violating somebody's free speech. And if there is a possibility of this being perceived, perception is reality until there would be a lawsuit around it, I'm sure. But that's a matter of time that goes around it. So it's not a matter of the president, of the chief executive. If the chief executive makes a determination that he's compelled to act to protect the First Amendment rights of the people of Colorado, then the president is compelled to act. All this amendment does is saying if the president feels compelled to act, and I'm not saying it is necessarily, I have not determined it. I don't know, maybe we've run it past the Supreme Court, Colorado Supreme Court. Maybe they've already given us a determination that there's no way on earth that this could be considered compelled speech and a violation of the First Amendment. Taking this amendment is confidence. Taking this amendment is confidence in your position. If you don't take this amendment and then it's declared, it's just considered, even if it's just an opinion of the chief executive. What we're doing is we're trying to ask you to keep this funding in place for Colorado. It's not us that's risking the federal funding of Colorado. It's not the Republican side risking the federal funding. It's our Democrat counterparts who are risking the federal funding. I don't know if this would be considered a First Amendment violation, but the compelled speech around gender identity has been considered by many to be a matter of compelled speech. And if it's compelled speech that we're putting in an official document and you're requiring somebody at the risk of their livelihood to document in violation of their conscience, you could find yourself at risk of violating the First Amendment. And if you're violating the First Amendment and you have a chief executive sworn to uphold the Constitution and protect all of the rights of the people of Colorado and all the other states, and this finds itself in violation, this is just the safety clause. It doesn't impact the bill one iota. It's just saying that if you get out in front of your skis on this one, that maybe you don't face plant. Maybe you don't have to come before the General Assembly and ask and plead, because we're talking about billions of dollars that you could be putting at risk. Not us putting at risk. It's not us putting these funds at risk. We're trying to stop you from putting these funds at risk. So people of Colorado, if the federal government comes in and says this is a violation of the free speech of Coloradans, or any other state that this would comport with being considered compelled speech, we are going to withhold these funds until Colorado is back in recognition of the values of the republic, because we talked about that we're a republic. That we would not be in violation at risk. So if these funds dry up for whatever reason, and I hope not, because we need them, because we have seriously overspent. By we, I mean you. Put the safety clause in there. That is just, it's a relief valve. Anything you would have, you would put you would put a relief valve. You would put some sort of escape mechanism in. We are asking you to not put our federal funding at risk. The Republican Party is asking the Democrat Party to not put our federal funding at risk.
Representative Bottoms.
Thank you, Mr. Chair. So my colleague just said a lot of what I was going to say, so I'll simplify it. This amendment is to try to keep federal funding. And the sponsor, I was confused by the sponsor's statement, but he said maybe we could talk about how to make sure we keep federal funding. We'll start with removing this bill or putting this amendment in it. And I got about 150 more to follow because our federal funding is going to be in jeopardy. So you say, well, is federal funding going to be taken away? Keep running bills like this and find out.
Representative Bradley.
Thank you, Mr. Chair. I'm going to echo that. I ran this amendment to try to maintain the federal funds, and now I'm kind of getting admonished for running it because we're going to lose federal funds, so I can't keep up. I just wanted a little bit of leniency since the bill sponsor brought a couple things up. We've introduced several bills this session, over $250 million of money for fiscal notes. We're $1 billion in debt. We have $250 million in fiscal notes in bills we've introduced this session, and we're $1 billion in debt. And now we're blaming the federal government for our deficit. Medicaid unwind was a disaster in this state, so now we're telling hospitals to pay for safety net providers that is going to affect rural Colorado. And the only thing that keeps us completely from overspending is Tabor. And then we blame Tabor for the inability to have nice things. So let's just look at crime and homelessness and roads and healthcare in our state. We cannot afford for federal funds to be taken away. We are risking federal funds in this bill, not Brandy Bradley's bill, this bill. I have put forth an amendment so that doesn't happen. And we are going to draw the line in the sand, by golly, on this bill. And I just read to you the billions of dollars in federal funding that is going to be taken away. Because Colorado is front and center with the federal government right now. I mean, our mayor's there right now visiting, having a little show. If the federal government takes the funds away from CDPHE regarding this bill, they would lose 80% of fully funding their department. That's just one department in the state of Colorado. They would lose 80% of their funding, one department. We are playing Russian roulette, and my party is not going to take the brunt of that accusation. I urge an aye vote. Thank you.
Representative Richardson.
Thank you, Madam Chair. I rise in support of this amendment. The first rule of holes is that when you find yourself in one, you stop digging. Our colleagues in the JBC are not here because they're struggling with the 750 million-ish, whatever the number is today, shortfall we have because we took one-time federal money and used it to start ongoing programs. Why we would risk cutting off future federal funding for ongoing programs, especially in healthcare and human services, I cannot understand. I would say this is an important amendment. It must be passed because it takes the shovel out of our hands if we think we're going to keep digging ourselves deeper into a hole. So I do urge an aye vote.
Representative Brown. Okay, any further discussion on the amendment? Seeing none, the question before us, the question. Members, it has been requested that. We're going to hold on. Go to recess. The question before us is the adoption of Amendment L15. A division has been requested. All those in the chamber not entitled to vote, please sit and remain seated. All those in favor of Amendment L15, please stand up and remain standing in one place, or raise your hand and keep it raised until a count is taken. You may be seated. All those opposed, please stand and remain standing in one place, or raise your hand and keep it raised until the count is taken. You may be seated. L15 is lost. To the bill. Representative Richardson.
Thank you. Thank you, Madam Chair. I absolutely appreciate the work of my colleagues in bringing this forward. I don't like the bill. There's a lot of bills that come before us that I don't like. But I do think the process is very important. So I appreciate the amendments that were passed during committee. As it was written, I do think I would have had very strong objections, but since we've maintained the biological sex box on the form, it still has great value in terms of medical research and epidemiology. But the concern I now have is the fiscal note under assumptions on page 3 assumes that CDPHE will update the sex field rather than create a new field for gender on death certificates in the same way that birth certificates are managed under current law. The amendment that was passed in committee states that on or before January 1st of 2026, the Department of Public Health and Environment shall add a gender field to the certificate of death, which violates that assumption that's in the current fiscal note, and further requires an update of the electronic death registration system. So I do believe the fiscal note needs to be updated. There will certainly be a cost associated with this, so I would move that this bill be sent back to appropriations with an updated fiscal note to determine what its fate should be there. So, thank you. I have
Representative
fiscal note
McCormick.
February 28th of February 11th.
Representative McCormick.
Oh, sorry, I didn't hear you. Thank you, Madam Chair. So we did double check on this fiscal note, and the department assures us that the vendor that manages their database system can easily update their database system by adding this box, and it's not going to cost a thing. So this is accurate. We've double checked, and there's no reason for this bill to go backwards.
Representative Luck. Representative Richardson.
I'm very happy that we have identified a source of free lunch in this state, but I do believe that nothing is free, and a fiscal note should be updated. But thank you.
Representative Luck.
Thank you, Madam Chair. So I have been having long conversation with the bill drafter and reading through the statute book quite a bit. There's some confusing terms in here from my standpoint because there's a difference between certificate of death and verification of death document, and neither of those are clearly defined. In the bill, different things are applied to different sections, and so we do have, as has been discussed, this new language that was added in during the committee report related to adding a gender field to the certificate of death form. And I believe that the word add means add, not replace the sex field with the gender field.
Representative Luck, excuse me for the interruption. Are you talking about the motion to refer this to appropriations? No. Okay. That's okay. If we can just acknowledge the motion, there has been a motion made to refer House Bill 1109 to the Committee of Appropriations. All those in favor say aye. Aye. All those opposed? No. Motion fails. To the bill, Representative Luck.
Thank you, Madam Chair. And for everyone listening, she was not gaveling me down, which is exciting. Okay, so I'm not going to repeat what I had just said for sake of time, but I will just note that with respect to the certificate of death, I do think that this language is sufficient to say add a gender field. And while statute does not specifically say that there has to be a sex field, because under the vital statistics law, there is just broad rulemaking authority and the ability to execute what actually is included on these death certificates. And so we don't actually have a place, as I understand in this section, to speak specifically to what is included on the certificate of death. This is new language that's being added in here as relates to the certificate of death. Now, that is not the same thing. It's not the same vis-a-vis a verification of death document, which is distinguished in Section 2 of this bill, page 3. Under that section, we are considering adding in the language, the gender of the decedent, to this sentence. A verification of death document must include the name and address of the decedent, the date of death, the place of death, and then add in that the gender of the decedent, the date the document is filed, the state file number, and the name of any spouse of the decedent. In order to make sure that all bases are covered and we have the right information on all documents, whether they be the certificate of death or the verification of death document, I move amendment L16 to House Bill 1109 and ask that it be displayed.
The amendment is properly before us. Please proceed.
Thank you, Madam Chair. All of this amendment does is confirm what the bill sponsors have said is their stated desire for the state of Colorado to collect both pieces of information, the gender identity and the biological sex. This just makes sure that we have that not only on the death certificate, which is covered by that amended language from committees, Section 3, or 25-2-113.9, but also under the verification of death document. That way we cover all of our bases and we have the requisite information so we can get the right statistics to be able to make good decisions on policy moving forward. And so I ask for an aye vote.
Representative DeGraff.
Thank you, Madam Chair. All right, so I appreciate my colleagues' attention to detail because that could have easily been missed. It's on or before the whatever date, the Department of Public Health and Environment shall add a gender field to the certificate of death form of the and to the electronic death registration system that is required to be utilized by a qualified individual. And since it is not a federal form, it could be easily jotted out to say, it could easily be read as changing that sex field to a gender field. Or, because there's nothing, I suppose, if it's a state form, there's nothing that says you must keep the sex field. So you could easily remove the sex field and then add the gender field. So there's no accusations, I don't think, in my colleague's amendment. Just a clarification to make sure that we don't end up having an official document that is not useful effectively for a lot of things. Because otherwise you'd have to go and everybody would have to go and instead of looking at just the paper, the hard copy, you would have to go into the electronic database in order to find that data if it was useful to you. So this just clarifies adding instead of replacing. So I support it. I suppose I suspect the sponsors will also support it. Otherwise, it would be an indication that they would be okay with the switcheroo, as it were. So I support this amendment. Thank you.
Any further discussion on the amendment? Seeing none, the question before us is the adoption of Amendment L16. Representative McCormick.
Thank you, Madam Chair. Just want to be clear, sex is still recorded. Both are sex and gender are included in the database. Sex is in there because of the requirement to report to CDC, and that is still there. We are requiring gender to be printed, and that's what we're asking for here. So sex is still recorded. We won't lose federal funding because of that, and we ask for a no vote on this amendment.
Representative Luck.
Thank you, Madam Chair. So again, there are contemplated in this section of code right now, there is a certificate of death, one document, and a verification of death document. There are no definitions in code as to what those two things are, how one is created and one is not created. I've talked to someone who runs a funeral home on this, and we have tried to work through what this means and what these documents, the distinctions between them are. We are struggling to do that. So what I'm just trying to do is make sure that the law is clear that regardless of the document, whether it's the death certificate or the verification of death document, that in both we are recording not only the gender but also the sex, the biological sex, so that we're getting the requisite information. So the verification of death document has been given, it says may be used by local offices of vital statistics and the state registrar. Presumably the local offices of vital statistics, you know, we want them to have the same information that is on the death certificate. All I'm trying to do is make sure that we are capturing both documents. On page 3 in the current bill as drafted, the bill sponsors are capturing the verification of death document, and on page 7 of the pre-amended version, the bill sponsors added in during committee that language related to gender into the death certificates to make sure. I just want to be clear that we should have it in both places. So I continue to ask for an aye vote to make sure that there's not any sort of administrative mishap such that we're not actually recording in both places what needs to be recorded.
Representative Bradfield. Representative McCormick. Representative DeGraff.
Thank you, Madam Chair. I'm just getting a little bit of a complex. All right.
Hey, Representative DeGraff, cool it.
Yes, ma'am. But I digress. Okay. It's just a simple amendment. We just want clarification that the paper document, and we can actually say it right here. You could even say it without the amendment because this is recorded. So let me just check, make sure. Page 3, line 21, after decedent, and I've remembered after the gender, the descendant of the decedent, insert the biological, the sex of the decedent is filed. So what we want for the protection of the document, the hard copy of the document, because we do have paper copies of documents in order to back up the electronic database. So when the zombie apocalypse comes and we lose all of our database, then we could go back and we could recreate civilization by bringing out our death certificates. So this is just to say, on the paper document, now this actually doesn't address the federal funding part, because the federal funding part would actually be part of whether it was deemed by the president to be a violation of an individual's First Amendment rights to have to state something which is a violation of their conscience, if it was a violation of their conscience. And I can't speak. It would be a violation of mine, but I can't speak to somebody else. So all you have to do is come up here and say the intent of the bill is that on the paper document, in addition to the electronic database, that we intend, I mean, it'd be just as easy to pass this, but we intend for there to be an additional box. One box for sex, one box for gender identity. Because it has been stated very clearly, very often, whether correctly or in, that gender identity and any physical attribute have nothing in common. So this is just asking to make sure that the immutable characteristic of the individual is recorded on the death certificate and the mutable characteristic of the individual is and the way the ideology has been presented is that those two are completely non-related to each other. So it would be no different than having the name on the document. It would be no different than having the address on the document. It's just a matter of indicating what is the chromosomal characteristic of this individual and what is the gender identity. Unless you're saying that those two are conflated, then, well, if they're, so all you have to do is say, let's say, take this amendment, or just very clearly state that the intent of the bill is to have both the sex and the gender identity annotated on there. Otherwise, I think we can assume, well, we can assume then whatever we want to, but at that point, then we could probably presume that the intent, if you can't say that the intent of the bill is to have a field for both on the printed document, I think we can then presume that the intent is for it to have one and change it. So that's all we want. So just, you could speak it to the record, we could go back and find it, say the bill sponsor said the intent was to have one box each. That's all. Otherwise, it's a presumption and a compulsion. It's even more of a compulsion if you eliminate the other one, because then you're saying that is the primary characteristic of the individual. So I think a yes vote on this amendment just makes sense, clarify the intent of the bill. I guess you'll be clarifying the intent of the bill either way. One towards truth, one towards duplicity. I hope you'll clarify the bill in the direction of truth.
Members, please keep it down. Representative Bacon.
Thank you. I just wanted to respond particularly to, I think I heard duplicity or duplicitousness. What is already occurring is a box to check for sex. What the bill is doing is adding a designation for gender. And so what I believe this amendment does already exists. But I also I want to be sure that this is not suggesting to be antithetical to what the purpose of the bill is, which is to record gender. The way it works right now is upon death, there is a box in the database to click for sex that gets sent off to like the CDC and whatnot, and gender gets placed on the certificate. So if the intent is to write it down, we would argue that that's already actually happening. And what the bill is doing is adding, unless the purpose of this amendment is to eliminate that addition. And if that's the case, we would vote no, but still urge a no vote.
Representative Luck.
Thank you, Madam Chair. So as I understood the representative from El Paso County, I think he was referencing duplicity in terms of my amendment and arguing that there was nothing duplicitous in it. Obviously, he can speak for himself, but that was the way I understood this. Again, I just want to make clear, contemplated under the language of this bill are two separate documents, or the potential for two separate documents. One known as the certificate of death, and one known as a verification of death document. The current bill touches on both of these documents. In one section, it is verification of death. In section 2, it talks about adding the gender of the decedent to the verification of death document. And in section 3, it talks about adding gender to the certificate of death. Now, under the certificate of death, we understand that not by statute, not by statutory requirement, there's not this list of all of the things that need to go in to the certificate of death, that already by rule, there is a field that says sex. I am personally comfortable with the fact that this language says add to what is already in existence. Add to, not subtract from, not replace, add to that form gender. So I am confident that the certificate of death by this bill will have both gender and sex. What I'm not confident of is the verification of death document. The document that, according to this section, says may be used by the Offices of Vital Statistics. That I am not confident that that document will have the same set of information, because that document, the verification of death document, actually does outline what should be included in it in statute. It includes the name and address of the decedent, the date of death, the place of death. By this bill, the gender of the decedent, the date of the document is filed, the state file number, the name of any spouse of the decedent. All I am suggesting is that we add into that list on this document the biological sex too, so that both of these documents, wherever they go, however they're created, have both sets of information so that we have the requisite data fully covered. That's all I'm trying to do. So I continue to ask for an aye vote. I appreciate your patience as I try to explain this. Thank you.
Representative Bacon.
Thank you. I just wanted to see if I understand. Are you saying that sex and gender are different and you're asking for both of those on the death certificate? Is that what you're proposing?
Representative Luck.
Thank you, Madam Chair, and thank you for that question. So, yes, but more. Okay, so, you can, I won't bite, I promise. What I'm saying is that according to the way this is written, there's a certificate of death. There's also a verification of death document. Two separate documents, not defined in statute as to where they come from, how they're, right? I'm trying to work this out with the bill drafter as well as someone who is in this space as a funeral, in this space of doing these things. Under this bill, the verification of death document is including in the list of things that have to be added, the gender of the decedent. Also in this bill, under the death certificate, the certificate of death, we are adding in gender. Under this one, it's an add-in of the gender field, right? Add a gender field to the certificate of death. That means that the certificate of death, which currently exists, will have what currently is on it, which includes sex. And under this bill, they'll also have to add in a new field for gender, right? So certificate of death, good to go. What is not clear is the verification of death document, because this document lists out, unlike the certificate of death, in statute what has to be included. And in the verification of death document, sex is not included, and yet we're including gender. All I'm asking is that in the verification of death document, we also include sex, so that both documents have it, because I don't know, and other people who are reading this don't know which one is used where, but the verification of death document, according to the statute, is the one that the vital statistic offices can use. So I just want to make sure that everybody has the right information that they are requesting, needing, what have you, that both documents have both gender and sex. Does that make sense?
Representative Bacon.
So then you're saying the verification of death document would then include the gender of the decedent, comma, and the biological sex of the decedent. You want both things noted on the form.
Representative Luck.
Thank you, Madam Chair. And yes, that's what I'm saying, and that is my understanding of what the bill sponsors are trying to capture, which is why on the certificate of death, they have already included that field.
Any further Representative McCormick.
Thank you, Madam Chair. I'm going to ask for a title challenge on this amendment.
The committee will stand in brief recess to discuss whether the amendment fits under the title. The committee will come back to order. The committee chair rules the amendment does not fit under the title. To the bill. Representative Luck.
Thank you, Madam Chair. Well, that is problematic in light of the conversation that has filled this chamber for I don't know how many hours as relates to this very question and the fact that the bill sponsors assured us multiple times that this whole conversation related to these two things was well in hand and that we were able to address these fullness of issues. Yeah, thank you.
Representative Bradley. Sorry, Bradfield. Forgive me, Representative Bradfield. For misnaming her.
Thank you, Madam Chair. I have been sitting on this wooden bench ever since the first words were spoken on this bill. And were our state not so badly in debt, I would recommend that a cushion be applied to both of the benches for people who have to sit there for a couple hours waiting for their chance to speak.
I concur.
Okay. In this last several hours, we have had amendments that could have helped this bill and could have made it much better, but they were rejected. And that is too bad. And that brings me to, Madam Chair, I'd like to move Amendment 011 to House Bill 1109 and ask for it to be displayed.
The amendment is properly displayed. Please proceed.
Okay. If you will look at your bill, you will see page 2, line 1 is the enacting clause. And of course, everything following the enacting clause would be eliminated, stricken. I ask for an aye vote. Thank you.
Representative DeGraff.
Thank you, Madam Chair. I concur with this amendment. I think this, I'm okay with thinking there's a lot of, there's some good intention behind this bill, but I think there's a lot that needs to be thought through. And I mentioned it earlier today that we started off the year with a couple very panicked I told you so's. We tried to make amendments. The amendments were declined. And then we had to go into like emergency consideration. You know, we've tried to avoid this issue of compelled speech by the Colorado General Assembly of the citizens of Colorado. I mean, in this case, in the case of the previous amendment, I don't know why I wasn't there for the title transfer, but it was a pretty challenge, but it was a pretty basic suggestion. And the sponsors could have clarified the issue by just stating that the intent was in fact to add in addition to, not add in place of a subtraction. Because there's nothing that said there was nothing that couldn't be subtracted first and then added to. So that was all that was asked for, is just some clarification that the paper document would still have some anchor to reality. Instead, there was just a lot of obfuscation, which is never a good sign. So I think we've brought up a lot of considerations. I mean, it's amazing how much time that we've spent here when the people of Colorado are wondering why we're $3.5 billion in debt. But even this very simple idea could turn out to be very problematic.
Representative DeGraff to the amendment, please.
Just want to make sure which amendment you're on. But the only way we can make this bill less problematic at this point is just to accept the amendment. And then we'll have the title, and then we'll be able to just remember it fondly as a good intention that wasn't a good idea.
Any further discussion? Representative McCormick.
Just wanted to let everybody know that we urge a no vote on this amendment because it strikes the enacting clause, which means there is no bill. So please vote no.
Is there any further discussion on the amendment? Seeing Representative Richardson.
I think we can generally assume that the dead are beyond offense. They cannot be offended any further. Misgendering them or not noting their gender on a death certificate is meaningless to them. To be offended on their behalf is hubris. Striking the enacting clause on a bill that does nothing to start with, that really has no impact on the dead, that apparently we're trying to protect the sensibilities of, is appropriate at this point. And I do think it is a good amendment. It gets rid of a bad bill. And I urge a yes vote.
Representative Bottoms.
So I do urge an aye vote on this amendment. Let me tell you a little Larry Don story. So my mother passed away summer of 2020. We had just jumped into COVID, and the fake pandemic was raging large, and people were making money like crazy on this thing.
Representative Bottoms, please do your best to stick to the amendment.
Yes, oh yes, I'm sorry, this is to the amendment. So when my mother passed away, when the nurse that was working with the doctor on the death certificate, then the nurse calls me up and says, Mr. Bottoms, we have the death certificate right here. And she had died in rehab, in a rehab building, but she had kidney failure and she was on dialysis, a lot of things like that. And so the nurse calls me, and my dad is sitting there, and he has dementia. It was early onset at that point. And she says to me, we have the death certificate here. It's all signed and ready to go. We need to know where to mail it to. And I said, if the death certificate says COVID on it, I am going to sue everybody, and I'm going to own the doctor, I'm going to own the rehab center, and everything else. Because why? It is illegal to lie on a death certificate. Some kind of gender creation that happens in somebody's mind is not truth. That is lying on a death certificate. It doesn't matter what people want to say or how they want to identify and all that stuff. Rational people do not accept this precedence. And so I mentioned to the nurse that I will sue everybody and own them all. And she said, oh, I'm sorry, Mr. Bottoms. I will get back with the doctor and we will have that changed. Because even though she died from kidney failure, they lied on the death certificate and said it was COVID. That's why they had to change it back, because my threat was not an empty threat. I would have owned that rehab center. Because you cannot lie on a death certificate. When somebody uncovers a body 500 years from now, it doesn't matter what a death certificate says when it comes to some kind of fake thing called gender. You can look at the skeleton and you know whether it's a male or a female, because those are facts. That's truth. We run around the truth in this building constantly to come up with these very strange, weird ideologies, and then we force them upon the people of Colorado. It is against the law to lie on a death certificate. I saw it happen. Why? Because that rehab center would have got $47,000 for doing that. That's why they did that. I don't think that this bill is trying to get $47,000. I think it's a complete ideological thing that has covered people's eyes, and they actually do believe this stuff. I do feel for them because I do put that in the category of mental health issues. Now, this is where we have to somewhere say, when do we stand up for what is right and what is true? This strike below needs to happen. This bill needs to go away, and we've already discussed the fact that this will put federal funds in jeopardy. It will. So at what point do we just do the right thing, the sensible thing, the common sense thing, the truth thing, and we do away with this? And so I do strongly urge, and I vote on this amendment. We just need a strike below to happen here.
Further discussion, Representative Bottoms?
I do have further discussion.
I thought you might.
Good guess. Thank you. So, point 2. I really don't understand this, and I know this, and I know that this is just me saying this, and most people will dismiss this out of hand and say this doesn't matter. But this does fall into the category, and this is the pastor part of me speaking to this amendment. This is the pastor part of me that says that the Bible actually tells us that in the last days, people will believe a lie. That means they voluntarily choose to believe something that they know is not true. And this is what we're dealing with right here. We're dealing with, I am voluntarily choosing to come up with something, create a false narrative, and then, sure, there are people to believe that. This is the thing that truly confounds me, is I really do come across people that actually believe this stuff. But most don't, and we see that statistically in so many different analysis or research tools that people really are not believing this stuff. But then we actually legislate from this, and this is where it gets very bizarre. Is we take just a creation. It's literally like smoke and glitter, and we come up with something that is completely a false narrative. It has no bearing in reality, has no bearing in science, and then we legislate from this arena. And this is the part where it gets egregious. Anybody can believe anything they want to at any particular time. That's their right. It's their choice, and it's not my place or anybody else's place to make them believe something. I've learned that over the years as a pastor. You can't make anybody believe anything. But I also don't have to buy into this and make it worse by enablement or by some kind of transference mentality. I have to stand on what is truth, and this is a false narrative that's been created, and now we're mandating it with a law, with a bill that puts it on official documents. It may not be federal documents, but the federal government will need access to these documents sometimes. These are state documents. But even if it's state documents, we still have laws that say you can't lie on state documents, and specifically a death certificate. You cannot lie on a death certificate. And this is what we're doing. And here's the weird, bizarre part, that when I just spoke at a high school recently about some of this kind of stuff, and they were asking me different things, and they said, what is one of the most difficult things that you deal with in the House? And I said, we look blatantly at lies and falsehoods, and we call them truths. That's one of the biggest things that I struggle with in this building, is we all know they're not true. We all know this is not a real thing, but it's the emperor's clothing kind of mentality. We all go along with it. And I don't understand it. It has always confused me. I just think rational thinking should be the rule of the day for adults, but we prove constantly in here that's not the case. Hold on while I clear my throat. Okay, I feel like I've said it. So please vote yes on this amendment.
Further discussion on Amendment L11. Seeing none, the question before us, a division has been requested. Before us is the adoption of Amendment L11. A division has been requested. All those in the chamber not entitled to vote, please sit and remain seated. All those in favor of Amendment L11, please stand and remain standing in one place or raise your hand and keep it raised until the count is taken. You may be seated. All those opposed, please stand and remain standing in one place or raise your hand and keep it raised until the count is taken. You may be seated. The amendment is lost. We are back to the bill. Representative Luck.
Thank you, Mr. Chair. So for those just tuning in to today's soap opera that we have just named as the gavel drops, I had just recently proposed an amendment in good faith, believing that it was going to clean up and ensure the intent that the sponsors have said up here that they have related to this, and to give comfort to my caucus that indeed this information will be collected. Now, it was determined that my amendment was not to the title, and so I think it's only fair to ensure that the whole bill is only to the title. Now, the title says, concerning the designation of a decedent's gender identity on the decedent's certificate of death. However, on page 3 of the pre-amended version, section 2, 25-2-110, what is actually being updated is not as relates to the certificate of death, it's as relates to the verification of death document, which is the problematic section that we were pointing to. Unfortunately, I can't strike that section to be as to the title because it's already been amended, and so it is a settled question. That said, there is another section in the bill that does not that does not comport with the title. And so, to be fair, let's just make sure we're cleaning that up, because I was told that sex was not part of this bill and could not be part of this bill. Therefore, I move Amendment L17 to House Bill 1109.
That is a proper motion. 1 second, we'll get it displayed.
Thank you.
Representative Luck, please proceed.
Thank you, Mr. Chair. So what this amendment does is strike the bill's references to the sex of the individual. Specifically, the statement that says, which may or may not correspond with the individual's sex assigned at birth and is designated on a certificate of death as male, female, or X, which is a sex designation that is neither male nor female. So I ask for an aye vote so that we are consistent with our determinations about what does and does not fall under this bill. Thank you.
Further discussion, Representative Brown.
Thank you, Mr. Chair. We ask for a no vote.
Representative DeGraff.
Thank you, Mr. Chair. We ask for a yes vote. There are two sexes, male, female. There's not an X sex. So you're asking. Now, if you want to put XXXY, that would be, that would be kind of a different sort of thing. But again, lying on the, it's one thing, it's one thing to say there's multiple gender identities because there's really no way to refute that. Because it is whatever you claim it to be. But to say in terms of that there's male, female, or X is just not true. And one thing that's important to note also in that quaint document, that oath that we take to the Constitution to support, is that that document comports with that our rights are in conjunction with, they're endowed by our Creator with certain inalienable rights that are entitled based on that they're self-evident based on the laws of nature and nature's God. So when we don't have necessarily a point of reference, well, we can just look at nature. We can look at nature, and as opposed to the bench, because what's going on the bench is disturbing. That this version of reality does not exist in the realm of which our founding documents, the documents to which we took an oath, that exists. It doesn't exist in science. It's not an immutable characteristic. It does not exist. So all you have to do is have the additional box. The additional box was offered, but then the additional box was rejected. So I think this is a good amendment. I recommend a yes vote.
Further discussion on L17. Seeing none, the question before us is the adoption of Amendment L17. All those in favor say aye. All those opposed, no. The amendment is lost. Back to the bill. Further discussion on House Bill 1109. Seeing none, the question before us is the adoption of House Bill 1109 as amended. All those in favor say aye. Aye. Opposed, no. No. The bill as amended is adopted. Madam Majority Leader.
Thank you, Mr. Chair, or Speaker Pro Tem. I would like to lay over House Bill 1185 and Senate Bill 39 till tomorrow.
House Bills 1185 and Senate Bill 39 will be laid over until tomorrow. Madam Majority Leader.
Mr. Speaker Pro Tem, I move committee rise and report.
You've heard the motion. Seeing no objection, the committee will rise and report.
The House will come back to order. Mr. Shebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave to report as under consideration the following attached bills, being the second reading thereof and making the following recommendations thereon. House Bill 1109, as amended, passed on second reading, ordered, engrossed, and placed on the calendar for third reading and final passage. House Bill 1185 and Senate Bill 39 laid over until March 6, 2025.
Speaker Pro Tem Basenecker. Members, you've heard the motion. We do have an amendment at the desk. Mr. Shebel, please read the Bradley amendment to the Committee of the Whole report, House Bill 1109.
Representative Bradley moved to amend the part of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Bradley Amendment, L15, to House Bill 1109, to show that said amendment passed and that House Bill 1109 as amended passed.
Representative Bradley.
Thank you, Madam Speaker. I move the Bradley Amendment to the report of the Committee of the Whole and ask for it to be displayed.
It is properly displayed. Please proceed.
Thank you. This is just going back to the fact that we are going to lose federal funding, and if this proceeds, and I'm just going to remind you once again what that entails, $12.8 billion total in statewide federal dollars, $871 million Department of Ed, $9 billion healthcare policy and financing, $600 million in human services, $200 million labor and employment, $325 million CDPHE, $860 million Department of Transportation, and that's 80% of the fully funding Department of CDPHE. We are at risk of losing federal funding. He has made it, our president, very clear that he is not going to tolerate gender identity. It's all throughout this bill. We have $250 million in fiscal notes for this session. We are $1 billion in debt. We are not going to be blamed when federal funding's pulled because of bills like this, when we have been told time and time again that federal funding will be pulled from education and healthcare. We're not going to sit here and be blamed for that. I urge an aye vote on this so that when federal funding is pulled, we can kill this bill and still keep our federal funding. Thank you.
Representative DeGraff. Representative DeGraff.
Thank you, Madam Speaker. I was a little confused at who I was again. That happens a lot. That's enough. Thank you, Madam Majority Leader. I try to be all about decorum. You know that. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. So let's say somebody like the Commander-in-Chief took an oath of office that was to support and defend the Constitution of the United States, which is based on the Declaration of Independence. And the President took that oath seriously, that his job was to secure the rights of the citizens of even Colorado in flyover country, even in blue Colorado. And that one of those rights would be the First Amendment right, that right that we hold to free speech. The right to assemble, the right to practice religion. And if that executive saw a bill like this with compelled speech of requiring individuals to perhaps speak, and there's a reason, there are ideological reasons to make people, force people, compel people to say things that they believe are untrue. We don't need to get into well, it'd be worth getting into the psychology of that. But it's kind of a form of psychological murder. But to violate free speech is to undermine the very nature of our republic. And I think somebody mentioned earlier today that we were a republic, and we're not governed by mob rule. We're not governed by what a majority of people have, for which they have proclivities or whims, or just determine that that's what they want to believe. So we have we have principles, and we took oaths to those principles, and so if the president looks at Colorado and says Colorado is going to engage, and I don't know if he will or not. It's not like I've got his ear or anything. He doesn't listen to me. I'm just wondering if he were to consider that Colorado was engaging in compelled speech, which could be considered in violation of the First Amendment, then I think he would be within his duties to say Colorado is engaging in compelled speech in violation of the First Amendment. And I mean, it's not like he's going to send troops. So an easy way would be to withhold funding. And an easy way to preclude the fallout of withholding funding would be to take this safety clause, this pressure relief valve, just put this in the bill, doesn't change anything, just gives that relief in case this is. Again, I don't think anybody in our caucus has any idea if that will happen. We hope not, because we're $3.5 billion in debt, practically about 3.5% of certificates of participation plus another $1 billion in debt. So we're about 10% of our budget in debt that we're not allowed to have. And this would be a way to double it if that were to happen. So, and when would it happen? Well, it would happen after the signing by the governor, which would be towards the end of session, I suppose, and then it would be after this session. So I just think we ought to sign this, put in that emergency relief valve, put in that escape clause, and not risk it.
Representative Brown.
Thank you, Madam Speaker. We ask for a no vote on this amendment.
Seeing no further discussion, the motion before us is the adoption of the Bradley Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
No.
Representative Lindsay votes no. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Representative Camacho is excused. Please close the machine. With 22 aye, 37 no, and 6 excused, the amendment is lost. The motion before us is the adoption of the report of the Committee of the Whole. Mr. Schiebel, please open the machine and members proceed to vote. Representative Lindsay, how do you vote?
Yes.
Representative Lindsay votes yes. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Please close the machine. With 38 aye, 21 no, and 6 excused, the report of the Committee of the Whole is adopted. Madam Majority Leader.
Madam Speaker, I move to lay over the balance of the calendar till Thursday, March 6, 2025.
See no objection. The balance of the calendar will be laid over until tomorrow. Members, announcements and introductions. Representative Lukens.
Thank you, Madam Speaker. The Education Committee will be meeting in 5 minutes in room 107 to hear House Bill 1167 and House Bill 1186.
Thank you. Representative Mabry.
Thank you, Madam Speaker. Judiciary Committee members, we will be meeting in the Old State Library when the upon adjournment committees are over, so please pay attention to the board. I will also be texting folks. We're going to be hearing House Bill 1235, Senate Bill 14, and House Bill 1232. We will not be hearing Senate Bill 62 or Senate Bill 129.
Thank you, Rep. Mabry. I've got 2 announcements. Rep. Mabry will replace Representative Woodrow on Business Affairs and Labor today and tomorrow only. Representative McCormick will replace Rep. Lindstedt on Business Affairs and Labor for today only. Thank you. Representative Brown.
Thank you, Madam Speaker. At the conclusion of the upon adjournment committees, Health and Human Services will meet in room 112 to hear 5 bills in the following order: 1270, 1257, 1251, 1252, and 1253. If you haven't ordered dinner, do it.
Representative Story.
Thank you, Madam Speaker. Tomorrow, CDC will not be meeting at 8 a.m. as was scheduled.
Thank you. Representative Valdez.
Thank you, Madam Speaker. Members of Energy and Environment, we will meet at 6:10 p.m. across the hall to hear 1197, 1260, and 1241. Again, 6:10 across the hall, E&E.
Thank you. Representative Clifford.
Thank you, Madam Speaker. Upon adjournment of the 1:30 committees, we will begin tomorrow's Disability Rights Advocacy Day at 9:30 a.m. Please join us.
And Representative Ricks.
Thank you, Madam Chair. House Business Affairs and Labor will meet at 6:10 in room 112. We'll be hearing 3 bills today: House Bill 1180, House Bill 1240, and also 1217. See you soon.
Members, I've got a little bit of business to do. We're going to run through some introduction of bills. You are free to go. We will be adjourning after we are completed. Mr. Schiebel, introduction of bills.
House Bill 1296 by Representatives Garcia and Zokai, also Senator Weissman, concerning the adjustment of certain tax expenditures.
House Bill 1296 will be assigned to the Committee on Finance.
House Bill 1297 by Representatives Brown and Gilchrist, also Senator Judah, concerning updates to the Health Insurance Affordability Enterprise to provide continuing coverage for health insurance needs in the state.
House Bill 1297 will be assigned to the Committee on Health and Human Services.
Senate Bill 78 by Senator Pelton R., also Representative Lukens, concerning the authorization of certain nonprofit hospitals to enter into collaborative agreements with other health facilities.
Senate Bill 78 will be assigned to the Committee on Health and Human Services. Madam Majority Leader.
Madam Speaker, I move the House stand in adjournment until Thursday, March 6, 2025, at 9 a.m.
The House will stand in adjournment until tomorrow, Thursday, March 6th at 9 a.m.